Lord Addington.
My Lords, I beg leave to ask the question standing in my name on the order paper and draw attention to my declaration of interest.
My Lords, final data for 2010-11 show that 18,940 learners participating on an apprenticeship programme self-declared that they had dyslexia. They had a success rate of 72.6% compared to 76.4% overall. All apprenticeships are stretching and prepare individuals for sustained employment. Dyslexia should not present an insuperable barrier to those candidates who demonstrate competence and commitment in their chosen field. Access to work and additional learning support are two possible sources of funding to help provide equipment or other assistance for apprentices with dyslexia.
I thank my noble friend for that answer. The fact remains that dyslexia is a problem which affects people in reading and writing, and there is a written assessment made at the end of an apprenticeship, and the fact that assistive technology, which is made available to those in the university sector, is not allowed to be used. Bearing that in mind, would my noble friend give me an assurance that this situation will be changed and reviewed in the immediate future?
As my noble friend knows very well, new assistive technology is advancing at a very rapid rate with apps and packages as Prismo, LifeScribe, Dragon and others. And dyslexia affects different people in different ways, and some solutions will suit some and some will others. If it would be helpful, I should ask officials to set up a meeting with stakeholders to include the British Dyslexia Association and Adult Dyslexia Organisation to help to ensure compatibility with assistive technology is considered when tests and other assessments are developed.
My Lords, how much of the assistance which the noble lady refers to, which I'm sure is very welcome, has been available to gypsies and travellers?
I'm afraid that I don't have those figures to hand. If I can find details for the noble lady, I will write to her.
The noble Baroness, the Minister, accept that whereas developmental dyslexia is the commonest and best known of the specific learning difficulties, there are a number of other specific difficulties less common, such as developmental dyspraxia, serious clumsiness, and developmental dyscalculia, which means difficulty in calculating and in the use of numbers. Is it not important that people with these difficulties also require special education and training needs and require just as much attention as those with dyslexia?
Yes, indeed, my Lords. There is a range of disabilities which can provide hurdles to young people embarking on apprenticeships. The National Apprenticeship Service looks at different ways of supporting diversity within apprenticeships, and we did commission a study from Peter Little recently to look at accessibility. We're implementing an action plan as a result of the report he submitted, and he himself will be helping us to implement that.
Many schools throughout the United Kingdom are encouraging young boys and girls to take up apprenticeships while they are still at school. In other words, they are given day release and special training, which would help people with special needs. Would Her Majesty's Government consider expanding this facility to as many schools as possible?
Well, indeed, of course, we do already encourage schools to promote apprenticeships as a career path for people while they're at school, so that they consider setting themselves with the right sort of programmes of learning before they leave school. And business increasingly go into schools to talk about the possibilities there. So there are ongoing programmes all the way through which should help what the Noble Lord is seeking to achieve.
Apprenticeships are one thing, but there are, I'm sure the Minister would agree, quite a number of children, young people, who are in university who are dyslexic and have other problems. Are courses designed in such a way that these children can end up with a degree rather than be frustrated and probably leave university not long after entering?
There are indeed a number a great number of students at universities who are dyslexic, and the universities have their own methods of dealing for these, and they will by and large have some very well established programmes of support and assistance to ensure that dyslexic undergraduates become dyslexic graduates.
Been asking this question about apprenticeships and dyslexia for a very long time. Isn't it time real action was taken and something was done?
Yes, indeed, my lords, and the particular point he makes is about assistive technology, and I think that is, in my answer to him, of saying that's developing very fast, but offering that we do try and get interested parties together to see if we can't find a way forward for that. But just, if I may point out, if we're talking about dyslexic apprentices, the Apprentice of the Year is a dyslexic woman called Emma Rogers, who gives credit to her college at Weston for having helped her through, and I think that is a tremendous role model that we have a dyslexic Apprentice of the Year.
My Lord, what help is being given to dyslexic children at school?
With the increasingly high profile of dyslexia and other forms of disability, it is becoming a part of the teacher training programme, and teachers are very much more aware of trying to recognise the signs at an early point where more help can be given to children from beginning stages, rather than as so often happened in the past and can still happen, that it doesn't get diagnosed until people are quite advanced in their educational process. But schools do have different ways of dealing with it, and by and large we get some very good reports of good practice.
My Lords, I speak as a father of two dyslexic boys, and my observations of dyslexia is it often takes young people longer to find their feet in life, especially if the dyslexia isn't properly diagnosed. Can the Noble Lady the Minister confirm that there aren't any age restrictions upon admission to apprenticeships? Because it's often a bit later in life when kids who are dyslexic actually are ready to take up apprenticeships and the like.
Yes, the Right Reverend Prelate makes a very valid point there. Of course, the apprenticeships that we have been focusing on particularly are the ones for the younger age group. But, of course, apprentices are certainly available for adults and are actually being taken up in a rather larger number by adults than they are by younger people. And so the possibilities for people with dyslexia to come into a very useful work-based programme of learning are increasingly there.
My Lords, I certainly welcome the government's approach to apprentices with dyslexia. However, what I'd like to know is this: what is the government doing when they become craftsmen? Because apprentices will become craftsmen and they will still have dyslexia. How is the government going to cope with that?
For a great many of the practical craft areas, dyslexia would be no handicap. You can see some absolutely wonderful examples of craftsmanship in this country, which are achieved by people with a whole range of disability. And we want to promote craftsmanship in the country as much as we can.
Lord Wood of Anfield.
My Lords, I beg leave to ask the question standing in my name on the order paper.
My Lords, all our efforts have focused on securing a successful outcome at the forthcoming Geneva conference. A negotiated political settlement remains the best way to end the current bloodshed. The US, Russia and UN are working intensively on the details of the conference. It's inevitable there will be challenges. However, the UN Secretary-General has stressed that the three parties are committed to convening the conference as soon as possible.
Can I thank the Minister for that answer? Given the failure of the G8 summit to agree a date for the start of the Geneva II talks, does the Minister think on reflection that it was a mistake for the government to spend the run-up to the G8 raising the volume on the possibility of the UK arming the Syrian rebels? And does she agree it will be damaging for the prospects of an international peace conference if the government was to repeat the mistake in the coming weeks and months?
The government has consistently approached this matter by responding to the situation on the ground. I don't think that the government can be criticised for actually responding to and encouraging agreement when we think it is possible. The countries that we're trying to get agreement between, the US, Russia and of course the UN playing a facilitating role, are all committed to Geneva II, and they're committed to a transitional executive authority that would be in accordance with the wishes of the Syrian people. I think it was right in the run-up to the G8 to get as much agreement as possible, and I think it continues to be right to continue to push Russia and the US to come to an agreement to bring the coalition and the regime around the table.
My Lords, does the Noble Baroness accept that if the international community is to have any hope of starting to resolve this dreadful situation, then all parties to the conflict need to be at the negotiating table? And if that is the case, and I ask this particularly in the light of the fourth question on the order paper, how does she respond to the suggestion that this ought also to include Iran?
The Right Reverend Prelate will be aware that this is a question that has been raised in the House before. Our view is that those parties that were party to Geneva 1 should be party to Geneva 2. The challenge we have at this moment is to get the opposition and the regime around the table and agree a roadmap. Of course, if there are other parties who can play a constructive role, then that too would be appreciated. But the role that Iran are playing in Syria at the moment is not considered, my lords, to be constructive.
My lords, would my noble friend agree that in addition to the importance of having Iran at the table, that it will also be critical to the success of the conference to have credible members of the Assad government there, if not President Assad himself? And moreover, the role of Hezbollah, which is often seen to be in alignment with Iran, is actually rather independent. Lebanon is a neighbour, is hugely affected by the civil war in Syria, and would she also consider in trying to move Geneva 2 forward, whether they might invite all the key players in an open gesture so that we might get reconciliation and agreement at the end of that?
No point.
I could assure my noble friend that we're trying to do all we can to bring the parties to the table. The challenge has been, at the moment, in relation to the regime. We do feel that people from the regime should be credible and should be those who can take decisions and can make sure that those decisions are subsequently effected. But to try and broaden that, I think, beyond the regime at this stage is not something that we think would be constructive.
My Lord, the main reason we're having doesn't the Minister accept that
further to my noble friend's question, will the Minister not concede that the Syrian government have agreed, the Russians have agreed, the Americans have agreed to participate? And did she see the report from Reuters that the leader of the Syrian National Council have said that they're holding out to get more arms? They're waiting until they get more arms to strengthen their negotiating position. So surely the British government's policy in holding out the prospect of giving them arms is therefore counterproductive.
Yeah. I've said on many occasions at this dispatch box, and maybe I should say it again, no decision has been taken to arm the Syrian opposition. The noble lord will be aware that the National Coalition have just elected a new president, Ahmed Assay al-Jabra, and he has made it his job, amongst other things, indeed before his election, to broaden the coalition, to include more people within that coalition, and to make sure that he unites the coalition, and he is committed to the Geneva process.
Will it be my right honourable friends, the noble ladies, my noble lord's policy to make sure that the housing needs in future of the refugees who are now in temporary provision should be looked at and be discussed with relevant governments, bearing in mind that many of those concerned cannot return to their original houses, which have been reduced to rubble.
My noble friend will be aware that the largest humanitarian appeal has been launched as a result of the situation in Syria. The United Kingdom has made the largest contribution it has ever to a single humanitarian appeal of 350 million. Indeed, the Secretary of State for International Development was in Lebanon only earlier this week, pledging further support for Syrian refugees in Lebanon. I think the long-term solution to this, my lords, is about resolving the political situation on the ground to allow these people to return. There are more than 4 million people displaced within Syria and 1.7 displaced outside of Syria. There is no way that we could conceivably, even as an international community, provide housing needs for that many people. The solution has to be to create the climate for them to return to their own homes.
Isn't the Minister aware that the reason that the Russians are reluctant to set a date, and they are reluctant to set a date, is because they want the Assad regime to regain as much control of territory as they can in order to strengthen their hand in negotiations. And that cannot be good for Syria or anyone else in the long run, but we do need to be realistic about it. There is a reluctance to set a date because the regime itself wants to extend its control on the land in order to negotiate from a position of strength.
My Lords, I probably couldn't hypothesise about what the reasoning for the Russians' position is. And of course, we have different views on handling this crisis. But we do have shared fundamental aims. We both are committed to ending the conflict, committing to stop Syria fragmenting, committed to letting the Syrian people decide who governs them, and preventing the growth of violent extremism. And we're hopeful that because we're committed to the same aims, we can reach an agreement on how to get there.
It's not good enough to... Lord Brooke of Elberthorpe.
Lords, I beg leave to ask the question standing in my name on the order paper.
My Lords, the public consultation on the Government's alcohol strategy closed on the 6th of February. We will publish our response in due course.
I'm grateful for small mercies. Would the noble Lord confirm, would the Minister confirm that the principal problem leading to over 10 million people drinking excessively is the easy availability of cheap alcohol? Would he please confirm that that is still the central plank of the government's policy in its alcohol strategy? Secondly, would he say when we're likely to start to see some progress on this issue, and would the government please embrace it with the kind of enthusiasm which the previous Labour government did when it was tackling the difficult issue relating to the tobacco industry and smoking? And until we take on the drink industry and some of the vested interests, we will not start to see the problem resolved in the way that we need it, given the issues that arise for the health service from excessive drinking.
Well, the noble Lord rightly focuses on those elements of the government's alcohol strategy which were put out to consultation. I've explained that a response to that consultation will be delivered in due course. Availability is one of many factors, but to suggest that this government has not been tackling the problem underestimates what has actually been achieved. The late night levy has been introduced. The early morning alcohol restriction order, which was actually created under the last government but not commenced, has been commenced by us. And we have indeed sought to rebalance the licensing arrangements so that the vicinity ability of individuals to object to licences is now greatly strengthened. I accept totally what the noble Lord has said, and indeed the government's strategy, I think, will demonstrate that.
Assuming that the Institute...
they have introduced and evaluated a minimum unit price for alcohol. And by introducing a 10% increase in the minimum unit price for some drinks, they've shown that there was a decrease of 33% in wholly alcohol-related deaths. Given this evidence, when will the government commit to including a minimum unit price as part of its alcohol strategy?
This is just the sort of evidence which has been being evaluated by the government at this present time. And I accept we have the Scottish experience too, where the Scottish have legislated for this. It's subject to an appeal in court at the moment, but we are taking note of what's going on elsewhere.
Lord, I'm sure that the government has looked at the evidence produced by the Institute of Alcohol Studies, showing that a 50p minimum unit price would reduce deaths by 3,000, reduce hospital admissions by 98,000, and would reduce crime by 40,000 a year. Has the government made any estimate of the saving to the public purse that that sort of reduction would produce?
Well, I can tell the noble Lord that the cost of alcohol to a society is estimated at £21 billion, and £11 billion of that is alcohol-related crime. These figures are part and parcel of the consideration that the government is giving to the issue.
My Lords, there is a clear relationship between the price of alcohol and severe liver disease, and we've known about that forever. And the number of hospital admissions and the deaths from liver disease are closely related to the price of alcohol. So we've been talking about it for a long time. When will we see some action?
Yes, my lords, there were 1.2 million admissions to hospital in 2011-12 in England. That sort of figure speaks for itself.
My lords, how long is due course?
I think noble lords are well aware of how long due course may be.
My lords, for all the talk of consultation, the consultation on the alcohol strategy specifically ruled out consulting on minimum alcohol pricing. It said that the government was committed to introducing minimum unit price and said, however, in other areas the consultation seeks views. The Home Secretary said, we will introduce a minimum unit price for alcohol. What's changed the government's mind? Is it private lobbying that's forced this U-turn?
Well, I can certainly counter that last allegation of the noble Baroness, but the response will be a comprehensive review of alcohol and the way in which we tackle alcohol abuse in this country, and it will be available in due course.
When does the government plan to start to pilot sobriety schemes as a way of reducing reoffending rates amongst those whose crimes have been alcohol-fuelled?
That's an interesting suggestion. I have no particular information on it, but I will certainly take that up.
My Lord, does the noble Lord agree that the previous government had at least 10 years in which to react to this, that price of alcohol and pricing alcohol is not going to do anything other than probably damage the government's income, but it's not going to move anywhere towards achieving what we need to achieve? That surely, my lords, is about getting in amongst the communities.
Well, I certainly will agree with my noble friends that the price of alcohol is not the only issue that's at stake. Lots of local communities are, in fact, taking positive action in this area. I went to Nottingham to see the night time economy in the centre of Nottingham, where street ambassadors, taxi marshals and street pastors have helped make that area of Nottingham safe at night. It's done a lot to improve the economy of that area, and there is a big role for community. It's not just a matter of the price of alcohol.
Lords, further to the question by Baroness Hollins about the Canadian experience, does he agree that it shows that it has in particular reduced sales and off-sales at supermarkets and the like, the very places that binge drinkers go to tank up before a night out?
Well, indeed. The information that the noble Baroness was able to give to this particular question was helpful, and I'm grateful for it.
Baroness Williams of Crosby.
My Lords, I beg leave to ask the question in my name on the order paper.
My Lords, diplomatic relations between the UK and Iran are not severed, but they are at their lowest levels possible. Our respective embassies are closed, but Sweden looks after UK interests in Iran and Oman looks after Iranian interests in the UK. Until we can be confident that Iran will abide by its obligations to protect our staff and allow them to carry out their functions, we cannot have a diplomatic presence in Tehran.
May I thank the Minister for that rather disappointing answer and point out that President-elect Rouhani was not only elected by a clear majority on the first ballot of the Iranian people, but had a majority of more than 12 million people over his nearest rival, the mayor of Tehran. May I also point out that in the last week, he has not only called for the clergy to cease to interfere in the private lives of Iranians, to call upon the Iranian state television and radio to address Iran's own problems much more honestly and much more fairly, but has also asked that the young people of Iran will benefit from having clear access to the internet. My Lords, given this, may I ask the Minister, and given also that there are now thousands of young Iranians on the streets praising their new president, whether we might not as a country make at least some gesture at the point at which he becomes the elected president on August the 3rd, which will open up again the lines of contact much more closely between Britain and Iran, And I would add to that that both France and other European nations are already establishing their willingness to work more closely with the new government.
I know my noble friend has much more practical experience on this issue than I have. Indeed, having visited the country on a number of occasions, she has, of course, seen the situation on the ground. And I can assure her that we are open to an improvement in the relationship between the United Kingdom and Iran. And, of course, I acknowledge the fact that this was predominantly a peaceful election with a large turnout. And I also acknowledge the fact that Mr. Rouhani, who, of course, will be inaugurated as president in August, has himself described his win as victory over extremism. But having said that, my lords, it is important that we see that these words are translated into action. There are a whole series of issues upon which we want to see a positive approach from Iran. And I think we also have to acknowledge and accept that the elections, although positive and produced a decisive result, it was an election in which a very large number of candidates were in fact disqualified, 678, and indeed all 30 women who wanted to stand.
His statement. That her caution is actually quite welcome to many of us in this House, and that in the 22 days up until the 8th of July, only 2 days ago, 75 people were executed in Iran. One of those was a person who was only 15 at the time of their arrest, and some of these executions were mass executions, with as many as 21 people being executed at the same time. Surely, my lords, the government is right to exercise caution, and indeed the mullahs are still very much in charge, no matter who takes over as president in August.
Of course, the noble lady is right. Khamenei, the supreme leader, still has a huge amount of influence in so many spheres of life in Iran. And the human rights situation in Iran, she's quite right to say, is dire. There were reports in 2012 of over 350 executions. And as of May of this year, 162 executions. It has more journalists in prison than almost any other country. And opposition leaders remain detained in prison after 2 years. That we have real concerns about human rights and other concerns in relation to Iran. We are open to improving this relationship, and of course there have been opportunities when officials have met, for example during the E3+3 talks, but it's important, as the noble lady says, to remain cautious.
My lords, would my noble friend the Minister not accept that it's precisely because of the recent, well not recent, the permanent history of Iran and its human rights infractions, it's precisely because of that that we should support a man, namely President just elected, who showed considerable courage in his election campaign, and who I would suggest to the government would be immensely supported in his undoubted wish to move away from the dark side of Iranian life if we were to restore diplomatic relations without preconditions.
I take my noble friend's points, but I think the one thing that and most of us who have been involved in foreign policy realise is it's never black or white. There are always many, many grey areas, and there are grey areas here. He has some positives, he's made some positive remarks, but it's important that those remarks are now translated into action. But I can assure him and other noble lords that we do have contact with the Iranians. For example, last year in the Heart of Asia discussions as part of the discussions on Afghanistan, the Foreign Secretary met Foreign Minister Salahi in the margins of that meeting. And so there are opportunities where even at the highest level discussions do take place. But in terms of restarting diplomatic relations and having an embassy, which, let's not forget, in 2011 was ransacked and our officials and our staff there came under attack, it's important that we do so cautiously.
Surely we need a direct
My lords, it's actually the crossbench. If we're quick question, quick answer, and we'll try and get in.
My lord, surely we need direct contact. Will the government seek assurances from the Iranians that if we sent in a chargé d'affaires, he would be properly protected? Fuller representation can wait till later.
I think we're proposing official-to-official contact, possibly even in a third country before, and that would be the normal course of event, not just with Iran.
My Lords, all of us hope that Rouhani will prove to be more reasonable, indeed more rational than Ahmadinejad, but isn't it very important that nobody should have any illusions, that we make it absolutely clear that sanctions can't be relaxed until there's real evidence through inspections or otherwise that Iran is not proceeding with a nuclear weapons program. And in view of the lamentable record which the noble lady has just set out on human rights and other matters, that we should reserve concessions, even symbolic concessions, on our side until the Iranian regime makes some positive move forward on their part.
Sanctions are there for a purpose, they are targeted, they're for a specific issue, and we've been careful to note that humanitarian goods are protected. But the noble lord is right, we have to make progress on the substantive issues, and nuclear is one of them.
Message from the Commons that they have passed the Financial Services Banking Reform Bill, to which they desire the agreement of your lordships.
My Lords, Financial Services Banking Reform Bill, I beg to move that this bill be now read a first time.
The question is that this bill be now read a first time. As many as are of that opinion will say content. The contrary not content. The contents have it.
Public Bodies Abolition of the Registrar of Public Lending Right, Order 2013, Lord Gardiner of Kimble.
My Lords, I beg to move the motion standing in my name on the order paper.
The question is that this motion be agreed to. As many as are of that opinion will say content. The contrary not content. The contents have it.
Social Security, Child Support, Vaccine Damage and Other Payments, Decisions and Appeals Amendment Regulations 2013, Lord Freud.
My Lords, I beg to move the motion standing in the name of my noble friend on the order paper.
The question is that this motion be agreed to. As many as are of that opinion will say content. The contrary not content. The contents have it.
Further consideration on report of the Marriage Same-Sex Couples Bill, Baroness Stowell of Beeston.
My Lords, I beg to move that this bill be now further considered on report.
The question is that this bill be now further considered on report. As many as are of that opinion will say content. The contrary not content. The contents have it. In Schedule 4, Amendment 84, Lord Ali.
My Lords, I rise to move Amendment 84 and to speak to my manuscript Amendment 84A. On the face of this, it is an amendment about pensions. My Lords, it's also about equal treatment for the ones that we love. I will give a few moments for noble lords to leave the chamber. My Lords, this provision is also about the equal treatment of our loved ones. It is the only time in this entire bill where we treat same-sex couples who get married prejudicially from opposite-sex couples. All married couples should be treated equally. It's a principle that we have fought throughout this bill to maintain. I know it's a principle that the noble lady Baroness Stowell of Beeston has defended. I know it's a principle that the noble Lord Wallace of Tankernes has defended. And I know it's a principle that the noble lady Baroness Northover has defended too. It is something that the majority of this House, regardless of party affiliation, has defended. If we let this clause go through as it is, it will be the first and only time we breach that principle. And let me explain why. If I were to marry a woman and was a member of an occupational pension scheme and died, my wife would be entitled to a survivor pension from my occupational pension scheme backdated to, I think, 1988. If I married a man and I died and was a member of the same occupational pension scheme, my partner's survivor pension benefit would only be backdated to 2005, the date, in fact, when we introduced civil partnerships. This bill takes the inequality in the Civil Partnership Act and applies it to same-sex marriages, instead of taking the position that opposite-sex couples and equalising the pension arrangement. In effect, it means that same-sex couples are treated as civil partners for these schemes. This might be necessary if it had a huge cost to the public purse and given we are in difficult economic times. But let me make it clear, in absolute terms, there is no public money required to make this change. Let me repeat it, because the government may try and imply there is. There is no public money required to make this change. If I'm wrong, I'm more than happy for the Minister to explain why. The cost is to private occupational pension schemes, and you'll see that's written on the face of the bill. And the government's own estimate puts the maximum additional cost at approximately £80 million for these private schemes. This, by their own admission, is a drop in the ocean of the size of these pension funds. The government knows this is wrong. And in 2005, when they changed the rules of their own pension scheme, their own survivor scheme, because it felt wrong to them to apply this principle to public service pensions. Equally, my Lord, 2/3 of the private occupational pension schemes in this country believe it's wrong too, and they have changed their policy. And we heard from the benches spiritual that the Church of England has changed its pension scheme arrangements too to reflect this. So why let 1/3 of occupational pension schemes discriminate against married couples in the future only on the basis of sexual orientation? It's also worth mentioning that in order to qualify, the scheme member will have to have fully paid up or towards the scheme. So it requires a private occupational pension fund to disregard the contributions made prior to 2005 to stop the survivor benefit coming through. My Lords, I said at committee that when you lose your husband or wife or long-term partner, it is by all accounts a terrible experience. It is the last thing you want to do, to have to argue your case to a pension fund trustee. And it must be insulting, having gone through this legislation, to be told that having married, you are now to be treated as a civil partner. So why are the government opposed to this amendment? It's the Treasury and DWP. And I know the noble lady, the Minister, will be forced to read out whatever they've asked her to read out. But I suspect it will go something like this. Number one, we foresee problems with this amendment as they may be unforeseen implications. Or number two, we believe, even though there is not a direct cost to the Treasury, we could see the possibility that someone could take a case that might lead to the possibility that we might have at some time to equalise pensions for men and women. By the way, it would be a miracle if that case came off. Or three, let's throw in a spurious cost. 2 billion, 3 billion, 4 billion, Minister choose whichever number they wish, which is to do with gender equalisation of pensions, not occupational pension schemes, but their lordships will be so bored or confused they won't care. Or four, let's make out that it creates an inequality, because after all, this is an equality bill. Or five, let's say we don't like to legalise retrospectively, legislate retrospectively, even though we changed our own pension funds retrospectively as soon as we could. My Lords, I met by kind invitation of the noble lady, the Minister, the Pensions Minister yesterday. And at the end of our discussions, I can honestly say I was no clearer about the Treasury or the DWP's objections to this amendment. The Pensions Minister gave the usual unconvincing, unintelligible Treasury line. The government are really making a mountain out of a molehill. This is a tiny issue affecting a small number of people at a terrible time of need. My Lords, I've also tabled a manuscript amendment which seeks to give the government an alternative. I'm calling it the Lord Leicester principle. It basically affords the government a two-tier process. Review the issues involved and report back, and secondly, give order-making powers to implement their decisions, as we did with humanist marriages. If the noble lady, the Minister, feels the government needs more time, then I would be happy to discuss one or either of these alternatives and to try and find a solution before third reading. If the government are not prepared, I will, of course, move my manuscript amendment 84A and seek to test the opinion of the House. My Lords, I beg to move.
Amendment proposed, page 36, line 20, leave out subparagraphs 2 and 3 and insert omit subparagraph 1.
My Lords, as at committee stage, I am pleased indeed to support the amendment of the noble Lord Alla. This amendment, as he has already pointed out, represents a crucial opportunity to ensure that the introduction of same-sex marriage in this country is achieved with exactly the same basic benefit, insurance rights, for male, male, or female, female, as for male, female. If we do not address this final discriminatory hurdle now, it will be several decades before all gay couples achieve this equality. It will mean decades of waiting for gay men and women who must continue to live with the reality that their loved ones may not be provided for when they die. Decades in which individuals that have worked and contributed to their pension, planned and have been prudent, are at the whim of employers and pension providers who may choose to pay a pittance in survivors' benefits for no other reason than the gender of their spouses. If we do not remove this last remnant of historical injustice, this second tier of marriage will continue in contradiction to all the calls for exactly equal treatment we've heard again and again during the last few days in your Lordship's chamber. A brief look across the Atlantic may help to illustrate this point. 2 weeks ago, in the landmark case of United States versus Windsor, the Supreme Court considered the case of Edith Windsor and her spouse and partner of 44 years, Thea. They lived together in New York, a state which recognizes same-sex marriages. And when Thea died in 2009, she left her entire estate to Edith. Had they been a heterosexual couple, Edith would have inherited the entire estate tax-free. However, US federal law prevented their marriage from being recognized for the purpose of inheritance tax, and Edith was hit with a bill for $63,053. Thankfully, the Supreme Court found this law to be unconstitutional. A key plank in its reasoning was that the treatment of Edith and others like her had the effect of creating a separate subset of legal marriages that were treated less favorably. To use the words of Justice Kennedy, and I quote, "The principal purpose and the necessary effect of this law are to demean those persons who are in lawful same-sex marriage. It tells those couples and all the world that their otherwise valid marriages are unworthy of federal recognition. The effect of this judgment was to grant legally married same-sex couples access to the same federal entitlements available to heterosexual married couples, including tax, health, and pension rights. Now, questions of taxes and pensions may seem mundane to some, but I can confidently say that this change in the law would mean the world to those people that it affects. Among those is a client of Liberty's, John Walker. Interestingly, I mentioned him when your lordships debated this issue at committee stage. John and his party have been in a loving, committed relationship for over 20 years, and they registered for a civil partnership at the earliest opportunity. Yet John's partner is currently entitled to a fraction of the survivor benefits which would be available to a female spouse, even one John met and married today. My lords, it cannot be right to continue a two-tier discriminatory marriage system, and surely John deserves the peace of mind of knowing that his partner will be equally provided for. Can I ask the noble Baroness, the Minister, isn't that exactly what the government's commitment is to in securing real equality for gay couples? Isn't that what it really means?
To this amendment, after two such full speeches by Lord Ali, Marquis Ali, and Lady Howe of Idlicott, it would be a waste of your lordship's time for me to say anything more than I agree with both of them, but I also believe in the art of the possible, and that is why I very much hope that Manuscript Amendment 84A, or some form of it, will be agreed by the government, because I think in that way we will have some hope of getting real change.
My Lords, Noble Lord Liddell has already spoken of some support from these benches for his amendment. I won't repeat what I said at an earlier stage, but I wish to support him again, and also, as indeed Noble Lord Leicester has just said, to support the device of regulation as a practical way forward.
My Lords, my heart is completely with Noble Lord Ali's Amendment 84, but I had trouble getting my head completely in agreement with the amendment, mainly because we're opposing a retrospective burden without any evidence of what that impact might be. I completely understand the case for the individuals who are affected, but we do not know where the cost will actually be borne. The cost is low overall, but it's not correct to compare it to the amount of assets under management, which was done in committee, because the incidence might be in very small pension schemes. It might be the instance of a small scheme, relatively small number of members, one highly paid member, civil partnered or married to a same-sex couple who's very much younger. That would have a very disproportionate impact on the actuarial valuation of the liabilities in that small scheme, which could be a charity, it could be a small business. And I would be much more comfortable if we knew what the impact was. We may still, knowing the impact, go ahead. And that is why I strongly support 84A, but had a little difficulty with 84.
My Lords, I also, like the noble friend who has just spoken, have serious reservations about this amendment. Indeed, I think I'm opposed to it. I do so in the light of experience, some 8 or 9 years on the front bench on work and pensions, and as a former chairman of a pretty large company pension scheme. My Lords, effectively what this amendment will do is remove the discretion of the trustees to exercise that in a way which is favourable or unfavourable to a particular group of people in the pension scheme. We don't know the exact cost. The noble Lord Ali put it at £80 million. I leave to my noble friend on the front bench to say what the effect is on public finances, but the reality is that this will affect a number of pension funds. We have to look at this in context, my Lords. If there was one disaster, individual disaster, more than any other of Gordon Brown's time as Chancellor of the Exchequer, it was the change he made to taxation on company pensions towards the beginning of that period of the Labour government. And the result has undoubtedly been the decimation of final salary pension schemes and a transfer to defined contribution schemes. But either way, we have seen the finances of pension funds seriously deteriorating, and in many, many cases giving up the final salary scheme or giving up the final salary scheme as far as new members are concerned. As the Noble Lord has pointed out, a number of trustees have gone along with what the amendment does, but some have not. And I think we must leave the discretion of them to deal with it to them, because there may be good reasons why they have not done so, not least financial reasons. And it may be that some scheme is tottering, as indeed many have been over the last 10 or 15 years, to the position of whether we should close the scheme or whether we should change it from a final salary to a defined benefit scheme, and so on. I think it is wrong, retrospectively, to put a charge on the funds in such a scheme who have been contributed to by the existing members, but by no more as far as the people coming into the scheme is concerned. Indeed, we may find a system, if we were to accept the amendment, where some people in a same-sex marriage are brought into the scheme, which is a final salary part of the company scheme, when others in the other part of the defined contribution scheme have not been allowed to have the same benefits. So that, I think, would be unfair. But overall, I think we should leave it to the discretion of the trustees. I no doubt over time it is likely that many more will, or indeed those who haven't yet, will carry out the or create the situation the Noble Lord Alley says. But I think we should leave it to the discretion of the scheme and the trustees of that scheme and their responsibility, and not retrospectively to impose a cost on those schemes. This, I think, would be wrong.
My Lords, throughout the whole of this debate, we have said that in the cause of equal marriage, we have had to say to groups and individuals who are very unhappy about this legislation that they will have to contain their unhappiness. We've said, for example, to registrars, and I use that example because I voted the other way on that, but we have said to registrars, because of the change in the law, you will have to accept that change. Now, it worries me that the moment we talk about money, all sorts of people who have been perfectly happy up to now start being concerned about the issue. And I hope that the Right Reverend Prelate will not be upset when I say I remember that in debates in the Synod of the Church of England. Everybody was very happy until you started talking about money. And once you talked about money, it was surprising how all kinds of other issues were brought in. Now, one of the things about pensions is that people can get married and be more expensive than if they hadn't got married. Nobody goes round saying, well, that's a pretty mean thing to do, isn't it? That's less for the rest of us. That's not how a pension scheme works. Now, it seems to me that it is perfectly acceptable, and I think the Noble Lord Alley, with characteristic care, has offered the opportunity of the government looking carefully in case one or two of the worries of the two noble lords who, or noble lord and noble baroness who've spoken before, turn out to be true. There might be something that we haven't really thought through, and it would be wrong to exclude that possibility. But I do think this House really cannot say that for the time forward, one sort of marriage will work in one way and another will work in another way. After all, we passed a motion, we opposed a motion which was delicately pointing towards that by a majority of over 200. It does seem to me that mammon is getting into this, and mammon should always be very carefully considered before mammon is allowed to win. And I do hope my noble friend the Baroness will at the very least accept that every effort will be made to ensure that this bill means what it says, which is equal marriage, and not equal marriage until it comes to money when the Treasury gets in on the act.
Lords, I remind my noble friend that we are advised to make friends of both God and mammon. But, my Lords, in this context, where we are is under the shadow of an enormous majority in the second reading debate in which the House accepted the principle of equality. And in committee, I sought to apply that principle to the process of converting a civil partnership into a marriage by requiring those undergoing that process to swear exactly the same, to swear an oath similar to that sworn by those getting married. I withdrew it partly at the request of my noble friend on the front bench and partly out of prudence in order to consider it before the next stage, which is this stage. And my noble friend was ahead of me at the dispatch box with an arrangement which comes just about to the same place in regard to my marriage and I beg your pardon, to my amendment. Very difficult to get close to my marriage, I assure you. My Lords, she put forward an arrangement which gave the government time to think, gave the Secretary of State power to review and to act if it seemed appropriate. And I think I was a little ungracious in moving my own amendment because I was so pleased with how clever my own drafting had been. My Lords, however, that was the principle I sought to support, and I was rather surprised that the noble Lord Alley, who had been quite supportive of my amendment at committee, came forward with all sorts of reservations and was unable to support it earlier on. And your Lordships will now be expecting me with a certain satisfaction to say that I can't follow him so far. However, my Lords, I am a man of principle, and I think that we do require to have equality through this Act. I do think the Amendment 84A gives the government power to pull out of this if it is necessary. I remind them that during the time that they are considering and reviewing and consulting, they might go through the same reviews and consultations with the insurers as they have done over, for instance, flooding. It does seem to me that the government actually is used to talking to insurance companies and can at least find out where the shoe pinches, and I think that this amendment would allow it to do so. I'm not supporting the first one, which locks them in, but the second one, I think, is a reasonable proposal which honours a principle which we reluctantly have accepted, but having accepted it, I think we should be gracious about it.
I'd just very briefly like to remind my Lordship's House that the Second Amendment, I support the First Amendment for reasons of principle the noble lords have talked about, and the principle of equality is a very important principle, and it seems to me the noble lady, the Minister at committee stage, was unable to respond with any arguments based on principle at all. They were purely pragmatic arguments which I don't think noble lords found very convincing. But I would just, in support of Amendment 84A, like to say that this is very much in line with the recommendation of the Joint Committee for Human Rights, which argued we considered the government should carry out a full review of pension provision in relation to survivor pension benefit entitlements of same-sex married couples and civil partners to ensure that there is no unjustifiable discrimination in pension scheme provisions.
My Lords, I have added my name to the manuscript amendment 84A from my noble friend Lord Alley, because we believe that at this stage this is absolutely the most sensible course of action. Like my noble friend, we want to ensure that there is no discrimination on the face of the bill and that there are no two tiers of marriage. I too am extremely grateful to the noble Baroness the Minister for managing to arrange a meeting with the Pensions Minister yesterday. My Lords, we have always accepted that there would be some direct cost to private pension schemes, but £18 million, which is the figure often quoted, is, I have to say, a drop in the ocean for schemes worth an estimated £76.4 billion. The government has asserted that equalising pensions benefits for civil partners and married couples of the same sex after this bill could leave the public sector liable for costs of up to £3 to £4 billion. However, they have been far more reluctant to explain where those costs might come from. The government, as my noble friend has said, has already acted to equalise survivor benefit entitlements for civil partners with those of widowers for public sector and contracted out schemes. The £3 to £4 billion estimate is based on the assumption that the removal of the legal exemption for civil partners will lead the government being forced to equalise the entitlements of widowers with widows, thus levelling everyone back to 1978. But why they believe this to be a significant risk remains to us unclear. The 1978-88 distinction between widowers and widows was based on the historic position of women as being largely dependent on their husbands for income, and indeed the courts have only recently upheld this distinction in the case of R versus Ian Coburn and Secretary of State for Health, where the judge ruled that there was an objective and reasonable justification for this because there had been, as the government argued, a progressive realisation of gender equality, and the initial rules had been set up to recognise the weaker economic position of widows. Without the provision within this bill, female spouses of same-sex marriages would, we presume, simply be treated as widows for the purposes of survivor benefits and male survivors as widowers. But nothing in my noble friend's Amendment 84 would affect the historic male-female distinction that the courts have so recently upheld. And to argue against this on the basis of retrospectivity is also flawed, as the government violated this principle themselves when levelling civil partners back to the entitlements of widowers, as they quite rightly did for public service pensions and contracted out schemes. In some sense, it could be said that by creating a different entitlement for widows and widowers of same-sex marriages than those of opposite-sex couples, the government is actually weakening their case against future challenges to widow-widower distinction. However, despite agreeing with my noble friend that the government's argument here is extremely tenuous, we want to offer the government an opportunity to remove this inequality in the most appropriate way, as noble lords on benches opposite have also said, and that is why I have added my name to the amendment to the manuscript amendment today. By voting for Amendment 84A, what noble lords will be doing is saying we're not happy about the provision within the bill as it stands, so we're leaving them there in parenthesis, as it were, for now, until the government has come forward with firm proposals for how to deal with this clear inequality. It is quite clear to us that one way or another the government will have to sort this out, and it is better to do this through a process that they can own rather than be forced by the courts to do it later, as undoubtedly they would have to do. So I would urge the noble Baroness the Minister to accept the amendment by my noble friend Lord Ali, Amendment 84A, and I realise that they may well have to come back with tweaks at third reading, but my lords, we want to right this inequality, and I think that this is a very fine way forward, that it gives the government some space to reflect, to look, to review, and then come back using the order-making power to get rid of this inequality. So I trust that the noble Baroness the Minister will be able to accept this amendment.
My lords, I think first of all I'd say to my noble friend Lord Elton that I'm in charge of many things at the moment, but one of the things I'm not in charge of is flooding, and I'd rather not add that to my portfolio for now. Before I respond in detail to the debates that we've just had, may I first of all make a correction to the figures previously used by the government in debates on this issue on the number of schemes using the Equality Act exception relating to civil partners. The government had stated that 2/3 of private occupational pension schemes already go further than the 2005 exception. This is incorrect. The correct figure is 1/3. However, this does not change the estimated 18 million increase in liabilities that would arise from removing this exception, as that was already based on 1/3 of schemes. My lords, the pension system as a whole is full of differences in treatment as a result of changes in society and social attitudes. Such changes are introduced prospectively, so as not to place new unfunded burdens on pension schemes which could not have been taken into consideration in their funding assumptions. The current Equality Act exception, which this bill also applies to people in same-sex marriages, recognises that pension outcomes in the present always reflect different accruals in the past, and that changes should be forward-looking rather than retrospective. Governments of all parties have sought to equalise pensions over time. What they have not done is try to equalise pensions outcomes in the present, thereby breaking the link between past accruals and present outcomes. The standard approach is based on the principle that it is not right to impose costs on schemes, meaning they would have to pay out new amounts that were not promised in the past, whatever the exact scale of those costs. Avoiding imposing retrospective costs on pension schemes is the standard principled approach which has been taken by successive governments. That is the approach the previous government took when civil partnerships were introduced in 2005 and when it brought forward the Equality Act in 2010. And that is the approach we have taken in this bill by aligning the pension position of same-sex married couples with that of civil partners. This approach means that pension schemes take time to catch up with societal changes, but over time the anomalies reduce and eventually disappear. Making any change to the position set out in the bill would mean placing retrospective costs on the schemes. The government understands that the current position is not perfect, but it is based on the principle that we should not seek to impose retrospective costs on private pension schemes, costs that were not planned for when benefits were being accrued. Now, the Noble Lord Ali seemed to try and dismiss the arguments that I was going to put forward before I'd even had the opportunity to do so. But the government's case is quite clear, and it's a strong one, and I will go through it properly. The two amendments in this group have different effects, as we've already established. Amendment 84, tabled by the Noble Lord Ali, would mean employers having to pay survivor benefits to civil partners in respect of their deceased spouse's service prior to 2005, when civil partnerships first became possible. This amendment does not achieve what I believe the Noble Lord is trying to achieve, which is to give parity in provision of survivor benefits between same-sex married couples and opposite-sex married couples. As well as going against the standard principled approach of avoiding imposing retrospective unfunded burdens, removal of the current exception in the Equality Act would potentially lead to a much wider range of discrimination claims against pension schemes. There would be a significant risk of a domino effect, leading to full equalisation of survivor at a significant cost to schemes and the taxpayer. And the Noble Lord Ali said that no public money would be required to make this change, and I disagree. In addition to its impact on private sector schemes, the amendment would also impose a direct cost on the public service schemes, who would at least have to pay survivor benefits to surviving female civil partners based on pre-1988 service. This is because if the amendment was passed not to pay benefits to surviving female civil partners based on pre-1988 service would be discrimination on the basis of sexual orientation. In order to remove any discrimination on the basis of sexual orientation, public sector schemes would have to equalise pension benefits for surviving female civil partners and couples of the same sex who are married with those for widows, which are based on accruals from 1978. At the moment, benefits for those female survivors are currently based on accruals from 1988. There is therefore an immediate cost to the taxpayer. The amendment would remove statutory provisions which mean it is not discriminatory for occupational schemes to only pay survivor benefits to civil partners based on the service of a deceased partner since 2005. It would also remove the provision in this bill which extends this exception to same-sex married couples. If the intention is not to alter the existing arrangements that apply to civil partners, but instead to ensure there is no discrimination between same-sex married people and opposite-sex married people, then Amendment 84 will not achieve this. It would impact immediately on those occupational schemes which currently make no provision for civil partners based on service prior to 2005. An alternative approach, which may be what the Noble Lord Ali would like to achieve, would be to equalise the position of people who are in same-sex couples and married with that of people or opposite-sex married couples. However, there is significant uncertainty as to whether a change of this kind would in fact have this result, given that the government would need to consider carefully whether different treatment of civil partners and married couples, married same-sex couples in this regard would be capable of justification. Further, instances of inequality between men and women run through the pension system because, as I have explained, rights built up in the past reflect the different social attitudes of those times. This means there are pre-existing differences in treatment between men and women. These differences mean that any change short of full equalisation would deliver only partial equalisation. Anything less could lead to new gender discrimination arising in the schemes. So removal of the current exception in the Equality Act would potentially lead to a much wider range of discrimination claims against pension schemes. There would be, as I say, a significant risk of a domino effect leading to full equalisation between widows and widowers across the public service schemes at a significant cost to the taxpayer. We do not know for certain what the full cost of the domino effect would be, but we know that in 2011 the Government Actuaries Department estimated the cost of equalising survivor benefits for widows and widowers in the public service schemes at between 3 and 4 billion. And this gives an idea of the potential cost to the taxpayer of full equalisation. And it also indicates why governments, including the government of the Noble Baroness Lady Royal, have avoided imposing retrospective changes on schemes. Now, while I understand the concern that same-sex married couples will be placed in a different position as regards their pension benefits from opposite-sex married couples, this demonstrates the need to consider very carefully whether any departure from the established approach is appropriate and what the costs and legal implications of any change would be. It would be irresponsible for any government to commit itself to potentially imposing significant costs on businesses and the taxpayer without undertaking an assessment of the full scale of those costs. And whilst it has taken me quite a bit of time to read all this out, it is very much the government's position, I think just the very fact that it is very complicated and hard to understand justifies the very fact that this is something which is not easy to solve in one fell swoop. It is also
I'm grateful. I may be wrong, but isn't it the case that to give effect to the principle, the EU principle of equal pay for equal work, there was in fact retrospectivity to give effect to that principle?
My noble friend is introducing a new, very complicated matter, and I'm struggling with the complicated matters in front of me. And
I wonder if
I am going to conclude very soon. I wonder if my noble friend would allow me to make some.
You just seem to be an appropriate point to interrupt the very clear exposition which my noble friend is making. Could I put this case to her? Here is a company which has a final salary scheme for existing members and then later in time introduced a defined contribution scheme. Is it the case that the fact the people in the defined contribution scheme can't get all the benefits in the original scheme, nonetheless the people under this retrospective legislation will be able to do so. So they will be more privileged than the people in the existing defined contribution scheme.
I think that's an interesting point. I mean, my understanding of the original proposals in Amendment 84 would only apply to those who are currently in a defined benefit scheme, and this is not about introducing the benefits of a defined benefit scheme to those who are not in a defined benefit scheme but are only in a defined contribution scheme. So I don't think what my noble friend is suggesting is actually what is proposed in the Noble Lord's amendment. As I have tried to explain, any change to the arrangements set out in the bill would impose costs on the public purse, and these would be considerable. Therefore, the House should be aware that any change to the position set out in the bill would have a cost, as I say, to the public purse. So an amendment to the bill on this issue would infringe the House of Commons' financial privilege. Given the degree of uncertainty and the potential scale of these costs, we should be very clear about what the implications and the costs of the change might be before we make any legislative commitment in this area. What I think we can agree on is that...
I was with the noble lady to that point. I really think the government cannot say there is a public cost, there is money coming out of the Treasury for a section of this bill marked Occupational Pension Scheme, Part 6, page 36, which is limited to occupational pension schemes only. There is no public money, and I do not think the government can say there is. It is so clear that I think the House really shouldn't be put in the position of believing public money is being spent on this.
Well, I hope that I'd been able to explain through the through my answer so far that there is a cost to the public purse in the Amendment 84, and therefore, because of that, therefore there would be this would lead to the bill being, or rather the amendment to the bill infringing the House of Commons financial privilege. I mean, I've explained to the House why the government believes that is so. But if I may, because I'm about to conclude. Given the degree of uncertainty and the potential scale of these costs, we should be very clear about what the implications and the costs of the change might be before we make any legislative commitment in this area. What I think we can agree on is that this debate demonstrates the need for us all to be much better informed about the wider implications of equalising entitlement to survivors' rights. And I think some of the points made by my noble friends Lord Higgins and Lady Noakes demonstrate that there are issues that need proper and careful consideration. My Lords, all that said, I can see the sense in what the noble Lord, Lord Alley, is trying to achieve via the manuscript amendment 84A he has tabled today, which includes a review and order-making powers. And I'm grateful to him for reflecting further following the meeting we had yesterday with the Pensions Minister, my honourable friend Steve Webb. I am very conscious of the strength of feeling that has been expressed in this debate, and I have considered the points that have been made very carefully. And whilst I cannot accept his amendment as it stands today, what I am willing to do is to take it away and discuss further with my ministerial colleagues, and with the firm intention of bringing back a government amendment at third reading. And I therefore hope that the noble Lord Alley feels that he can withdraw 84A today.
My Lords, can I thank the noble lady, the Minister, for that? Before I move on to that, I'd like to add a few things. 8 minutes. It was 8 minutes before all 5 of my responses were used. And I say that because it is a very complex area, which I accept. But there is a lot of smoke here. And the issue that most concerns me, and the reason why I intervened, is there is no public money. There just is no public money. And I say that having looked very deeply into this issue. And for those at committee, I said that I had the honour at the beginning of my career of being the publisher of Pensions magazine, and Savings Market, The Insurance Age, and Review. So I have spent a little time understanding the pensions market. The £2 to £3 billion that the government refers to is about taking out the gender discrimination between widows and widowers. that there have been recent judgments that have upheld that principle. Yeah? It has nothing to do with occupational pension schemes. The second correction that I really wanted to make was the issue about the Civil Partnership Act and why this was put in place. The Civil Partnership Act, there is no corresponding civil partnership for straight people. So the read across between opposite sex couples and same-sex couples didn't apply with civil partnerships. In this particular instance, yes, there is a read across of a prejudicial treatment of two types of married spouses. And that is my concern. No. The final issue is the cost is so minimal. £18 million at the low end, £80 million at the high end. And the actuarial assumptions, so hard to make. Actuaries, in my experience, don't build in the cost of gay people into their schemes. They don't look at, yes, whether someone is straight or gay and discount the rate. Historically, they don't go back and say, some gay people will have married because history allowed them to do so or society forced them to do so. The actuarial calculations, I'm pretty sure, will remain pretty static. Right. So they are, for me, the issues involved. But I have to say thank you to all noble lords that contributed to this debate and given support. I would like in particular to pay thanks to the noble Baroness Howe of Idlicott and the noble Lord Leicester of Herne Hill for adding their support to Amendment 84. I'd also like to thank my noble friend Baroness Waller Blazon for adding her name and support to Amendment 84A. And of course, I do want to thank the Minister. And we have all been on a huge educational process in terms of pensions. I fear there may be another week of pensions mania, for which I deeply apologise. But I thank her for her response. I think it's what the House had hoped to hear, and I'm very pleased with it. So on that basis, I beg leave to withdraw Amendment 84.
Is it your Lordship's pleasure that this amendment be withdrawn? The amendment is by leave withdrawn. Manuscript amendment, Lord Alley, 84. Not moved. Before Clause 12, Amendment 85, Lord Armstrong of Ilminster.
My Lords, I move this amendment standing in my name and in the names of my noble and learned friend Lord Mackay of Clashfern and my noble friends Baroness Williams of Crosswick and the Lord Lee of Condor, if a crossbencher may be allowed to have noble friends in all parts of the House. Yes. What are the purposes of this amendment? The preamble makes it clear that it is limited to legislation regulating or relating to marriage. The primary purpose of the bill is, I take it, to enable same-sex couples to be married and to enjoy the same rights and privileges and be subject to the same laws, duties and obligations as married man and woman couples already enjoy and are subject to. As the noble Lord the Minister said on, noble Lady the Minister said on Monday, there is one institution of marriage and we are opening the door to it. There will be only one door and all couples will be invited to walk through it. That's the end of the quote. My Lords, the first sub-clause in this amendment supports and restates that purpose. The institution of marriage will be like a club of which all lawfully married couples, whether in same-sex marriages or in man and woman marriages, are equal members, enjoying all the privileges and pleasures afforded by the club and accepting the rules of the club and the duties and obligations of membership. Once this bill reaches the statute book, there will be, within the single institution of marriage, two forms, or as Lord Alice said just now, types of marriage. there will be a high degree of uniformity within the institution between the two forms of membership. But as in any club, not all members will be exactly alike. There will be some differences, fundamental differences, physiological and biological differences, which all of us recognise and understand, and which no human legislation can ever completely smooth over or eradicate. We should be doing the cause a disservice if we were to pretend that it will be or might be otherwise. So this amendment is intended to provide for the greatest possible degree of uniformity in legislation as between same-sex couples and man and woman couples, but also for situations in which, because of these fundamental differences, it may be necessary, not just desirable, but necessary, to introduce legislation which applies to marriages of man and woman couples, but not to marriages of same-sex couples, or conversely, to marriages of same-sex couples, but not to marriages of man and woman couples. When or even whether such a situation is likely to arise, I cannot predict. But our debates on this bill have already shown that the development of the law on marriage in the new circumstances will, for some time at any rate, be a complicated and delicate business. It seems to me to be more likely than not that such a situation will arise within the next few transitional years after this bill is passed, as the new institution settles down. If that is so, we should be foreseeing it and providing for it now. My Lords, the definitions of the two forms of marriage suggested in this amendment are dry and factual. It would be possible to find in the great heap of the riches of the English language apt words of greater evocative moment, though not perhaps of greater pith. I rather think that traditional should not be one of them. That word has too limited a shelf life for use in legislation. Innovations tend to become quickly encrusted with traditions. That is part of the process of establishing them. And the youngest traditions are often the strongest. We know what traditional marriage means today, but I hazard a prediction that within a generation of the passage of this bill, perhaps even within 10 years, gay marriage or gay and lesbian marriage will become as traditional as heterosexual marriage. However that may be, the definitions in this amendment have been adopted because they are already those in the bill. So that is what I might call the line of least resistance. My noble and learned friend Lord Mackay of Clashfern particularly hopes that the noble Lord Phillips of Sudbury and the noble Lady Baroness Howarth of Breckland will be gratified to note that this amendment is 100% bracket-free. Sorry, my lords, my fingers are thumbs. My lords, these definitions are permissive, not mandatory. The amendment makes it clear that they may be used in legislation, not that they shall be used. If in future anyone wants to use different definitions in new legislation, they will be free to do so. My lords, we offer this amendment as seeking to improve the bill, not to weaken or dilute or frustrate its purposes. It is completely even-handed. It neither expresses nor implies any value judgments as between the two forms of marriage within the single institution of marriage. It cannot be interpreted as implying that one form of marriage is superior or inferior to the other. I commend the amendment to your lordships as a strictly limited, practical, realistic, sensible and undogmatic proposal for dealing with problems which are likely to arise in relation to the application of legislation to the institution of marriage, as it will be once this bill has been enacted. I beg to move.
Amendment proposed before clause 12 inserts the new clause as printed on the marshalled list.
My Lords, some amendments moved in the course of our debates have been eccentric. But I think, respectfully, Amendment 85 is among the most eccentric, not least because of its very distinguished supporters, the former Cabinet Secretary and Lord Chancellor, and my noble friend Baroness Williams of Crosby, whose deeply held religious convictions as a Catholic I fully respect. My Lords, leaving aside its extraordinary length and detail, Amendment 85 is moved in the face of the overwhelming and decisive decisions made by the House on Monday to reject similar attempts to classify and separate opposite-sex and same-sex marriages. The amendment declares in paragraph A that there shall be no distinction or difference between lawful marriage of same-sex couples and lawful marriage between a man and a woman, save as provided for in this Act. And if the amendment stopped there, it would be completely unobjectionable, although also completely unnecessary. But it doesn't stop there. It continues by making an exception, quote, as required to give effect to any difference or distinction which is made necessary by reason of physiological or biological differences of gender or consequences thereof. My Lords, it's probably my fault, but I don't understand what that is meant to mean. Most men and most women are biologically different, and sexual intercourse between man and man and man, and woman may reflect those differences of biology and anatomy. But how do those differences require future or existing law regulating or relating to marriage to treat traditional conjugal and new consensual marriage differently? My Lords, we are beyond the watershed for children, and I should be grateful for an explanation about what this has to do with the law rather than the Kama Sutra. Paragraph B seeks to separate the two forms of marriage using about 100 words instead of a bracket. But we've already firmly rejected that attempt. What is the point, I respectfully ask, of rehearsing the arguments again and again? Paragraph C is unnecessary because it goes without saying, or should go without saying, that existing legislation will continue in effect in relation to opposite-sex marriages, except as amended by the bill. As to paragraph D, given the vague obscurity of the earlier parts of the amendment, its meaning and effect would puzzle Henry VIII and his Lord Chancellor, as well as the current holder of that high office. If the noble Lord tests the opinion of the House, I hope the amendment will be rejected.
Lords, I agree with the noble Lord, Lord Leicester of Herne Hill, though possibly not in relation to the Kama Sutra. Right. The noble Lord, Lord Armstrong of Ilminster's point, as I understood it, was that provision should be made in this bill to confer power to address problems that may arise in consequence of this bill when enacted. But of course, clause 15, subclause 2, already does that. What it says, can I remind you, Lordships, is that the Secretary of State or Lord Chancellor may, by order, make such provision as the Secretary of State or Lord Chancellor considers appropriate in consequence of this Act. And subclause 3, for the avoidance of doubt, states that any such provision that may be made includes provision amending United Kingdom legislation. That would seem to me amply to address any concern.
May I just say one thing, because I was attacked at the last, not attacked, but charmingly referred to by the noble lady, that she said I was being a bit jokey about adultery, and I really wasn't being jokey about adultery, but I still think I'm coming back to my mother again on this, because what is being proposed here is actually another version of the ones that we've had all the way along, because this one is to say we can't find anything at the moment, but we might find something in the future. So in case we do find something in the future, we'll put something in at the moment, and by the way, that means we can point to the thing we put in the moment which shows that actually there is a difference, and it is different, and that's what we meant in the first place. That's what it is. I'm not a lawyer, but it seems to me I don't need to refer to the law, if I may dare say, to the two noble lawyers who went before. All I can say is that this is one of the most ingenious attempts we've had so far. I don't think they can do it again, but it is another go. And once we give way, even if it's charmingly presented by the noble with such elegance and beautiful English, which we all honour him for, the fact is it won't wash. It's another go. Let us not take it, and if it is to be voted on, let's increase the majority over the 200 we had last time.
My Lords, I do agree with the noble Lord Deben that this is an elegant amendment, and it might be bracket-free, but it has an awful lot of commas and sub-clauses. I listened very carefully to noble Lord Armstrong and the supporters of this amendment who didn't speak, but are distinguished members of your Lordship's House, to see if there were indeed new arguments to justify passing an amendment which would, like the ones we discussed on Monday and in committee, undermine the purpose of this bill, which is to have same-sex marriage on the same basis as opposite-sex marriage. And I do pay tribute to the noble Lord Armstrong for his ingenious amendment, which seeks to undermine the bill through secondary legislation. But, my Lords, its effects are the same as those that went before. And, my Lords, I am still puzzled as to why those noble lords feel that same-sex marriage somehow undermines opposite-sex marriage, and indeed their own. We do not believe that the bill needs two classes of marriage, one gold and one base, which will be the effect of this amendment. And we do feel that the time has come to perhaps stop having this argument that there should be two sorts of marriage. So certainly I and my colleagues will be not supporting this amendment.
My Lords, can I thank the noble Lord Armstrong of Ilminster for his amendment, and also which he, in view of the hour, and I think we were all very grateful to him on Monday evening, he decided to degroup so we could actually debate it today. But I think even allowing for the intervening hours, it will not come as a surprise to him nor anyone else that we do not feel able to accept this amendment. However, to use my noble friend Lord Deben's words, however ingenious, or to use my friend noble friend Lord Leicester's words, however extraordinary it is. It does contain within it, as the noble lady Baroness Thornton has said in paragraph B, the same distinction between marriage of a same-sex couple and the marriage of an opposite-sex couple that was embodied in Amendment 1, admittedly without the brackets. Although I think this question is for better or for worse, I'm not quite sure. But it was the amendment which my noble and learned friend Lord Mackay of Clashfern moved was one which did seek to have two different institutions of marriage to exist in law, one for same-sex couples and one for opposite-sex couples. And as my noble friend Lord Deben said, this is another attempt, and I think in all fairness, my noble and learned friend Lord Mackay of Clashfern said when he was moving his amendment on Monday, he said, "This is a minimum that seems to work, although I and other noble lords think it may be possible to go further." And he then said, "The later amendment of the noble Lord Armstrong, to which I and others have added our name, indeed does go further than the minimum." And I think, my lords, the vote which we had on Monday was very decisive. Of 119 voting content, 314 voting not content. So I believe the House has made clear its view that it would not be right to draw a distinction in the bill of the kind set out either in Amendment 1, which we voted on, nor, I believe, that is here in Amendment 85. As has been said on more than one occasion as this bill has been debated in your Lordship's House, it's about inclusivity and it's about fairness. And this amendment, I believe, strikes at the heart of that intention. We do not accept that there should be a separate term or institution in law for marriages of same-sex couples. We want them to marry, plain and simple, in the same way that opposite-sex couples can. And I think my noble friend Baroness Stoll of Beeston, when she was replying to the amendment moved by my noble and learned friend, said at columns 31 to 32, "It is very simple. there is one institution of marriage. It is one of the most important institutions that we have, and we want gay and lesbian couples to be part of it in exactly the same way as any other couples who wish to be married. These amendments create two separate, potentially legal institutions and therefore undermine the fundamental purpose of the bill. And it's for that reason, principal reason, that we cannot accept this amendment. I just further say that the amendment, I believe, would create considerable confusion in terms of the effect it would have sitting alongside Clause 11, and as it deals with much the same subject matter, how marriage for same-sex couples and opposite-sex couples is to have effect and being interpreted in law. It adopts a different approach, but it makes no provision about the interaction of the two, and I do believe that this confusion about how it might work is another reason, in addition to the one of principle, as to why this amendment should be rejected. My Lords, I do hope that the noble Lord will withdraw his amendment, but clearly I would hope that if it is pressed to a division, that the House would see fit to defeat it.
My Lords, I am grateful to noble Lords who have taken part in this brief debate. I didn't expect to please the noble Lord Leicester, but I don't myself think that the amendment deserves the obloquy that he attempts to throw upon it. Nonetheless, against the views that have been expressed, I do not think it would be right to force a division on this amendment, and so, with some regret, I withdraw the amendment.
Is it your Lordship's pleasure that this amendment be withdrawn? The amendment is by leave withdrawn. Schedule 5, Amendment 86, Baroness Stowell of Easton.
My Lords, I beg to move Amendment 86, and in doing so I will also speak to the other government amendments in this group. My Lords, I'm pleased to have this opportunity to talk about a group affected by this bill who are often overlooked in our debates, and that is those men and women who are transgender. And I would like to put on record, before I go on, my thanks to all of them for sending me the many emails that I've received from them over the last few days. This bill will, for the first time, enable couples who wish to remain married when one spouse obtains gender recognition to do so. And this is a welcome development for trans people who have in the past been faced with the difficult choice between obtaining gender recognition or staying in their marriage. Whilst the government does not believe it is justified, I nonetheless understand that there is a real fear amongst some trans people that the bill will allow their spouse to veto their attempt to get a full gender recognition certificate if they do not wish to remain married. And I have listened very carefully to the views that have been expressed in committee and in meetings with noble lords about this issue, and indeed I am very grateful to the noble baronesses Lady Thornton and Lady Gould, and also my noble friend Lady Barker, who made time to discuss their concerns with me in some depth. And having done so, I am grateful for the opportunity through amendments 87 and 88 to make clear that all the non-trans spouse is being asked to give their consent to is whether they wish to remain married if their spouse changes their legal gender. Now, I think it's important that I explain why this consent is needed, because some people have questioned why the consent of the non-trans spouse is needed in these circumstances. And the reason, therefore, is this. A party to a marriage obtaining gender recognition is a life-changing decision for the applicant and their spouse. The marriage will no longer be contracted between a husband and a wife of the opposite legal gender. That is why it is right that both spouses have the right to agree to a proposal to change the terms of their marriage before the change takes place. Regardless of the non-trans spouse's view about the future of the marriage, the applicant is still able to get their gender recognition. Trans people whose spouses do not give their consent to remaining in the marriage will be in the same position as they are now. It will be open to either spouse to commence proceedings to end the marriage before the full gender recognition certificate is issued. I am very pleased to table these amendments today, which I hope will put it beyond any doubt that a spouse will never be able to veto a trans applicant's ability to obtain gender recognition. I hope these amendments, which make it clear what it is that both parties to the marriage are agreeing to, will allay the concerns that have been expressed, and I commend these amendments to the House. As to Amendments 86, 89 and 133, as I said during committee stage, the Government has been considering very carefully what can be achieved within the scope of this bill to assist trans people who made their transition to their acquired gender a long time ago, but have not applied for gender recognition up to now because they would have to end their marriage. This bill now gives such people the opportunity to obtain gender recognition while remaining married if their spouse is content for the marriage to continue. But applicants who made their transition a long time ago may find it difficult to obtain the required medical reports from gender dysphoria specialists. These amendments will assist these applicants. These amendments will make the new fast-track procedure available to trans people who are or who were in protected marriages or civil partnerships and who transitioned 6 years prior to the commencement of these provisions. It will help them by reducing the amount of medical evidence they will be required to submit to the Gender Recognition Panel. Such applicants for gender recognition will be required to submit one medical report, either from any medical practitioner, including a GP, or else from a registered psychologist who practices in the field of gender dysphoria. I can assure the House that a great deal of time and consideration has gone into developing these amendments, and I hope that they further demonstrate the positive changes this bill is seeking to make to the lives of married trans people, and I therefore commend them to the House.
Amendment proposed, page 40, line 10, after with, insert this part of.
Lords, can I begin by firstly thanking the Minister for her tolerance and her forbearance throughout our discussions on this very complex issue, and for taking the time to meet myself, Baroness Thornton, and Baroness Barker, and to try and see if it was possible to arrive at a common view. And before looking at how successful our talks were, I do want to say on behalf of the trans community how much we appreciate the inclusion in the bill of the clauses that remove anomalies in respect to providing married trans people who wish to apply for recognition by removing the requirement for them to being single at the point of gender recognition, and so removing the obligation to dissolve their existing marriage or civil partnership. And equally important to the community is the concession on the spouse's survival pensions, ensuring that ongoing financial penalties will be incurred should a trans person be in an existing marriage gain gender recognition. And the Minister has also just referred to the question of the fast-track procedure, which is also very much appreciated. However, there came, I must say, a little disappointment, because we certainly have been unable to resolve the concerns over the question of the issue of spousal consent. We do appreciate that the amendment the Minister has outlined does clarify the position in respect of married couples and clarifies the definition of statutory declaration of consent. But in reality, it makes little difference in terms of that consent, only that the divorce would probably not be en route for registering a civil partnership. But it makes little difference for the trans person. It doesn't really matter if the spouse is going to consent to the marriage or give consent for recognition. The principle thrust of the opposition to the schedule remains unchanged. And I have to say, my Lords, there was a temptation to try and arrive at a further amendment that might resolve the differences that there certainly were between us, but it did seem that that would require an awful lot of detailed discussion and deliberation. And although not wholly happy with what we have in front of us, I suppose it is in some ways a step in the right direction, which I do acknowledge. Hopefully, my lords, so there may be another opportunity in the future for that discussion to take place. And when that does occur, I hope the Minister will again be cooperative, as she has been, in trying to resolve our differences. This is almost certainly the unfinished business of the bill. There is no doubt the transgender community is angry, and it will continue to be angry until we manage to get some resolution of this problem. They're angry because they're still concerned that the bill actually does provide a spousal visa. So at this stage, I would like perhaps to ask the Minister and perhaps to seek her assurance that when this issue will be passed, that there will be, during the course of the post-legislative scrutiny, which should take place after the bill becomes legislation, this will be an issue that will then be considered.
My Lords, I freely confess that one of the happiest days of my life was the day that I gave up speaking on pensions matters in your Lordship's house. And I never thought that I would come across anything more complex until we came to this particular piece of legislation. My Lords, it's not that this is a complex issue, but when the Noble Baroness, the Minister, talks about a fast-track procedure, she's talking about something that has gone on for at least 2 years. That's the level of difficulty that we're into here. Can I start off by thanking the Noble Baroness, the Noble Baroness, the Minister? She, like the rest of us, I believe, has been on a very fast learning curve over these past few years. And we have dealt with these issues, she has dealt with these issues with great sensitivity and dedication, and I'd like to thank her for that. The Noble Baroness Gould is right. We are perhaps 90% in agreement. The people who are directly affected by this issue are very grateful for the advances which have been made in this bill, and I'm sure that the very small number of people who will be directly affected by Amendment 89, i.e. people who have not gone through the process of acquiring a full gender recognition certificate because they would have had to divorce their spouse to do so, will be extremely pleased. And we're very pleased to be accompanied by a number of bishops today, and I thought it might be apt to say that one of the couples who I know will be directly affected by this are couples who are active members of their church, and for whom their marriage was a very, very important thing, and they did not wish for that marriage to be broken up in these circumstances. So we have enabled a small number of people to live their lives with greater dignity, and that is important. I think the Noble Baroness Gould is right. The people in the transgender community believe that there is still a possibility that spouses who are very angry and upset may retain the capacity to delay the process of divorce and therefore them obtaining gender recognition for some time, mostly through the practice of starting divorce proceedings and then not actioning them. That remains an issue. I agree with the Noble Baroness Gould. We have probably gone as far as we can go in this bill, and perhaps that is something that should be returned to in post-legislative scrutiny. I think that this bill has achieved a very important step forward for a very small number of people who, in the course of their ordinary lives, put up with an awful lot of hostility. We've made their lives a bit better, and we've enabled them to live with a bit more dignity. And for that, I think this House should be very, very proud of what it's done.
Yeah. So, my Lords, Government Amendments 86, 87, 88, 89 and 133 will provide a fast-track procedure for gender recognition where individuals have been living in the acquired gender for a long period, and would clarify that consent of a spouse means consent to the marriage continuing, not consent to gender recognition. And there is no doubt we wholeheartily welcome these amendments, and would like to put on record our thanks to the Noble Lady, the Minister and her team for the amount of work that they have put in on this issue. It is an issue that colleagues in both houses have been pushing throughout the bill's passage, and I think we have made progress with the government on issues of pensions and the fast-track procedure. However, as my noble friend Baroness Gould has said, the issue of consent is a very sensitive one, and the transgender community has reacted with outrage at the idea that their final recognition through gender recognition certificate should or could be possibly vetoed by their spouse, particularly if they were estranged or the relationship had broken down. So, well, as with noble Lady Barker and my noble friend Baroness Gould, we think we have made great progress, but there is still this issue that is unresolved, and indeed a community which has faced enormous discrimination and prejudice are very concerned about this one particular issue. So I do think we need to keep a watching brief, and I do think it is something that we will need to return to, certainly during post-legislative scrutiny, if not a bill that passes along and we can find some other way of doing it.
Well, Lords, I'm very grateful to all the noble baronesses who have contributed to this debate, and it's due to the same noble baronesses who I met to discuss these matters. I will be very brief in responding to the points that have been made. I would say, first of all, to the noble Baroness Lady Gould, who raised the question about post-legislative scrutiny, that as part of that process, I would certainly expect scrutiny of the bill to consider, or for the bill's impact to be considered, and for the issue of spousal consent to be part of that process. And I think that would be, you know, a matter of form. So, I can at least give some reassurance in that regard. My noble friend Lady Barker made some comment about the fast track procedure and the length of time. I mean, I would just make the point to her that the fast track procedure reduces the amount of evidence a trans person must submit to the gender recognition panel. It therefore saves them having to obtain new additional evidence, which may be difficult and time-consuming to obtain. It doesn't affect the length of time from application to the gender recognition certificate being issued. So it's about the process prior to that point. But I think really the main thing I want to say in concluding is to say how grateful I am for the generous remarks that have been made, and to remind all noble lords that this bill is about allowing same-sex couples to marry. And what we've done is allowed trans people who are already married to stay married. And that's an enormously positive step forward, and I don't think we should lose sight of that fact. But it's also worth pointing out that because they are already married, it is essential that both spouses confirm they want to remain married, because their marriage is a legal contract which will change, because when we all get married, although as we all know I'm not married, but when people do get married, I've been to weddings even if I haven't had one of my own, on their wedding day we take somebody to be either our lawfully wedded wife or our lawfully wedded husband, and that is a legal contract between two people. And what we've been able to do in this bill is to ensure that if one of those people is transgender and wants to have transgender recognition, that they are able to do that and to remain married to the person that they first fell in love with and who they married some years before that. And I do think that's an important thing to be able to have made happen. So I take on board the points that have been made in the debate, but I'm pleased that we're able to at least acknowledge that the big step forward that this bill does allow us to achieve. I beg to move.
The question is this amendment be agreed to. As members of that opinion will say content. Contrary not content. The contents have it. Amendments 87 and 88 and 89 move formally en bloc. The question is that these amendments be agreed to. As members of that opinion will say content. The contrary not content. The contents have it. After clause 13, amendments 90, 91 and 92 already debated move formally. The question is that these amendments be agreed to. As many as of that opinion will say content. The contrary not content, the contents have it. In Schedule 6, Amendment 93, Baroness Stowe. Sorry.
My Lords, Government Amendments 90. I beg to move Government Amendment 93. The Government Amendments 93 and 128 to 132 amend provisions in the Bill relating to marriage in consulates and armed forces bases overseas to exclude their effect in relation to Northern Ireland. Clause 13 repeals the Foreign Marriage Act 1892, which applies UK-wide. Schedule 6 makes provision to replace that regime of consular and also armed forces marriages overseas with a new regime providing for marriages of both opposite sex and same-sex couples in consulates and armed forces bases. The legislative consent motion concerning the bill, which the Northern Ireland Assembly agreed on the 24th of June, does not, however, cover Clause 13 or Schedule 6 to the bill. In light of the terms of that legislative consent motion, these amendments amend the extent provisions of the bill so that the relevant provisions which would fall under the Northern Ireland Assembly's legislative competence do not extend to Northern Ireland. The effect of these amendments is that opposite sex and same-sex couples marrying under the law of England and Wales in consulates and armed forces bases overseas will be married under new procedures to be introduced by Northern Council to be made under Schedule 6 of this bill. These new procedures will also apply to opposite-sex couples marrying under the law of Scotland and in due course to same-sex couples as and when the law in Scotland is changed to allow them to marry. However, couples marrying under the law of Northern Ireland will marry under the existing legislative framework, namely the Foreign Marriage Act of 1892. This will mean that those officiating in marriages overseas will have to operate two distinct systems when conducting marriages, depending on whether they are marriages under the law of Scotland, England, Wales or Scotland on the one hand, or the law of Northern Ireland on the other. Whilst this will add to the complexity of the system, this is a consequence of the Northern Ireland Assembly not having given legislative consent to the relevant provisions in the bill, and so, my Lords, consistent with the Convention, we must make amendments to reflect that. If I may turn to Government Amendment 106, this is a technical amendment which provides for the definition of, quote, England and Wales legislation, unquote, used in the bill, also to be applied to the Marriage Act of 1949, and the amendment inserts an interpretation provision for the definition into that Act. Finally, my Lords, with regard to Government Amendment 125, this is minor and technical, and adds to the definition of Superintendent Registrar to the list of defined expressions already set out in Clause 17.2 of the Bill, and this is necessary for completeness. My Lords, I commend these amendments to your Lordship's Chamber as they will improve the Bill, and I hope that the House will feel able to support them.
Amendment proposed, page 50, line 8, leave out subparagraph 3. The question is that this amendment be agreed to. As members of that opinion will say content. Contrary not content, the contents have it. In clause 14, amendment 94, Baroness Deach.
My Lords, I move this amendment together with my noble and learned friend Lord Lloyd and with the noble Lords and Lady Okerhoyne and the noble Lord Cormac. I won't repeat the arguments that I made at committee stage, save to remind your Lordships that I'm seizing this opportunity which has presented itself in no other bill and no other foreseeable bill to extend the hand of equality and a glimmer of hope of support to the thousands, mostly women, this could be a gender issue, the thousands who as siblings have lived together for many years. I also want to help carers, very often but not always family members, where a younger person has cared for an older one for many years and then finds themselves in a bad situation when the older one dies. We now have a chance to recognise and assist them through the study which the government has already committed to carrying out in the context of civil partnerships. It was admitted in the European Court in Strasbourg that the situation is discriminatory. But it was held that the government was justified in this discrimination because it had placed the advantages of marriage firmly in one area and nowhere else. But the justification for the discrimination that actually exists against people living together in a codependent, supportive and loving arrangement, the justification for that discrimination has gone. My Lords, the Berlin Wall of marriage has come tumbling down, and there are others who are coming out
who need our help and support in the name of equality. And this is not merely about money, albeit that a great deal of time has been spent on financial arrangements and pensions in the last few days. It isn't just about money. It is about the advantages conferred by marriage and civil partnership, and shortly, same-sex marriage. That means the right to live in a home, pensions, medical consent, responsibilities and rights in relation to children, and many other rights and obligations attaching to that status. If you read the amendment carefully, you will see that I'm not pressing for a change in the law in this bill. I am merely asking that the government study the situation when it undertakes a review of civil partnerships, as it has pledged to do. I cannot imagine anyone hard-hearted enough to block this, although I gather the government is not sympathetic, and I fail to understand why. At second reading and at committee stage, certain objections to my amendment were voiced. Your Lordships will recall that the opponents of same-sex marriage argued a while ago that its existence would undermine traditional marriage. This was stoutly denied by, inter alia, the noble ladies, Lady Royal and Barker, and the noble lords, Lord Marks and Lord Alley. Why, they said, should recognising the existence of one union have any impact, let alone adverse, on another, causing the older union to be less respected or more fragile? Their arguments were and are persuasive. If recognising same-sex marriage has no impact on heterosexual marriage, then recognising a union or contract or arrangement of some sort for siblings and carers likewise can have absolutely no impact on same-sex marriage. Not that I'm arguing for an exact same union, far from it. The amendment that I have put forward suggests that a formal contract or union could be established which in no way detracts from civil partnerships as they exist now and has no religious connotation or connection. For example, in France, there exists a Pacte Civil de Solidarité, known as PACS, for some heterosexual couples and same-sex couples with most of the advantages and status of marriage, but which can be terminated very readily by a letter from one to the other or by marriage entered into by one of the two. It is popular. It presents a model for adaptation. The noble Lord Alley argued at committee stage that lending a helping hand to siblings and carers would devalue civil partnerships. I said then, and I repeat, I do not get it. Not only do I not understand the fears and what seems like protectionism of those able to succeed in achieving same-sex marriage, I cannot understand the logic. There are no limitations on equality. It is not rationed. We can all have it. There is enough to go round. It isn't a situation where equality for some means nothing left for others. On the contrary, those who make the case for equality in unions, even with the very small differences that we've debated in the last few days, ought to be generous to others. To deny to others, simply a study, to deny to others what they seek for themselves, sets an unfortunate precedent. Love and commitment come in many forms, not necessarily with sex, as has been pointed out. Ordinary people will recognise the love and care that some family members give to each other, and if only there were more of them. Ordinary people will find it incomprehensible to treat them as less deserving or inferior when the opportunity, maybe once in a generation, presents itself to study their situation in this bill. At the committee stage, the noble lady, Lady Farrington, was worried about incest. My lords, this is extraordinary. My amendment refers to people who have cohabited voluntarily for over 5 years and are over 18. It cannot be seriously suggested that two sisters, or a father and daughter, who are already living together in a codependent household, taking care of each other, are guilty of incest, a punishable crime. The length of cohabitation referred to in my amendment also answers the argument made that family members might be forced by others to enter a union. It will be their free choice, because what I'm suggesting would only come about if those people had already been living together for a long time. Duress vitiates contracts and marriage in English law in any case. As I said, if the government studies the situation and decides that these people need help, whatever it is that they come up with need not be called, I'm certain, would not be called civil partnership. It might be called a family contract, for example, and be terminable by letter or by the marriage of one of the two. There's nothing wrong with that. If one of two siblings or carers gets married, that is a very happy outcome, and their rights and obligations will lie elsewhere. My Lords, your support for this amendment will show that we take equality, love and commitment seriously for all. We do not confine it to groups who have attracted support. We look out, all of us, for each other, for our citizens who are taking care of each other. We want to grant them all the equality that they need, as enshrined in the European Convention on Human Rights and our own Equality Act. Equality for one in no way detracts from the equality of another. As I said, the Berlin Wall that once existed to separate marriage from all other unions has fallen. And if I can mix my metaphors, those who are achieving equality shouldn't pull up the ladder behind them when the opportunity presents itself, as it does today, to extend support, or at least just inquire into the need for support for those others. The debates on this bill have proved an epiphany. There is no ration of equality, no limit on respect. My Lords, I beg to move.
Amendment proposed, page 13, line 13, at end, insert the words as printed on the marshalled list.
My Lords, I have my name on this amendment and I'm delighted to support it briefly. The noble Lady Baroness Deach has spoken, as she did last time, very eloquently. All I would wish to add and to say to your Lordships is that a review is to happen. If that commitment had not been made, it could have been argued that this amendment was an intrusion and that it was not appropriate or fitting to be debated during the course of this bill. But the government gave that undertaking in another place. And if the government is to have this review of civil partnerships and attendant matters, then it is surely right, as the noble lady has argued so forcefully, it is surely right that these other relationships should be taken into account. In the name of equity, in the name of decency, it is right that your Lordship's House should say, please include these relationships in the review. That is all that we are asking. We have no guarantee what those who conduct the review will finally determine. But to exclude this from their terms of reference would be entirely wrong. And I would beg your Lordships to support the very sensible and extremely modest suggestion that the noble lady has made.
I also have my name attached to this amendment. In my speech in committee, I gave two examples within my own experience of couples whose case ought to be considered in the forthcoming review. One was the former Bishop of Lewis, who shared a house with his sister for very many years until his death. And the other was a man living in our village who was paralysed many years ago in a riding accident. and has been looked after ever since by a young friend of his. My Lords, my friend, the noble Baroness, in moving the amendment, made it clear that she is not asking for a change in the law now. Lord, she's not even asking for a new review. There is already going to be a review, as the noble Lord has pointed out already. Under the bill as drafted, the review can consider other matters relating to civil partnership. It seems to me, therefore, that on the ordinary meaning of those words, it is for those who oppose this amendment to say why those other matters should not include the two cases which I have mentioned from my own experience, the case of the sibling and the case of the long-term carer, both of whom are, of course, covered by this amendment. There was the very point made by the Bishop of Ripon and Leeds, the point I've just made in committee, that there's to be a review anyway. And it was echoed by the noble Lord Pannock. And since other matters are going to be considered in that review relating to civil partnership, this seems to be the ideal occasion to consider the points which everybody agrees are points which are worthy of consideration. So what are the objections to the amendment? I start with the objection raised by the noble Lord Marks, who I'm sorry to see is not in his position. He says that accepting this amendment would undermine the whole notion of civil partnerships, which are about loving relationships between people living together as couples. Well, so far, no one could possibly disagree with that. But then he went on to say that such relationships must, however, to be within the civil partnership meaning, be sexual relationships. But where does he get that from? There's nothing, so far as I know, in the 2004 Act which confines civil relationships to sexual relationships. Why should civil partnerships not include the sort of platonic relationship which the noble Lord Mackay referred to on Monday in relation to the debate which we held on that day? Lord Elliston Morgan argued that non-sexual partnerships might not come within the long title of the bill. But why not? It refers only to civil partnerships, not partnerships of a particular kind. Lord Alley argued that to include carers would inhibit the further development of civil partnership to a point where they might be blessed by the church. This would not, he said, be possible if civil partnerships included carers. But surely it would not be beyond the wit of the church to devise a method by which they would bless some civil partnerships, but not others. So why should the partnership be devalued, the whole notion of a partnership be devalued, just because this amendment is accepted? As the Minister said, the argument advanced by the noble Lord Alley was just the sort of argument which should be considered when the review takes place. And I agree with him about that. I can understand why Lord Alley desires that civil partnership should continue to develop in the way he wants. But why should he stand in the way of civil partnership being developed in the way in which we want, which would include both the siblings and also the case of the carer?
My Lords, finally, coming to the Noble Lord Wallace's objections to the amendments, he agreed with Lord Marx's argument, and I say no more about that. He said that it would undermine the current understanding of a civil marriage, but why, I ask him, and I hope he will explain that further. Secondly, he said it would be difficult to cover the case of the sibling because of the rule about consanguinity. It would lead to the legitimization of relationships which are currently prohibited. I would give the same answer to the Noble Lord as he gave to Lord Alley. That is just the sort of matter which should be considered when this review takes place. So I hope, as we know the review is going to take place, that he will accept this amendment and allow these matters to be considered along in that
My Lords, I too support this amendment and would make 2 points, just picking up what the noble and learned Lord Lloyd of Berwick has said. First of all, if both spouses are in agreement, consummation is not a necessary part of marriage. You perfectly well have a platonic marriage throughout the entire period of that marriage. Consequently, that point goes. Secondly, the government has opened the door. Okay, it was a deal done in the House of Commons, but the door is actually open. And once it's open under Clause 14, that the Secretary of State must arrange for the Civil Partnership Act to be reviewed and for a report on the outcome of the review, and the review, it does not prevent the review from also dealing with other matters relating to civil partnership. That absolutely opens the door for the amendment that the noble lady has put forward, and I find it very difficult to understand why it can't at least be looked at.
My Lords, I wish to support this amendment as an example of the category of person that it is intended to cover. Having lived for some 30 years in a shared household with my sister, a jointly owned home, shared management and payment of household overheads, and with the commitment of a happy family relationship, sharing everything but sex. It's therefore disappointing to find that the ties of blood and family love are less important than other bonds, and that the concept of equality does not cover this. Sadly, my sister died 3 years ago, so I gain nothing personally from this, but others can. I therefore fully support all that the noble Baroness has said in moving this amendment so clearly and helpfully, and I trust that your lordships will give it very sympathetic consideration.
My Lords, I listened carefully at committee stage to the arguments for why sisters, brothers, fathers, sons, mothers, daughters should be allowed to have civil partnerships, and I will try and address some of the issues raised by the noble Lord Berwick. The first thing I want to say is about the development of civil partnerships in terms of religious organisations. I set out at committee stage why I believe the gap between where we are today and same-sex marriage is too big for the churches to make in one step, for many churches. I believe I will see a day in the not-too-distant future when civil partnerships will be celebrated in churches. And I think that if we were to broaden civil partnerships beyond the scope they are today, I think we will endanger that. This amendment also seeks, via the Civil Partnership Review, to extend the eligibility of unpaid carers to those they care for civil partnerships. My Lords, I'm very confused about this. I don't understand what prevents that happening today. If you are a carer and you are of the same sex, you can have a civil partnership today. If you are opposite sex, you can have a civil marriage. We don't inquire into the nature of either of those institutions, and all the benefits that the noble Lady Deach asked for, all the benefits the noble Lord says wanted, are available. So for unpaid carers, the very notion that is being asked for exists. That can happen today. The issue, therefore, boils down to the issue of brothers, sisters, father, son, mother, and daughter. And
the noble Lord goes on to that point. Does he advance the same argument that Lord Marx advances, that there must be a sexual element in every civil marriage? That's the difficulty which I feel with the argument the other way.
I have the same answer for same-sex marriage, for opposite-sex marriages. We don't ask that question. We just don't. We say, if you say you are married, you define the nature of your own marriage. The state only intervenes in the breakdown of that marriage when you cite the grounds for your divorce. And you can choose adultery, or you can do unreasonable behaviour. The same for civil partnerships. But I do understand, like marriage, civil partnership, there is a component of the majority of the relationships start with a sexual component. And that must be broadly understood. My Lords, I have two principled objections to the noble lady's proposition. Firstly, it's about the nature of the relationship in terms of civil partnership. The noble lady seeks to use the civil partnership to review the government's tax and inheritance law. And that doesn't deal with the nature of civil partnerships as I understand them. They were devised and brought into being to recognise a loving and indeed, and I accept the point, and indeed, in most cases, a sexual relationship between two individuals of the same sex. It was devised to give those sexual relationships a status in law, but not exclusively sexual. It gave them the same benefits in many cases as married couples. It specifically excluded relationships that were exempted from marriage, i.e. mothers, daughters, fathers and sons, brothers and sisters. To me, because of my view of civil partnerships, and it's my own personal view, and I think it's probably the view of the majority of people in this country, the very notion of giving the access to civil partnerships between family members is the same as giving access to marriage to a brother and a sister, a father and a son, a mother and a daughter.
As I'm grateful to the noble Lord for his courtesy in giving way. But the fact is, there is to be a review. That is not in doubt. There is to be a review. What possible exception can he take to those who are conducting the review, looking at the relationships mentioned by the noble Baroness in her speech? It may be, as I said in my brief remarks, the review comes to the conclusion that they should not be included. But why does he want to stop these relationships being considered by this review?
I thought I was giving three reasons. The first was my reason about trying to get the churches to make a step and use civil partnerships as part of that transition where they can recognise the stunning relationships between a man and a woman and a woman without having to cross that line into marriage. The second is, I believe, what the noble Lord seeks already exists. For unpaid carers, they can enter a civil partnership where they are the same sex, and they can enter a civil marriage and get those benefits. And the third is, I believe, civil partnership...
My Lord, could I just intervene? Can I ask the noble Lord, is he saying that two sisters, he seems to be saying this, we're looking after that. Well, could he make himself clearer, because I didn't understand that.
He wasn't here.
Yeah. The third component of this is the one I'm coming to, which is about the nature of the relationships of civil partnerships. I don't view civil partnerships as a financial transaction between two people. I believe they are based on, initially, as I said, but not exclusively, a sexual relationship between two same-sex couples. It is that sexual relationship, often that mirrors marriage, that forms the basis of it. I know your lordships don't, well, I actually don't know, but the lordships don't like talking about sex. But sex is part of what is the foundation of marriage, and it's the foundation of civil partnerships. And it's for that reason that, for me, I look at civil partnerships akin to marriage. The thought that a father could marry a son, or that a mother could marry a daughter, or that two sisters or two brothers could marry, substitute the word civil partner, is what makes it feel wrong to me. Because civil partnerships make it feel like a relationship that should not be allowed. My lords, I believe the noble Lady Deach, and I don't question her sincerity, sees it as a piece of paper that brings the financial benefit. My lords, this amendment is one of a process. It should be up to the government of the day to decide on its tax and inheritance policy. The Chancellor and the Treasury set out and have a well-documented process for consultation. I, like many, and I said this at committee stage, and I said it in 2004 to the noble Baroness Oakerhoyne. I, like many, think the current inheritance tax system is unfair, particularly when it comes to family homes. I personally would be in favour of inheritance tax being paid on the death of the second or the third survivor, so the Treasury would only suffer a deferral of inheritance tax. But that's not a discussion for this bill. It is a conversation to be had with government. Can I assure the noble lady that I will write to the leader of my own party and will advocate a change in policy to reflect that? I hope the noble lady understands why I don't support this amendment. We debated it in 2005, and I don't believe the arguments have much changed. I do, however, believe that the experience of civil partnerships might have helped the noble lady understand why this amendment could be seen as being hurtful to those people that value their civil partnerships in a different way. Finally, let me say this, and I risk the groans of the House. I have to say that in the intervening years from 2005, I have not noticed a single amendment down in another bill pushing this very point, and there have been plenty of other bills that have come through this House that could have addressed it, including the Carers Bill, which is going through this House as I speak. So I say to the noble lady and those who support this amendment, I hope they will forgive me if I look at this amendment, I look at the intervening 9 years, and I ask the question, why now, and not at any time over the last 9 years? Whatever the reason, this is neither the time nor the place in a for civil partnerships to be used as a means of inheritance tax. And I hope the noble lady can recognise that and will withdraw her amendment.
But I'm sorry to interrupt the noble lord just before he's completed. I think he's already said that the noble Baroness who is proposing this amendment is to some extent motivated because of the need to provide for the financial benefits. May I say that that is not my reason at all. Of course there will be financial benefits available. My reason lies far deeper than that, that these civil partnerships should be available to people of the kind covered by this amendment.
I understand that, but I think therefore you are trying to, the noble lord is trying to break the notion of civil partnerships as we understand it. And I would just say to the noble lord this, the issue of the churches being able to bless civil partnerships is one that I genuinely feel, should be taken on board when considering the noble lords.
My lords, noble lord, Lord Alley, really does raise the standard of debate on this issue. And we really have enjoyed from these benches the contributions that he's made, and we deeply appreciate his commitments and share many of the things that he wants to achieve. But just as he sometimes disagrees with me, I think I'm going to have to slightly disagree with him over this. I don't know what the Church of England will do about services of dedication or blessing in relation to same-sex marriages. It's not entirely clear to me that extending civil partnerships to other dependent relationships might actually increase the likelihood that the Church will be able to move in this area. It really is arguable both ways, and indeed, if you have two people whose lives are really intertwined in a sort of covenantal way, in the way that Baroness Deitch's amendment indicates, they may well want some sort of blessing or dedication upon that interdependence without a sexual relationship. I mean, the issue to me partly is that when civil partnerships were introduced, they were mirrored too much upon marriage. I think many people on these benches were in favour of a legal arrangements to in every way support and protect people whose lives were interdependent. And we had a problem precisely because it was all narrowed down too much to same-sex couples. But I think there's always been a support from these benches for a proper legal arrangement to support people whose lives, for one reason or another, are interdependent. But let me move on from that. I think there is an issue of justice here. We haven't heard the word justice mentioned much, though the noble lord did refer to the situation as being unfair. I think there is an issue of justice here across our society, which, given what the Equal Marriage Bill is trying to achieve, we ought at least to acknowledge the deep issue of justice. But there's also another issue I think hasn't been mentioned at all so far, that in our society now we have an increasingly diverse range of family structures and patterns. And I think allowing some form of legal support between people who find themselves not in marriage, but not wanting to be civil partners in that sense, would have a very deep civilizing effect upon a society. We have a lot of single parents now, and maybe you have a single mother bringing up one child. And that child may not marry, they may find themselves sharing a home as they have done since that child was a baby. And we have increasingly diverse patterns of family life, and something ought to be there to provide support, yes, indeed, blessing in every sense for those who find themselves in that situation. So I hope that the review of civil partnerships will be able to look at the issues which are specified in this amendment, and certainly I, in those terms, would be delighted to support the amendment.
The noble Baroness Lady Deitch, I think, referred to me by name. I believe that the issues that various noble lords have raised, and in particular the Right Reverend Poet has just raised, are incredibly important issues. The diversity of family patterns, the circumstances people find themselves in. And I personally would like to debate and look at particularly the role of carers, the relationship they form with other members of the family, or in the case of the noble Lord Lloyd's example, someone for whom they assume a responsibility because of the way they feel about that person. I would be delighted to be debating that issue, not even in a review, but now. I've waited for a long time because during the civil partnerships debate in your Lordship's chamber, the issue was raised quite frequently. But I do not believe that this is the vehicle for doing that. The Noble Baroness Lady Deach referred to cohabiting. Now, I think if you ask the average person in the street the meaning of the word cohabiting, you'll get a variety of responses. If you ask a counsellor, it's usually somebody who's coming to claim that their benefit in the past has been withdrawn because of the nature of the relationship with somebody in the house. My lords, these are complex issues. They seriously need to be developed, and they need to be developed in the right way and at the right time. I do fear that this is exactly the wrong time. If you ask anyone outside your lordship's house, including a boy of 12 to whom I spoke, this is about marriage and for people who wish to get married because they love each other in a particular way. I hope all noble lords will resist the temptation to tackle the subject of this amendment at the wrong time in the wrong place.
Order. I'm grateful, but we're not seeking to determine it this afternoon. We're merely asking that those experts, presumably dispassionate, presumably people in whom we can all have confidence, should look at this and make the review a little more comprehensive than is at present envisaged. That's all we're asking.
My Lords, can I remind noble lords we're at reports, and if noble lords have already spoken, unless with the permission of the House they're asking a question of somebody, then they shouldn't be speaking again.
My lords, I think the noble lord, in speaking in support of this amendment, has got exactly the right wagon, but is seeking to attach it to the wrong train going to the wrong place. I absolutely agree. This issue must be dealt with, but I do not believe that noble lords who've spoken are actually saying that they think this bill is about anything other than same-sex marriage. Therefore, I hope that noble lords will find another vehicle to attach their wagon to, and as my noble friend Lord Ali said, I too will be their supporter.
Who once at a competitive level drove teams of horses with wagons behind them, could I be allowed to make a very small interjection? My name is not on the order paper. There was no room for it, but I do rise to support my noble friend Lady Deach. I can't add anything to the power of her argument, or indeed I think the impeccable logic that she showed when she advanced. But can I just say that the words equity and decency have already been used in support of this amendment. I would add generosity, I would add compassion, and I would certainly add appropriateness, because, as she has already said, this amendment will seek, or does seek, to correct a prior acknowledged discrimination. It only asks the government to consider within the terms of a review, not to change this bill, but simply to cause the review panel, the review body, to look at this issue. Now, I was not in your Lordship's house when it was debated 8 or 9 years ago, but I do know that I've been told by many whom I respect that there have been many attempts to try to couple this issue onto the appropriate wagon or stagecoach, and it has not been found. Here is an opportunity for us to do that, not to get in the way of the current bill, because I certainly do not intend to do that, and I'm quite sure that my noble friend does not either. I think the time is right for the review, and I would therefore vote, if she puts it to the vote, in favour of this amendment.
My Lords, when discussing previous amendments, both at committee and at report stage, much has been said of teachers being required to teach the law of the land. But I do not envy their task. as the law regarding different personal relationships has become rather complex. And I think that is best exhibited by the discussion, just the exchange just now between the noble and learned Lord, Lord Lloyd of Berwick, and the noble Lord, Lord Alley, about whether or not civil partnerships are a sexual union. And I would just add that I have friends who have had civil partnerships and who have gone to the registry office and been separated and been asked questions to ensure that in fact it was a sexual relationship. So although I do think these matters need clarifying, I shall state now what my understanding of the situation is. Opposite-sex marriage is understood to be a sexual relationship because it can be ended by annulment and also by divorce on the grounds of adultery with the opposite sex. Civil partnerships are same-sex and, for the reason I've just outlined, treated as sexual, but there is also no annulment. Platonic friends can marry who are either opposite sexes or the same sex, but the lack of annulment for same-sex marriage may lead this institution to develop very differently. And I agree that the Right Reverend Prelate states in reality what the position is in modern-day Britain. The demographics of our country are changing rapidly. In the 2011 census, 29% of UK households are single-person households, not single-parent households, single-person households. The fact that two people can live more cheaply than one is becoming increasingly important with rising living costs, poor return on private pensions and high housing costs. We could end up seeing two people who want to say to their best friend that they share a house with, "You can depend on me. I am the first port of call." A commitment that is not merely financial, about inheritance tax or being one household for the purpose of benefits. And with an ageing population, the government should be pleased if this kind of development occurred under the same-sex marriage bill. Of course, that analysis means that carers outlined in this amendment can marry already and gain the financial benefits outlined. If we were to see such a cultural development, the injustice to family members will be even more apparent. One might, my lords, even see deeply religious people of the same sex who currently oppose the bill getting married if same-sex marriage develops in the way I've outlined in our culture. That kind of development might even make it easier to be used mischievously for immigration purposes. We just don't know. This amendment, my lords, would give clarity and direction to this review. The review will give the government time that it has not had with such a speedy legislative process to look at the whole legal relationship landscape. I noted the comments of the noble Lord, Lord Alley, that it feels wrong to him. It's very subjective, very postmodern in my view comment, but it feels wrong to me to close down the area of discussion that this review would enable. And I do believe that if it was so wrong to put this wagon on a coach or wagon on the horses here, the amendment wouldn't have been allowed on the face of this particular piece of legislation. I shall be supporting this amendment as it would be unjust that everyone, and I mean everyone except family members, will be able under our law to promise a lifelong non-sexual commitment or dependency.
My Lords, well, I rise to oppose these amendments because I really do think it's disingenuous of those who move it and support it to suggest that this is about simply being hard-hearted if you don't see the purpose of it. And I just want to say I'm rather shocked. I'm shocked to hear lawyers who spent their lives in the law not recognising the implications of extending what is essentially about marriage or commitments to a sexual relationship, because that's what it's about. Imagining that a civil partnership between a father and a daughter or a brother and a sister should be blessed, it's even being suggested, because it may come to that because of the great multiple of relationships there are. I can't believe that I'm hearing senior lawyers endorsing this, and I can only believe it's because they really want to dilute the purposes of what civil partnerships are about.
On a point of order, I don't think anyone has suggested that fathers and daughters get married or brothers and sisters. This is about asking the government to include the position of carers in an inquiry and siblings. That's all.
And the point of my opposing that, of it even being considered in a review, is because we know that it will continue this debate that has taken place in this House over the past weeks and which has sought to undermine this bill, whose purposes are to end discrimination against gay people. And it has been, this bill is about civil rights. That's what it's about. And the idea, I'm hearing someone on the bishop's benches suggesting that this is all going to be about recognising important relationships which are somehow as on the same par as a couple who choose to be with each other because of their sexual attraction to each other, their love for each other and their desire to stay together. I can't imagine that the church would think that was a good thing. And I can't imagine it, please. I can't imagine it because we know that this is about choosing a partner whom you intend being with. It's about that human yearning that there is amongst human beings to choose someone as your love, to be with that beloved and to share your life with them. That is very different from the relationships between brothers and sisters and fathers and daughters. Think of the implications of a civil partnership being extended to a father and daughter. Are we going to put an age limit on it? Is a father going to be able to enter into such a civil partnership with his 22-year-old daughter or his 18-year-old daughter? It really is something that we have to be conscious of. This is yet another way of trying to scupper this bill. And the reason why is to continue the debate, is to continue the argument long after this bill has been passed. So I really urge everybody who cares about making sure that there is an end to discrimination in this nation towards gay people, that this means that you have to vote with those who are against these amendments.
Speak again, but I think given the way in which the noble...
Order. As my noble friend pointed out, order. As my noble friend pointed out earlier on the debate, we are at report stage, so the only basis on which we are allowed to speak twice is if we are asking a specific question of the person who is speaking. So the Right Reverend Prelate has actually already spoken in this debate.
The guideline is that the member is allowed to explain himself on an important point. That's what the guidelines say, and that's all I'm wishing to do. I believe that is what the guidance says, and I want to make it clear that I'm not wishing to extend civil partnerships as they are now to the sorts of relationships which are in this amendment. Clearly, if these sorts of relationships, family relationships, carer relationships, come into civil partnership, it will change the nature of a civil partnership. But I understand that to be within the terms of the review.
Can I, in response, very briefly, in response to the noble prelate, say that I have listened over these weeks to people of strong religious faith saying that this would undermine, that to extend marriage would undermine a social institution. What would undermine the social institution of committed sexual relationships more than the idea of fathers and daughters entering into some sort of contractual partnership? If you're caring about social institutions, that seems to me a good way of undermining them.
My noble friend has come to the view that coming to the view that a review will come to a certain conclusion. We don't know what conclusion that review will come to, and the question surely is this: that we know that under Section 13 Clause 13 of the bill. And this was a fairly late addition by the government, that there will be a review of civil partnership. We also know under Clause 2 that it does not prevent the review from also dealing with other matters related to civil partnership. Are those who are against this amendment suggesting that the review should be stopped from dealing with these matters? Part of our problem as politicians or members of this House, perhaps who do not consider themselves politicians, is that we face this disconnect between what we are doing here and public opinion. And in my own judgment, having served 30 years in the other place, that public opinion would consider this an important matter when faced with the sort of examples that were given by Lord Lloyd, when looking at the example given by the noble Baroness Hooper, they would say that there is a certain injustice in that matter, and we remove ourselves from this view of justice and public opinion if we say that it cannot be included within the review, that the review, when it takes place, will be able to look at this, or it may say that it is not properly within its terms. I don't know what the government considered to be the specific terms of the review, whether they will say that will define what the review can and cannot view. But surely, on the face of it, the review will be able to deal with such matters, and they may reject them. But I think at least public opinion, and most of us would say that these are important matters, that they deserve to be dealt with. They may be dealt with by the review, which may come down either to say it is not properly within their purview, or say that it is not something which should be dealt with at all. But in my view, it is proper for them, under the terms of that clause, to deal with it. And I look to the government and to the noble minister in replying to say, in terms, does the government recognise that this is a problem? Does the government recognise that the examples given by the noble Lord Lloyd and others do refer to something which is considered unjust by the great number of great people, public opinion in this country? And if so, even if the government will try to remove this from the review, will the government deal with it in some other appropriate way?
I've listened to and taken part in these debates ever since Noble Baroness O'Coin first raised them in 2005 during her then opposition to civil partnership. And there remains one point which is fundamental to this discussion, which has never been answered properly by those people who have advanced, such as Noble Baroness Deach, who have advanced them. The rights and responsibilities of adults who voluntarily enter into relationships with other people are wholly different from the rights and responsibilities of family members, people who are born into the same family. If we were to treat them in the same way, as she intends in her amendment, it is wholly possible that a member of a family could find themselves under an obligation to a family member to enter into a relationship, in particular to preserve the right of the family to property. I think that sets up some potentially damaging and ugly relationships within families. I think that is a consequence of what she is proposing, which she really would not like to see come to pass. And to answer the noble Lord Cormack, I don't think that potential should enter into law, and I don't think it should form even part of any review. And therefore, I wish today to make that statement as strongly as I possibly can, and I will vote against this amendment, and I will do so in the knowledge that there are people who will support me in supporting carers in a whole variety of different ways which are wholly appropriate and far better than this.
My Lords, I find this a much more difficult issue, I think, than all noble lords who have spoken so far. I think there are very strong arguments indeed on both sides of the case, and I very much hope that noble lords on each side would recognise that. My reason for speaking is that I spoke at committee stage in favour of this amendment. And I think I am in a very unusual position in that the debates that we've had in committee on this issue have actually caused me to change my mind. And the reason why I have changed my mind is because I think there is a very real injustice that is done to the people for whom Baroness Deitch has spoken, but I am not persuaded that this is an appropriate vehicle by which this injustice should be addressed. And the reason why the noble and learned Lord Lloyd of Berwick says sotto voce, why not? Well, I'll tell him why not, because I think that the purpose of the review is very simple indeed. The purpose of the review is to assess whether or not the existing civil partnership regime, which is part of the law of the land, continues to serve any useful purpose now that we will be having same-sex marriage. That, as I understand it, is the purpose of the review. It's a very narrow purpose, and I don't think it's appropriate that a review should consider whether or not civil partnership should be used as a means to address a very real injustice that, if it is to be addressed, should be addressed through the taxation system and through other means. That's why I've changed my mind, and that's why I much regret that I'm unable to support Baroness Deitch.
Well done. My Lords, this amendment would seek to would seek to extend the civil partnership review to include unpaid carers and family members who live together. I'm just going to read, because of the discussion that took place between my noble friend Baroness Kennedy and the Right Reverend Prelate. The amendment actually says unpaid carers and those they care for, and family members who share a house, provided they have cohabited for 5 years or more and are over the age of 18. My Lords, if that doesn't mean fathers, daughters, sisters, brothers, I'm not actually quite sure what it does mean. So I think my noble friend did have a point in her indignation about that matter. I think the problem that is before the House and has been very adequately explained by various noble lords is that this is an issue about legitimate support for carers and the protection of people, sisters and brothers, growing old together, sharing a home, who require a new regime which protects their interests in their home and all of the other things. My Lords, that is to do with carers, it is to do with tax, it is to do with inheritance, it is to do with all the compassion and other issues that noble lords have mentioned. But in my Lords, it is not appropriate to use those words in terms of pulling up ladders and so on in this bill. This review is about civil partnerships as explained by the noble Lord Panic. So I'm not going to read my note out because he said it much more adequately than I could do. And I think the noble lady...
Section 1A, I'm sorry, but it is proposed by the noble mover of this that it's the case for amending the criteria in the Civil Partnership Act. Is my noble friend suggesting that the criteria themselves should not be amended in any way? And what would she suggest should be the criteria employed by the review? Will we seek to limit what they can review?
I think the noble Lord Panic very adequately and concisely and accurately explained exactly what this review is about. But I think the point is that, of course, these are legitimate claims that the noble lady has explained to us. And I think my noble friend Lord Ali said, the last time I heard the noble lady speak with such passion about these issues, apart from during committee stage, was indeed during the Civil Partnerships Bill. And in the meantime, there have been at least 2 Carers Acts that I can recall that my own government put forward. There was the Free Personal Care Bill. There have been numerous discussions about finances, about inheritance tax. Although we may not discuss those matters necessarily in this House,
to conclusion. Certainly there are plenty of members of Parliament in the other place who can, could and indeed could put down amendments. So I would be more sympathetic perhaps if I thought those things had happened, but they have not happened. So I think my noble friend Baroness Kennedy is right when she says that you have to question the purpose of this when all of those opportunities have been missed. So certainly we would ask the noble lady not to move this amendment, but if she does, I for one will be voting against it.
My Lords, can I start by thanking the noble lady Baroness Deitch for moving amendment, indeed to the others who have put their names to it, which would amend Clause 14 of the Bill, under which the Secretary of State will arrange for the operation and future of Civil Partnership Act 2004 in England and Wales to be reviewed. And the amendment, therefore, to require the terms of the review to be extended to consider first the case for enabling carers and family members who live together to register civil partnerships, and secondly, the case for creating a new legal institution to give carers and family members the same benefits as couples in a civil partnership. And, my Lords, I think I recognise, as indeed we did in the debate on committee, this has been a debate where many passions have been, views have been expressed very passionately. I particularly listened to my noble friend Baroness Hooper, who, from her own personal circumstances, made an important contribution to this debate. I think I also share the point made by the noble lady Baroness Thornton that in many respects the issues which have been raised about inheritance or about the rights to have a say, for example, in funeral arrangements or related issues such as that are issues in their own right. And I'll say more about that as to whether there has indeed been a clamour for them. But my principal position, my Lords, will be that this is not appropriate for a review of civil partnerships. My Lords, first there is the issue in the nature and purpose of civil partnerships. They were designed to provide rights and responsibilities, and to use the words of the noble Lord Alley, akin to those of marriage for same-sex couples. And I did note that the Right Reverend Prelate, the Bishop of Chester, thought that the possibly mirrored marriage too much. I think that was he said the view of at the time when they were brought in. But they were done so because they were to extend or to provide that. These rights and responsibilities, because at that time, because under the Civil Partnerships Act, people were unable to marry because they were of the same sex. And because of the fact that they were akin, they had civil partnerships have a formal means of entry, they have a formal means of exit. They imported the prohibited degrees of affinity, which parallel those in marriage law. They have the similar rules governing deathbed civil partnerships, and obviously to financial and property arrangements. And therefore, my Lords, I believe seeking the extension of civil partnerships to family members is tantamount somehow to seeking to allow marriage between close family members within the prohibited degree of affinity. And in this respect, we have decided as a society it is undesirable for close family members such as siblings or parent and child to marry. And I accept that the noble and learned lady, Baroness Butler-Sloss, said that, of course, I mean, the issue of procreation doesn't always arise. And, of course, that's obviously clear. In many cases, the issues of procreation don't arise in marriages between a man and a woman if they're both, for example, pensioners. Nevertheless, they can still have great companionship that they bring to each other. No one questions that that devalues that marriage in any way, or the concept of marriage in any way. But, my Lords, we would not think it right for even a brother and sister over the age of 60 to marry, because there's just something about our society that over generations has said that that is just not appropriate and not right. And even where procreation is impossible, my Lords, we believe that is not something that should happen. Now, my noble friend Baroness Berridge did say that she had heard a situation where couples have been separated and questioned about a possible sexual relationship. I rather suspect that the reference was to a couple being separated before they can marry is in part, in certain cases, intended for the prevention of sham civil partnerships. A couple have to have a face-to-face meeting with the registrar when the registrar takes notice of the marriage, and the registrar needs to ensure him or herself that they are indeed a genuine couple and they do actually know each other, and that this is not a sham civil partnership for immigration purposes. But it is not to ensure that there is a sexual relationship between them. My Lords, as for carers and those they care for, there is, of course, as the noble Lord Alley pointed out, nothing in general to prevent them from marrying or entering into a civil partnership at the present time. And the noble and learned Lord Lloyd of Berwick referred again to circumstances which I'm sure, in personal terms, is a very real relationship of the man who was paralysed after a riding accident and a younger carer. But as I understand, I think we said in the earlier debate, the younger carer was male as well. There is nothing under the law as it stands at present as to why they cannot enter into a civil partnership. It would be wholly wrong and inappropriate to speculate why they haven't. But there may be many cases of carers up and down the country where that civil partnership has not proceeded because they just do not feel that is right in terms of the way civil partnerships have developed, or indeed the origins of them. And as was discussed during the debate in this matter in committee, the change would mean that couples would have to dissolve the civil partnership if either party wanted to marry or enter into a civil partnership with someone else from out with their family whom they loved, with all the financial implications, legal and practical difficulties involved in a dissolution. And that's why I believe that shoehorning such relationships into the existing regime of civil partnerships won't work. Now, I listened carefully to the noble lady Baroness Deitch, and she said, well, perhaps it could be ended by a letter, or simply by someone going off and marrying someone else. Whereas I think that fails really to understand what Parliament legislated for when it established the institution of civil partnership. It was an institution which had a very formal means of entering into it and a very formal means of leaving it. I rather suspect what the noble lady, and I understand where she was coming from and why she was arguing that case, but what she was actually arguing for wasn't really a civil partnership at all. And I think, again, that's why we do not believe this is right, to take place in the review of the nature which we propose. I accept too that in the case of this debate, there has not been as much said about the financial benefits of inheritance tax. I think, and I salute those who argued for the case for the extension of the review at committee stage, and quite openly and quite frankly talked about inheritance tax things. I think that was a commendable frankness. But, my lords, I don't think that treating civil partnerships as a vehicle for gaining tax or property benefits is in fact appropriate. Indeed, I think it's disrespectful for those who enter into civil partnerships for the reasons that there's that mutual love, or, be it sexual or desire for companionship. And if one thinks about it for a moment, I mean, the noble lady Baroness Kennedy of the Shaws put it very starkly about fathers and daughters, but as the noble lady Baroness Thornton pointed out, in the terms of this amendment, that is indeed possible in terms of civil partnerships. But there's other situations that could arise, which I think do underline that civil partnerships aren't really intended for families. What do you do with the following of two siblings caring for a mother? In that instance, which of the two forms a civil partnership with the mother? What about two sisters and a brother living together? In what circumstances, who would form a civil partnership with whom? Imagine the contentiousness of the choice, or the sense of rejection, if one sibling was preferred over the other. Or an elderly father living with two sons. Who would he choose to form a civil partnership? Well, as I just illustrate some of these, just say it is not appropriate. And if one looks too at the other issue of the position of carers and family members, should benefits equivalent to those enjoyed by civil partnerships be made available to carers and other family members? And the noble Lord Anderson said, I think he did ask, was there a clamour for it? Well, as I've got to say, there is no correspondence filling up the in trays of my ministerial colleagues. And I rather suspect from the comments made by the noble lady Baroness Thornton, nor those who were in ministerial office before the present administration on this issue. And I'm advised that since 2004, we're aware of this issue being raised only once during debates on the finance bill in the other place. I appreciate in this House we cannot raise the finance bill is not subject to amendment, but my information is that there was only once there was an amendment made by the Right Honourable Member for Birkenhead, Mr Frank Fields, to the 2008-2009 finance bill. But other than that, it doesn't seem to have been an issue that has been raised by way of amendment. And also, too, my lords, the Carers UK, in a parliamentary briefing which I understand they didn't circulate to parliamentarians, but I'm happy to make available and put in the library. They said in 2004 we reviewed an amendment to the Civil Partnerships Act, or bill it would be, as it was passing through the House of Lords, that carers should also be able to form a civil partnership. At that time we foresaw a number of complex and difficult problems with this approach and did not feel it was the right way to solve the challenges that carers face. Our view remains the same in 2013. Now, as my noble friend Baroness Barker said, there are a host of other issues with regard to carers indeed some of which we are addressing in the Carers Bill currently before your Lordship's House, but I don't believe the way to tackle it is as proposed in this particular amendment. My Lords, finally, can I say the issue is whether these matters should properly be included in the civil partnership review. And I heard, and I think it was argument that was made with some, I could see prima facie some logic that we're going to have a review. Why don't you put all this into a review? But, my Lords, as I said before, I think what was being proposed is indeed a fundamental change, something that is very different from civil partnerships as they were established and as have they developed. I think that point was very well made by the noble Lord Pannick, who said that this review is into the existing civil partnership regime as a consequence of the provisions of this particular bill. Indeed, whether indeed there is a need for the institution of civil partnerships following this bill, or indeed whether civil partnerships should be extended to opposite-sex couples. And therefore, my Lords, I think that is the proper remit of this particular review. I do accept there are other issues which have been very properly aired, and there are other different pieces of legislation at different times where these can be followed up with regard to specific rights and responsibilities. But, my Lords, I think transforming civil partnerships from a legal union of a committed and loving couple into something which is somewhat very different in its nature, or indeed was described simply as a contract which you can get out of by writing a letter or marrying something else, is not really what the purpose of this review is. And therefore, whilst I think it's important we've had this debate, I would ask the noble lady to withdraw her amendment.
Yeah. My Lords, I think there have been a number of misunderstandings in the comments that people have made. I was not privileged to be a member of this House in 2004, but I do know that the House did then pass an amendment that would have included siblings and carers within civil partnership. I myself have raised it, and I've just checked very briefly on my iPad, in 2008, 2009 and 2012, and in some of those years more than once. I looked at the Carers Bill and I did not see a hook on which to hang it. But the point is, the amendment that your Lordship passed in 2004 was rejected in the other place, and there are complications. That's why an inquiry is so particularly apt, an inquiry. Civil partnerships were invented in 2004. Another form of union could be invented now. It's not right to jump to the conclusion that some noble lords have, that this means that family members will get married or have a civil partnership. Not at all. It's an inquiry. There is, of course, no question of incest, and anyway, there's no prohibition right now on siblings living together, and I don't believe the police go knocking on their door to see whether there is incest or not. Some carers do get married, actually. We've all read of elderly gentlemen marrying much younger ladies who care for them, quite often to the dismay of the family who are worried about inheritance. Inventing some new sort of covenant or contract would probably be much more acceptable, but it will, of course, be a question of choice. We're not talking about marriage or civil partnership or incest. We're talking, my lords, about an inquiry. Now that civil partnership is up to be examined and the wording is broad enough to allow this. No matter what the hopes may be expressed by the noble Lord Ali for religious marriage in the future or the future of civil partnerships, I can't find it in my heart to stand in the way of a study of equality. Just because something else may happen in the future, how can we stand in the way of an inquiry into equality? And as the noble Lord Pannick knows, because he was counsel in the case, Strasbourg said that the treatment of the sisters was discriminatory, but it could be accepted because in this country there was this rigid division between marriage and all other unions which no longer exists. So it is discriminatory. How can we say, let's not look at it, this is not the right vehicle? That's not the way that this House normally treats questions of equality and justice. And it's not just money grubbing or financial. I listed many of the other advantages of marriage and civil partnership, only a few of which are financial. Moreover, same-sex marriage is likely to come about long before this inquiry reaches any sort of conclusion, and therefore the two will not impact on each other. We need a debate on this, as the noble lady, Lady Farrington, said. We need a debate. Here is the very vehicle for it. Lord Wallace was assuming that there would be no choice in the matter. People would be forced into these unions. Not at all. I will keep repeating it because it seems to be misunderstood. An inquiry into an existing situation of discrimination. That's all that this amendment calls for. They don't all have to be treated in the same way. One is not suggesting that an inquiry, even if it went the way that I would hope, would end up saying that sisters and fathers and children should be treated as if they were civil partners. That is just something to be seen in the future. And although I've said it's not just about finance or property, let us not overlook the fact that many a marriage, certainly in the past, was most definitely about property. But I'm not suggesting that is the case today, nor that this is about money. There are various other statutes, as learned members of this House will well know, that deal with tax and inheritance with people who live together. I don't think that a matter of justice is ever inappropriate. We have talked about carers for years and years since I have been here. This is a chance to do something for them in an inquiry. I am getting letters from sisters. I don't know what to write back to them if this House rejects this opportunity, which may not come up again for years. How can I write to them and say, the House was presented with your situation and decided that it wasn't appropriate even to look into it? If this House sees discrimination, it should allow it to be looked at in an inquiry. That's all I'm asking for, and therefore I would test the opinion of the House.
The question is that Amendment 94 be agreed to. As many of that opinion will say content. The contrary, not content. Not content. I think the not contents have it. Clear the bar. My Lords, the question is that Amendment 94 be agreed to. As many as of that opinion will say content. The contrary, not content. The contents will go to the right by the throne, the not contents to the left by the bar. question is...
Order.
The question is that Amendment 94 be agreed to. My Lords, there have voted contents 89, not contents 267. So the not contents have it.
The statement. My Lords, although we are 2 or 3 minutes ahead of time, this may be a convenient moment to take the statement, and I'm extremely pleased to see my colleague coming in, and I hope that on which note, my Lords, I beg to move that further consideration on report be now adjourned. In moving this motion, may I suggest that the report stage begin again not before, my maths is not very good, 8:12 p.m.
The question is that further consideration on report be now adjourned. As many as that opinion will say content. Contrary, not content. The contents have it.
Thank you, Jim. Thank you, James.
The opposition put their question.
With your Lordship's permission, I propose to repeat a statement made by my Right Honourable friend, the Secretary of State for Business, Innovation and Skills, made in another place. Today, I have laid a report in Parliament announcing that the Government has decided to proceed with the flotation of Royal Mail shares on the London Stock Exchange via an initial public offering. A sale will initiate the final stage of the Government's postal sector reforms. The overarching objective of these is to secure the universal postal service. The 6 days a week service at uniform and affordable prices to all 29 million addresses in the UK, which is vital to the UK economy. Over 4 years ago, the independent review of the postal sector, led by Richard Hooper, concluded that the universal service was under threat. The previous government accepted the review's package of 3 main recommendations, but the bill to implement them, which would have permitted a minority sale of Royal Mail shares, was withdrawn. In 2010, Richard Hooper's updated report confirmed his initial findings and that a package of measures was needed to secure the universal service. Through the Postal Services Act 2011, we have implemented 2 elements of that package by establishing Ofcom as the postal regulator and taking on Royal Mail's historic pension deficit. As set out in today's report, we will now implement the 3rd and final element of the Hooper recommendations by selling shares through an IPO in this financial year. We will retain flexibility around the size of stake to be sold, as this will be influenced by market conditions, investor demand, and our objective to ensure overall value for money for the taxpayer. And it is our intention to dispose of a majority stake, taking into account shares sold and those allocated to employees. The IPO will include a retail offer to enable members of the public to buy shares on the same terms as the big institutional investors. At the time of the IPO, the government will allocate 10% of the shares to an employee share scheme. These shares will be free to eligible employees, recognising that many might otherwise find them unaffordable. And I want to strengthen employee engagement by ensuring that employees own a real stake in the business. Employees must retain their shares for at least 3 years, giving longevity to the scheme. Our scheme will be the biggest employee share scheme of any major privatisation for nearly 30 years. Eligible employees will also receive priority in allocation if they purchase shares in the retail offer. I would like to reassure employees that ownership change does not trigger any change in their terms and conditions. The CWU will continue to be their recognised representative, and employees' pensions will continue to be governed by the trustees. As part of a 3-year agreement, Royal Mail is also prepared to give assurances on the continuation of a predominantly full-time workforce, a commitment to provide and enhance existing services to customers using the current workforce with no change to the current structure of the company in relation to these services, and no additional outsourcing of services. Royal Mail is now profitable, and its overall financial position has improved, and this is partly due to the government's actions so far. But considerable credit is due to the management and the workforce, which has implemented a modernisation plan. The challenge now is to maintain this positive momentum. In recent history, Royal Mail's core UK mails business has swung between profit and loss. In the 12 years since 2001, it suffered losses in 5 of those years, and over 50,000 jobs have been lost. Resting on the current levels of progress is not enough. Under public ownership, there is simply not the freedom to raise capital in the markets. A share sale will not only give Royal Mail commercial disciplines, it will also give Royal Mail future access to private capital, enabling the company to continue modernising and to take advantage of market opportunities, such as the growth in online shopping, building on its success in parcels and logistics. Recent estimates indicate that this market is worth £76 billion in the UK. There are various myths that need to be rebutted. Contrary to what is being claimed, after a sale, Royal Mail will still be the UK's universal service provider. This includes services to urban and rural areas and free services for the blind. Only an affirmative resolution in Parliament can change these minimum requirements. Free services for the armed forces are entirely independent of ownership, and Royal Mail is fully reimbursed for these services by the Ministry of Defence. Ofcom's primary duty is to secure the provision of the universal service. It also has duties to promote competition where that benefits consumers. However, and let me make this absolutely clear, should the two duties be in conflict, it is the universal service that takes precedence. In March, Ofcom published a statement on its approach to end-to-end competition, making clear that should a threat to the universal service arise from such competition, it has the powers to take any necessary action. Whilst Ofcom is clearly the most appropriate body to assess and react to such threats to the universal service, as a safeguard, the government has retained powers to direct Ofcom with respect to certain regulatory levers, such as reviewing the financial burden of the universal service and taking mitigating action to ensure that the universal service is maintained. I also confirm that Post Office Limited will remain publicly owned, although we will continue to explore mutualisation. This government has committed that there will be no further closure programme. Royal Mail and Post Office Limited signed a 10-year commercial agreement in 2012 to ensure that they continue to be strong business partners. The government's decision on a sale is the practical, logical and commercial decision designed to put Royal Mail's future onto a long-term sustainable basis. It is consistent with European developments where privatised operators in Austria, Germany and Belgium have profit margins far higher than Royal Mail and have continued to provide high-quality services. Now the time has come for government to step back from Royal Mail and allow its management to focus wholeheartedly on growing the business and planning for the future. It is now time for employees to hold a stake in the company and share in its success. This government will give Royal Mail the real commercial freedom that it has needed for a long time, and I commend this statement to the House.
My Lords, I thank the Minister for his statement. And first of all, perhaps I should declare an interest as a former Joint General Secretary of the Communication Workers Union and many, many moons ago a one-time apprentice of when it was called the GPO. We opposed the government's privatisation of Royal Mail during the passage of the Postal Services Act 2011, and we oppose it today. Maintaining Royal Mail in public ownership gives the taxpayer an ongoing direct interest in the maintenance of universal postal services in this country, helps safeguard the vital link that the Royal Mail has with the Post Office, and ensures that the taxpayer gets to share in the upside of modernisation and the increased profits that Royal Mail delivers. Despite that, the government have pressed on regardless with this sale, and they failed adequately to justify why they must sell now. On one side, there is an unusual coalition against this move, the opposition, the Conservative supporting Bow Group, which described this move as poisonous, Royal Mail employees, represented of course by the CWU, and the National Federation of Sub-Postmasters. Indeed, the Minister of State for Department for Business Innovation and Skills, the Right Honourable Member for Sevenoaks, Michael Fallon, wrote to a constituent in 2009 saying that he too was opposed. On the other side, there is the government, which now includes the Minister of State. Government are ignoring the huge changes that they acknowledge that have taken place since the passage of the Act. Chief among them is the more than doubling of Royal Mail profits to $403 million, significant progress on the modernisation programme, which calls into question the future assertions that there is no prospect of Royal Mail being self-financing in the future. I noted carefully the Minister's reference to the package that Hooper recommended, and it's true that Ofcom and the pensions thing were part of the package, but he didn't actually recommend full-scale privatisation. He did recommend an injection of private capital. There are a number of concerns that we have. Government rushing to sell the business without making the case as to why the sale of shares in Royal Mail through an initial public offering must be carried out now, nor have they illustrated how a sale will deliver maximum value for the taxpayer. Failed to show the climate for an IPO now is a good one, or how much capital it would result in being injected into Royal Mail business. Instead, they're pressing ahead with a fire sale this financial year in a desperate attempt to cover the gaping hole in George Osborne's failed economic plans. Further points that the government have failed to address the timing. No evidence has been of the sale. No evidence has been provided to demonstrate that the government will secure best value for money for the taxpayer from a sale at this point in the Parliament. Additional years of profitability may well increase the sale value in future years. There's unresolved competition issues, legitimate questions regarding the fairness of competition posed to Royal Mail by other postal operators, given other postal service operators are not subject by the regulator to the same high performance and service quality standards as the Royal Mail, have not been resolved. The different service requirements required of Royal Mail by the regulator arguably put the Royal Mail at a competitive disadvantage compared to its competitors. The funding needs of the business. To what extent will Royal Mail be able to raise capital from other sources to meet its funding needs if it enters into private ownership? The impact on the post office network. In January 2012, a 10-year deal was entered into between the Royal Mail and the Post Office, under which Royal Mail will continue to use the Post Office to deliver a range of Royal Mail services. However, there are no guarantees this arrangement will continue on expiry of the agreement. The impact on consumers and businesses. Royal Mail assets could be sold off, generating large short-term profits for the private company, with higher value urban centres sold off to be replaced by distant depots, making it worse for the consumer. What assurances can be given that regulation will be sufficient to protect against consumers being ripped off in the same way as they have been following transport and energy privatisations? Postcode accesses for business. As part of the proposed sale, it has been reported that the Royal Mail maintenance of post office codes is up for sale with a wider negative impact on business. I welcome the Minister's response on this point. And on employee ownership, well, we welcome the 10% of shares for employee, but if it's such a good idea, given that the government is proposing to fully mutualise the post office, why is the share being given to Royal Mail employees not larger? I also have, to conclude, the following questions for the Secretary of State. First, Royal Mail faces competition from other postal service operators who are not, as I've said, subject to the same high performance and service quality standards as it is, putting it at a competitive disadvantage. How will this not depress the sale price, and what will he do about it? Secondly, this cannot be allowed to put the post office at risk. What guarantees can he give that a privately owned Royal Mail, as I've said, will renew the agreement under which the Post Office provides Royal Mail products, which is essential to the Post Office future? And he said that the universal service obligation is fully protected, that it takes precedent, And if things start to go wrong, then Ofcom will renew the financial burden. What exactly does he mean by that phrase, renew the financial burden? We think this is an ill thought out process which will not benefit the taxpayer, will not benefit the consumer or the employers, and believe that the government should think again.
Well, my lords, I'm sorry that the noble Lord Young of Norwood Green takes such a negative view of this privatisation programme with Royal Mail. I hardly agreed with any of the points that he made, and I will attempt to address them as best as I can. The first point to make is in terms of the rationale for sale. I should reiterate again that the government's overarching objective is to protect the universal postal service. That's one of the key aims of this privatisation. And to do this, the Royal Mail needs future access to private capital and commercial disciplines to be able to continue its modernisation programme and seize the opportunities for growth. And it's important, as I mentioned earlier, to focus on the market for online shopping. And for example, it's absolutely vital that the Royal Mail is able to change its technology to upgrade its sorting technology and improve the way in which the tracking of parcels gets through the system, and also updates on methods of delivery. And there are 40,000 vehicles, for example, through Royal Mail. So that there are many, many good reasons as to why it's necessary to raise this particular money. In terms of doing it through a private sale, as opposed to raising it through public money, the issue there is that if it remained in public ownership, then the competition would be with the education service and the health service in terms of fighting for limited resources. So again, there's a very good reason why there's a move to private funds. The second point that was made was in terms of the so-called fire sale. And as my right honourable friend, the Secretary of State for Business Innovation and Skills, said in the other place just today, it must be the longest fire sale in history. And I would at this stage like to pay tribute to the previous government, and the noble Lord Mandelson is in his place, in terms of what he did to start the process of privatisation of Royal Mail. And that was a process that he started, and we are completing. So it's not a fire sale. It has been long in the planning, and today's announcement follows more than 2 years of preparation since Parliament passed the Postal Services Act. It is a commercial transaction, and the government will follow normal commercial practices in setting the share price and delivering value for money. It's also the point that, as I mentioned earlier, Deutsche Bank and Austria Post, Deutsche Post and Austria Post have experienced some very good profits as a result of their successful privatisation programmes, and we do not want to be behind the curve. So that is another good reason for moving to privatisation. In terms of employee ownership, I'm delighted to reconfirm that employees will be gaining 10% of shares free. On top of that, of course, with the special allocation process, they have got the opportunity to purchase shares on top of that. So we believe that it's a very good deal for employees, and the objective is to tie employees in to and align them to the strategy of the company. So overall, as I say, I do not agree with the noble Lord Young in terms of all his queries, and I do believe that we're on the right track.
My Lords, my noble friend referred to this as being the biggest employee share scheme for almost 30 years as a privatisation. And I think that last one was in fact National Freight Corporation, which I did myself. And if I may remind my noble friend, the reaction from Labour benches and from the unions was exactly the same on the NFC as it is today on the Post Office, although now I don't think anyone would remotely argue against NFC. But may I put this to my noble friend? while I congratulate the government on this decision, doesn't he feel it was a great pity that this decision wasn't taken 25 or 30 years ago? Does he realise that if it had been, then the Royal Mail might at this stage be leading in the international carriage of parcels, rather than leaving it to the German post office to take that advantage? So I think it is an enormous lesson for us, and may I urge my noble friend that privatisation might come back onto the agenda as far as this government is concerned, and there are a number of other companies that could be privatised. I think in particular of BBC Worldwide, and that would be to the benefit of the public and to the people who are working for them.
My Lords, can I join?
I thank my noble friend for that comment, and to hear that he was harking back 25 years, and he makes an extremely good point. Hindsight is very nice. I can't remember exactly where we were with Royal Mail 25 years ago, but I'm delighted to say that we are where we are at the moment, and I do believe that the conditions are right to privatise. In that, the Chief Executive of the Royal Mail has done, I believe, an excellent job in turning around Royal Mail with profits of over 400 million. And the climate and the time is right, and I believe that there is an appetite. Let's see what investors think about that.
Can I say to the Minister that some of us on this side of the House who were supportive of a minority shareholding were so because we wanted to see an improvement in the quality of management, and frankly we had despaired in many instances of that ever happening, because it takes a particular skill for a manager to run a monopoly in a capitalist system and run it at a loss. And that's what, over a number of years, the managers of the Post Office succeeded in doing. Now, the fact is that circumstances have changed. They have changed because the nettle of the parcels has been grasped by the Post Office in quite a spectacular way. But at the same time as that, we are seeing now the diminution in the volume of postal mail day by day being required to be delivered. But the fact is, the length of the walk of the final mile that the postmen have to go is exactly the same length, regardless of the number of letters they have to carry. And therefore, this is the most vulnerable part of the operation. And it's not the parcels that will be the problem, it will be the cost of delivering letters. And the assurance that the Minister has given us this evening, frankly, doesn't in any way give us comfort, because all we can see is a weakening of the Universal Postal Service when it becomes too expensive to subsidise under the economics of this flawed scheme.
Well, you may not be surprised to hear that I do not agree with your assessment. And it is true, however, that since 2006, the fall in letter volumes has been as much as 25%. So the market is changing, and we need to keep ahead of the market. And I would remind the House again that Germany and Belgium are ahead of the game. The injection of private capital into Royal Mail will help with the change, but there is a double benefit in that through legislation, the universal offering remains strong. It is set in stone, and that is a very important point to make.
My Lords, as the noble Lord will be aware, from the Liberal Democrat benches, we are very much in support of this, and indeed from the Liberal Democrat element in the coalition, starting with Ed Davey, who was, of course, the minister responsible for this in the early days of the coalition. We're absolutely delighted to see the culmination now. And it's, as the noble Lord rightly said, it's very nice to see the noble Lord Mandelson in his place, who started this process so many years ago with considerable opposition from his own side, which appears to continue. But if I can just ask the noble minister 3 questions on this. I think that the noble Lord Young did raise a perfectly valid point, which is that is the government satisfied, and have they had advice from whoever is running the IPO from them, who presumably will have been taking soundings from the institutional shareholders they're expecting to invest, that those shareholders will be prepared to put up the necessary capital to invest in the Royal Mail, which was the whole purpose of the privatisation exercise in the first place. So are they satisfied that this structure will provide the necessary capital to continue the modernisation process in the Royal Mail that we all know is behind the whole privatisation drive? Secondly, and I think this is important, that the government has chosen to go the IPO route, which I must say some of us were slightly surprised by this, because we had assumed that the more likely result would be either some form of trade sale or a private sale. Would the noble Lord the Minister confirm that were the IPO to fail for whatever reason, particularly if listening to the noises that are coming from the trade union movement at the moment, would he confirm that were that to fail, the government will continue with the process of selling off shares in the Royal Mail? And would he also confirm that were that to happen, it is likely that the buyers would be probably a private equity group who are probably less likely to be sympathetic to the interests of the trade union movement than will happen under an IPO? And thirdly, if I could just reflect for a moment on the 10% that are going to employees, which, as the noble Lord will know, the Liberal Democrat element of the coalition has been strongly pressing for right from the start here. Would he confirm the numbers that have appeared in the newspapers recently as to the value of this to employees of the Royal Mail? That the numbers that I have seen are that the average employee in the Royal Mail is being paid approximately 19,500 per annum, and on the likely price of an IPO, every employee will receive shares approximately £1,900 to £2,000, which, if those numbers are correct, is clearly a very significant sum to be put in the hands of the well-deserving employees of the Royal Mail.
Mm-hmm. In answer to my noble friend's first question, in terms of the appetite from shareholders, the indications are that there is a clear interest in purchasing shares in Royal Mail. I would not want to go further because it is not my role to speak on behalf of investors, but my noble friend makes a very good point. But the most important thing for Royal Mail is to have flexible access to capital to allow them innovative and capture market opportunities, such as the strong growth in the parcels market, as I mentioned earlier, driven by online shopping. That's what an IPO will deliver for Royal Mail. And they should not have to come cap in hand to government and compete with schools and hospitals when they need to innovate or commit to future investment. The second question concerning the route to the IPO as opposed to other methods, it is true to say that having got up to this point over a good number of years, the IPO route was clearly the preferred route. Other options, I'm certain, were looked at. His specific question was, my noble friend's question was, if it was to fail, would other methods be used? I would not wish to be drawn on that one, and I wouldn't want to speculate, only to say that it is our firm belief that the IPO route is the right route, and that's the route that we will be following. The final question, which concerned the employees, and I'm delighted to hear that my noble friend is very much in favour of the giving of free shares to employees of 10%. In terms of the actual valuation, I'm certainly not going to be drawn on that because a prospectus will be produced in due course, and that will set out the terms of the IPO. And in terms of the actual valuation, that will of course depend on investor demand and market conditions at the time. So what my noble friend has read in the papers, as he will probably know, is pure speculation.
My Lord, I think that the Minister might agree that many of those who retired from the Royal Mail worked very hard to get it into the shape it's in just now, which is a very good shape. And I wonder if any consideration has been given to allow shares to be bought by those who are in receipt of a Royal Mail pension, in other words, former sorting staff and postmen and women. Also, that my thoughts go to the fact that in my previous constituency, which, although known as Glasgow North East, was known as Springburn, also known as Springburn at one time, that we have a lovely sorting office which I pass coming here every week to the House of Lords, and it's known as the St Rollox sorting facility. The people who work there are several hundred work there, and they've changed their hours, they've adjusted to the new situation that we've got. They work very hard. And I would be deeply saddened if any organisation came in and took over and vacated the site at St Rollox and went somewhere else, and which meant that the loyal men and women who get up maybe at 4 and 5 in the morning, walk to their work in the Springburn area, some of whom I'm related to, that they would lose their jobs, because some of the newer delivery companies like TNT and FedEx tend to go into great industrial estates, but the only way that you can get to these facilities is by private transport and not public transport. So I wonder if there's been any consideration given to the securing of jobs in the communities that they already exist in.
I thank the Noble Lord for those 2 points. The first point that he made was, or the question that he asked, was whether shares might be considered to be given to those who had worked for a long time for Royal Mail, and that their hard work might be rewarded and being given shares. But it is fair to say that the employee share scheme is designed to secure the future success of Royal Mail and the universal service, and we therefore consider it appropriate only to include the current workforce who deliver the universal service and can influence and benefit from the future success of the company. So share awards will only be made to those employees who have been in employment for the relevant qualifying period, which happens to be a number of months. In terms of his second point, I listened carefully to what the Noble Lord said, and I know Springburn, so it's familiar to me. And I'm sorry to hear that there's clearly been some disruption to individual lives regarding the transfer of the sorting office. My only response to that is that it is very much up to the Royal Mail management to...
Everyone's fine in St Rollox. My worry is that if some of these new companies come in, that they might close the facility and move the machinery somewhere else.
That's fine. It's useful to have the clarification from the Noble Lord. In that case, my point is still the same, which it is very much up to the Royal Mail management to look very sensitively at those personnel issues. And I have no doubt that they will do that if there is a particular move in that way. I mean, change, as we know, is always difficult, and it affects individuals, and the Noble Lord makes a very good point.
My Lords, I welcome the affirmation in the statement, and the Noble Minister has himself repeated this affirmation twice, that the Royal Mail will still be the UK's universal service provider, and that this will include services to urban and rural areas alike. However, my Lords, may we be assured that not only will there be universal coverage, but there will continue to be universal or uniform pricing. Too often, the residents of rural areas, especially remote and sparsely populated areas, do face higher costs for public services. Is the Noble Lord the Minister able to affirm unequivocally that a privatised Royal Mail will be required to maintain a universal pricing structure, and that in future residents, whether of Westminster or of West Devon, will continue to pay the same price for the service that is offered?
In answer to the Right Reverend Prelate's question, through the Postal Services Act, Ofcom has the primary duty of securing the provision of the universal service, and I can confirm that this is secure in the hands of will be secure in the hands of the privatised Royal Mail. And in terms of what is protected, it is not only the 6-day-a-week letter service to every address in the UK and free services to the blind, which I mentioned earlier, but it also includes affordable prices, which is monitored by Ofcom. In terms of the specific question, Royal Mail stamp prices, for example, for the Universal Postal Service will continue to be regulated by Ofcom, which has a duty to ensure that they remain affordable. And Ofcom, for example, has put in place a safeguard cap on second-class letters and parcels to ensure that the service remains affordable for all users. So I do hope that that reassures the Right Reverend Prelate.
Grateful to my noble friend for the statement, which I welcome very much indeed. Could I ask him whether he's had an opportunity to read through Richard Hooper's report, which was commissioned by the previous government and which paves the way for this announcement here today? Because it identified some very major hurdles to achieving its competitive position. It said it needed the elimination of restrictive labour practices, increased levels of automation, and a culture change towards customers. Could he advise what progress has been made towards that? And in welcoming the announcement, would he also speculate on the news from IMRG, where they've pointed that parcel deliveries, due to the growth in online sales, are going to increase by 70% over the next 4 years, providing a real opportunity for a revitalised Royal Mail in the private sector if it can sort out those inherent problems?
Well, my noble friend's points and questions allow me just to say that there is tremendous market opportunity for Royal Mail when it is privatised. And in terms of the automation programme and the changes that I mentioned earlier that the Chief Executive has brought about with the rest of the board of Royal Mail, there is extremely good progress to report, and I'm glad that my noble friend has in fact endorsed that. In terms of the market itself, we know that there is a tremendous opportunity in terms of future online shopping opportunities, but it will be up to the Royal Mail Board, following privatisation, to use the flexibility of private capital to look at the market and to take even greater advantage of the opportunities that there are there for the company.
Sits down. Sorry. No.
Thank the noble lord for his statement. Fully applaud this decision, which is belated in the extreme. It's clear that one of the great rationales for this privatisation is the increasing competition and the threats from technology which the Post Office, which the Royal Mail faces, and the idea that a state-owned operation of this kind can face those challenges in the nimble way that is required in business today seems to me unarguable, and I absolutely applaud the decision. Two quick questions, if I may. Is there a price, and I'm not asking you to name it, is there a price at which the government wouldn't sell? And secondly, are there any considerations about potential foreign takeovers in due course?
On the first question, my noble friend would probably be surprised if I gave an accurate answer there. So I will pass on that particular one. As I mentioned earlier, in terms of the price, the prospectus will be produced at a particular point in time between now and April 2014, which is the period during which we anticipate that the sale will take place. And, of course, market conditions and investor demand will also be part of that particular aspect.
Before the noble lord sits down, there were a number of questions that I raised that the noble lord, the minister, didn't answer, so I would request that he addresses those in writing. I haven't got time to reiterate them all. And I couldn't help but observe that I didn't think the Right Reverend Prelate got an absolutely explicit answer on a universal tariff as well as the universal service obligation. Maybe I missed something.
I will be very happy indeed to write to the Noble Lord, Lord Young, on any questions that I haven't managed to answer.
Lord Rogers of Quarry Bank.
As my lords will have recognised, the title, the description of this debate is a reprise. In a short debate on the 5th of February 2008, I recognised my concern about two issues, separate but related. One was the way in which ministerial and other papers are kept when they are left departments but not destroyed or sent to the National Archives at Kew. The other was the need to continue the long-standing series of official histories and how best to choose, organise and publish the books. As I explained in my debate in 2008, my interest on the first issue arose on the fate of government departments when I was seeking documents from my time as Secretary of State for Transport. After 6 months of fruitless exchanges between me and the department, I finally abandoned hope of anything substantial. The departmental government records officer, where papers are stored at Hastings, apologised, in his own words, an unsatisfactory situation. He recognised quite openly how this had arisen. The essential discipline, and these are my words, that had been lacking to ensure that they were proper catalogued, remain in the correct files, or change their names appropriately, and to return them when they had been borrowed. In the end, I wrote to the then Secretary of State of the Cabinet on the general question of government records and their condition. I said that some departments took great care about their archives and others did not, especially when departments were chopped and changed. I understood that his predecessors had reminded permanent secretaries that they were obliged to keep accurate records and in good condition. I received a helpful reply, and eventually he said that within a year or so he would again ask to remind permanent secretaries their duty in this respect. Since the previous debate, most, if not all, permanent secretaries have retired or gone elsewhere. Some departments have adopted new names and policy areas changed. So where are the papers now? And has today's Secretary of the Cabinet reminded new permanent secretaries of their responsibilities in keeping records? Or is it now the head of the Civil Service, Sir Bob Kerslake, to keep permanent secretaries up to the mark? To put simply, can the Minister reassure me that government papers, as I have described them, are now in good order? My Lords, I turn to official histories. On the previous occasion, 5 years ago, I mentioned Problems of Social Policy by R.M. Titmuss, published in 1950, a seminal study of poverty and deprivation in war. It was the official history I had read. Another I mentioned was the SOE in France by M.R.D. Foote, in which I was required to read as a ministerial interest at that time. Then I referred Churchill's Man of Mystery, Desmond Morton and the World of Intelligence, an unusual choice even amongst the eclectic selection of titles in the current series. It was this book about Desmond Morton, that focused my mind on some wider policy questions about the official history programme, the timetable, the shape of the programme, the publisher, the contracts with authors, and the marketing of books. Desmond Morton seemed to be a one-off, as it had been well-designed jacket and told a fascinating story, so it should have sold well, serialised in newspapers and considered a television programme. I asked how many copies had been sold at £49, about twice the usual price, and were there both reviews book reviews in magazines and journals. In reply to the debate, the Minister was full of goodwill, but no figures or substantial response. However, after the debate, things began to move. Before the end of that year, the Cabinet Office said it was commissioning a fundamental review, and Sir Joe Pilling, a retired civil servant, would undertake it. He took evidence quickly and widely, and his report was completed by April 2009. A further report was associated with it, was a report on the publishing arrangements written by Bill Hamilton, a literary agent. These were internal classified reports, but 2 years later, when Noble Lord Hennessy intervened to the Cabinet Secretary, it was decided to make them publicly available on the Cabinet Office website. I welcomed this step, though I was bothered in that some key paragraphs in the Hamilton report had been removed as they were commercially sensitive. The principal terms of reference for the Pilling report were to require the official history programme and whether it should continue. And Sir Joe Pilling's recommendation was strongly positive. The overwhelming weight of evidence, he said, supported the continuation of the programme. He then went on to make detailed suggestions to ensure that the programme was better, stronger and more useful. I should say that in 1997, the Prime Minister had nominated 3 private councillors, Noble Lord Healy, Noble Lord Howe of Aberavon, and me, to ask whether they were content with the subject and the author for each proposed book in advance of the Prime Minister's formal approval. This led to my interest in the whole Official Histories programme and how it was put together and published. In this respect, I have much exceeded my proper and limited role. However, I've kept in touch with Lord Howe from time to time, and at the beginning of my inquiries he shared my view that the programme appeared to fall not short of chaos. Later, he wrote directly to the Secretary of the Cabinet expressing his concern. Then, in a letter to me on the 25th of August 2010, copied to Lord Howe and Lord Healy, Sir Gus O'Donnell said that as the current programme of official histories was coming to an end, and I quote, "Given the current challenging economic climate, I am sure that there will be likely to be a hiatus in commissioning news titles." So, my lords, that is where things stand. There is now a hiatus, a gap in the official histories. The last volume of the existing programme was commissioned 5 years ago, so the break in the sequence is already lengthening. I'm grateful to members of the Official Histories team at the Cabinet Office for their helpful responses to my persistent inquiries over a long period. But I do not know who decided that there should be a hiatus. Was there a ministerial decision? And if so, by whom and when? If a new programme either marks time or goes ahead, what are the financial consequences? Is it really justified to stop official histories because of the challenging economic climate? As I said earlier, my lords, there are no relevant figures and costs given the deletions in the Hamilton report, but it must be peanuts against public expenditure. I think that the latest book published in the existing programme is the second volume of the Official History of Britain and the European Community by Sir Stephen Hall. It is an outstanding and wholly relevant to the possibility of a new referendum in the next Parliament. I remain disturbed about the publishing and marketing arrangements for official histories, given that this book is priced at £70, a ridiculous figure. My Lord, history never stops, and the Secretary of State for Education is very anxious that Britain's own story is recorded and studied. To stop official histories is short-sighted, and although the Minister cannot announce today a reverse of this unhappy situation, I hope the Government will make an early decision to resume the publishing programme.
My Lords, can I congratulate Lord Rogers on raising this matter of government archives and records? I was a bit unsure whether my experience, which I wish to relate to the House, fitted into this. But in his first few words, it made clear the kind of chaos that's associated with the records and archives. That has been exactly my experience of the last 2 years, not going back as far as Lord Rogers. I need to set the background as to why I needed access to the records. The background came from the Dirty Tricks Department in the local government department led by the Secretary of State, Mr. Pickles, who decided to go back to my record of expenditures in the department in 2004 and 6, clearly an obvious political reason, and then he spelt out all the expenditures that were done by government procurement cards in my name. That meant, of course, it was given to the press. There were PQ questions here and in the Commons, and it became me running around everywhere, eating in the best restaurants, etc. Just not true, but they were put out and politically inspired to do that. My concern then is, how do I get access and challenge it? So I write to the Secretary of the Cabinet, obviously, Gus O'Donnell, and I say I'm very concerned about this matter. It's not true. So he wrote back to me, and I have the 2 letters, and this is my first point. And I spoke to Lord O'Donnell about this. He sent me a letter saying, yes, there had been some fraudulent expenditures, the person had been caught and disciplined, and that I should have been told before they released this information. That is the normal courtesies. Don't normally apply to me, but anyway, that's what's supposed to be the courtesies. And he sent me the letter, and that was dated the 18th of November. 5 days later, another letter came back contradicting his letter with his stamped name on it, but not the signature. And I've talked to Lord O'Donnell, so I end up with 2 Cabinet Secretaries' letters. The essential difference, one about the criminal and finding out the person that's done it, and the other one not being told, deleted from the second letter. So clearly I get a little concerned about who signed what where. And I then asked and I talked to Lord O'Donnell, he said, I only signed 1 letter, I don't know anything about the second one, and he still was in that early stage before his retirement. I clearly want to know, so I asked the question, and the department won't give me the information. So I then applied to the Information Commissioner's Office under the Freedom of Information. He looks at it and says he backs the Secretary of State. I went to another appeal and he said, I back the Secretary of State. What is he backing? He's backing the view under Section 36 of the Freedom of Information Act that if it is in the public interest not to tell you, then he can deny you access to that information. Well, the Cabinet Secretary has already declared and confirmed by the Information Commissioner that, yes, they know who the person was who instructed. Now, clearly, my suspicions are, and since they won't give me the information, we're back to the old Spads and Schnaps, or whatever his name is, was a minister at the time, and Mr. Pickles. Somebody directed the Cabinet Office over the weekend to change the letter. They didn't ask Lord Donald, we're changing your letter, is that all right? No. So somebody did it. It was a political intervention to take out 2 important bits of information. And therefore, it's certainly relevant to what I was concerned about. The Information Commissioner confirms all this. Yes, the information's available, but it's not in the public interest to tell you. Why is that? Because it's a public high-profile case. Well, I'm not sure that's a sufficient answer to be given. But why is it a high-profile case? Because they've released the questions to the press about my expenditures. That's what's made it high-profile. And then that comes the justification for the Information Commissioner, why he can't tell me, why it is not in the public interest. It could have a chilling effect, I think, on civil servants telling you what's actually happened. We're talking about political intervention here, not civil servant. One civil servant doesn't tell them this. This is a direct intervention on essential information by somebody in the Department of Local Government with the Cabinet Office over the weekend. So to that extent, my concern, therefore, is how do I get that information? I can't get it through the Information Commission. They're actually confirming the decision taken by the Secretary of State in that Mr. Pickles. So then, what can you do about that? Well, I know it's difficult when you're up against the Information Officer, Commissioner, who said that, but I still have that concern about this political intervention. So, right. There's many expenditures in this department. They list them all. I must have eaten myself round the ruddy world, according to the department, and in all the best restaurants, of course. And therefore, I think, can I get access to my diaries? One of the expenditures, over £1,000, was spent in a hotel on Christmas Eve. You won't be surprised to know I wasn't in London having a do. I was at home. I need the diary to be able to prove that these allegations against me are just wrong. So I then go to the Cabinet Office to ask for the information. But don't forget, the Commissioner of Information says you must appeal if you want to go to the final body for appeal. You've got to do it in 28 days. So I write to the Cabinet Office and I ring them and I said, I want the information of my diaries. And they tell me they're very difficult to find. And in the end, I get a letter this morning telling me they've found them. This is weeks later. The trouble is the appeal's gone. Now, is that the normal service one can expect? I know they're supposed to get some privilege if you're a Privy Councillor. Well, I'm not now, but this I was when I was then anyway. So I should have still had the access to the information on the fast track. I expect slow track from now on. But anyway, the circumstances are such that basically I couldn't get the diaries. If I could have got the diaries, I need that to show where I was on what date and to perhaps throw doubt on all these expenditures that are involved in it. So to that extent, I'm frustrated with it. I didn't think I could bring it up until I heard Lord Rogers say, oh, delay in access to information, which ministers of the past. If the government can get it, and they have in my case, and the ministers, why can't I, the man that attacked him for it? It's what I call political dirty tricks. I hope they'll read this report, but I just felt there was a frustration. Here was a chance on Lord Rogers' debate just to put my point of view with such eminent people who are going to follow who have direct experience of what happens in Cabinet offices.
My Lords, I'm left breathless, but I will try. May I thank the noble Lord Rogers of Quarrybank for giving us the opportunity to debate this important theme, and may I declare an interest as President of the Friends of the National Archives and as a teacher of contemporary British history at Queen Mary University of London. My Lords, I should like to concentrate this evening on a special oeuvre within the genre of official histories, those dealing with the Secret Services. Two very fine ones have appeared since the noble Lord Rogers last enabled your Lordship's House to discuss official histories. The new pair are first The Defence of the Realm, the Authorised History of MI5 by Professor Christopher Andrew, which was published in 2009, spanning the years 1909 to 2009. Secondly, the following year saw the publication of Professor Keith Jeffrey's MI6, The History of the Secret Intelligence Service, 1909 to 1949. Both books, my Lords, brim with their own special mixtures of analysis and swash and buckle, of operations and organisation. Both studies kindle that fascination to which we Brits are so susceptible when reading about the King's or the Queen's most secret servants in either fictional or non-fictional form. And it's here, my Lords, in that strange twilight terrain between the facts of Professor Andrew and Professor Jeffrey and the imaginations of the spy novelists, that one finds, I think, the real utility of intelligence history. Why? Because, my Lords, spying and counter-spying are activities which uniquely lend themselves to fantasy and conspiracy theory. And the meticulous, careful reconstructions and assessments filtered through the minds and pens of Chris Andrew and Keith Jeffrey are the best antidote we have to what one astute critic called the snobbery with violence practised by Commander Bond on both page and screen. My Lords, part of the special utility of Secret Service official histories and historians is that they possess another virtue, a Heineken lager quality, for they can reach those parts of the secret state that others cannot reach because of the stratospheric classification levels of many of the documents on which they draw and the care needed to avoid blowing both human and technological techniques, the sources and methods of the craft that remain of enduring value.
The paper product of our secret agencies does not flow that easily into the public domain on the tide of the 30-year and soon to be 20-year rule. But, my lords, the appearance of the official histories of the Security Service and the Secret Intelligence Service has provided a scholarly bonus, a Keynesian multiplier effect, in fact, which I had not anticipated. For once the volumes had been published, a proportion of the retained files on which Professors Andrew and Jeffrey had drawn could be prepared for declassification at the National Archives, and indeed were. At Kew last May, my lords, the Foreign Office, the Cabinet Office and the National Archives mounted what can only be called a cornucopic release, drawing on two of the most secret collections the British state has ever created. The FO batch covered the Foreign Office's dealings with the SIS, the province of what the FO euphemistically calls the Permanent Under-Secretary's Department, covering the years 1903 to 1951, and shedding much new light on how the secret state coped with successive threats from the Kaiser, Hitler and Stalin. The second tranche flowed from what I call the Cabinet Secretary's Too Hot to Handle cupboard, formerly known as the Cabinet Secretary's Miscellaneous Papers. This batch covered the years 1936 to 1951 and contained material which, in my judgment, my lords, is of continuing value to today's guardians of national security in the secret agencies and in Whitehall. I particularly have in mind the report prepared for Mr. Attlee and a small group of ministers in 1951 on the secret intelligence and security services. Written by that great technician of state, Sir Norman Brooke, the Cabinet Secretary to 4 Prime Ministers, it painted for ministers a vivid and indeed an unsparing portrait of how the secret world had fared and was faring against the toughest target British intelligence had ever faced, Stalin's Russia. I hope, my lords, the current heads of service and the Cabinet Secretary will read the Brooke report. Not only is it an exemplar of concision and penetration and the jargon-free language at which Whitehall excelled before departments sought the assistance of management consultants, it is a model for how such a review might be commissioned today. If, for example, the Prime Minister wished to review the workings of the secret world as a whole, with now over 3 years of experience available of his National Security Council as the taskmaster and pacemaker of the agencies. My lords, I profoundly hope that the current austerity will not dam the flow of official histories for the foreseeable future, not least those dealing with the secret world. It would be hugely beneficial, for example, if Cheltenham could authorise an official historian to start work on a volume designed for the general reader, embracing as much as can safely be divulged about the government communications headquarters and its previous institutions, its predecessor institutions, to complete, as it were, the secret agency set, to make it 3. My lords, I like to think that in this House we have a keen sense of history across all our benches. In fact, I know we do. I know, for example, that the noble Lord Cormac would have added his wisdom to our deliberations this evening had he not been involved with our other business today. And I should like to finish by giving my thanks to all those across the departments and agencies who provide us with such a rich paper trail, though obviously not to the noble Lord Prescott, regrettably, and those who care for the documentary product permanently at the National Archives. We are truly in their debt.
My Lords, I too am grateful to the noble Lord Rogers for initiating this debate. At least I was until I heard the speech of the noble Lord Prescott. Now, I'm tempted to say in reply to him that things must have gone downhill since my day. But actually, I think I can solve his problem for him. Because unless things have very much changed, he doesn't have to go to the Information Commissioner to get the papers either about his diary or about his restaurant bills. Certainly it always was the case, I believe it still is the case, that any former minister can consult the papers which he himself dealt with. So my advice to Lord Prescott, if he finds himself being traduced again, is to go directly to the department and ask to see them, and not to bother with the Information Commissioner. Well, I think the noble lord should have gone to his own department. But I would like very much to endorse what the noble Lord Hennessy has said about the value, and what Lord Rogers said, about the value of both the official histories and of the National Archives, and the importance of good record keeping in government
not just for the benefit of academic historians, but in my view also for their relevance to current decision-making. It is the case that decisions that the government makes when it isn't fully aware of the history of the subjects that it's discussing are like, in my view, a car driver who goes out into the traffic without having taken the trouble to check in his rear mirror before taking the action on the road which he does. And in that respect, both the files and the official histories are very valuable. But in my view, they are not enough, because we need something else to exploit the lessons of history for policy decisions. If when a crisis arises, there is no official history on a subject, certainly if there is, it ought to be consulted, but that is it's a monumental work and doesn't cover all areas of government policy. And it is too late at that time to go back to the archives. So, in my view, we need to ask what else is needed to exploit the lessons of history when they are necessary for informing policy decisions. It would, of course, be impossibly expensive to employ enough historians in government to cover the vast span of each department's responsibilities. But it is not too expensive for each department to have a historical advisor who would not necessarily be able to give advice on all major issues, but who would have sufficient tendrils into the academic world to know where such advice could be obtained. And it's not sufficient, in my submission, for this advice simply to be fed into the department. A historical advisor must be present at the table when major decisions are taken. Of course, it's the case that in the case of Iraq, for example, there were many in the Foreign Office and State Department who were fully aware of the complexities of both Iraq and Afghanistan when policy decisions were being taken on those countries. The question is whether they had the opportunity to make themselves fully heard by the decision makers. In this respect, I admired the practice of Margaret Thatcher as Prime Minister, whose first step when taking a major decision was to hold a seminar of experts. The seminar she held when facing the issue of the unification of Germany has become well known. It didn't necessarily overcome her prejudices, but it was certainly a counterweight to them. It's said that under the pressure of economies, all departments, with the notable exception of the Foreign Office, have disbanded their historical sections. If that is so, I think it is a grave disadvantage to the operation of government. I ask that the Minister might tell us tonight, when replying to this debate, or otherwise write to me, whether it is true that all departments except the Foreign Office no longer have historical sections, and if that is untrue, which departments still have them. I also invite his comment on whether, even if departments cannot afford historical sections, they should at least have a historical advisor. Without such, government decisions will be taken blindly.
My Lords, I would also like to welcome the debate that Lord Rogers has initiated tonight. The reason I wanted to speak was to make one simple point, which is a point in favour of official history, very strongly in favour of official history, and wanting to make official history more contemporary, not less, because I believe that history is of vital importance to people when facing difficult decisions. In the years I spent as an advisor in government, one thing that struck me a great deal was the lack of institutional memory in government departments. Even in a long-serving government like the Labour government from 1997 to 2010, ministers change jobs very frequently, and it was very unusual to have ministers, except in one or two cases, who had a long period of office in one department. But apart from the ministerial merry-go-round, there were very, very frequent changes in the civil service. I think one of the most striking things, for instance, in Lord Adonis's book on education, is how, in the case of the Academy programme, there were 8 different people in charge of it in the Department of Education in 9 years, when he was the relevant person at Number 10 dealing with it, and then as a junior minister in the department. There is far too much changing around, and as a result there's a lack of institutional memory. And I remember when Lord Mandelson came back from Brussels and went to I can't remember what it was then called, Burr, I think, and started to think about industrial policy. There was very little available that one could turn to that analysed the strengths and weaknesses from the perspective of government records of government policies in the past. So I do think that more history would be good for us, and more contemporary history. The most recent official history I've read is Stephen Wall's excellent book on Britain and the European Community from 63 to 76. It's made me reassess what I think was probably a rather too jaundiced a view of Harold Wilson. And actually, when you read, as Stephen has given us, the benefit of the actual minute books of the cabinet secretaries, so you know what each minister said in the cabinet meetings, you come to admire Wilson's skill in handling questions like the common market at cabinet. But the lessons for what we're currently going through, the lessons for the renegotiation that the current Prime Minister proposes, come out of that book extremely strongly. And one of the reasons why, taking again the Europe example, I would like some more contemporary examination of the records, was that many of the issues that are going to be raised if there is a renegotiation in the next Parliament were actually raised during the European Convention in the period from 2000 to 2003, when many of these issues about competencies and repatriation of powers and legitimacy and accountability of European institutions were thoroughly gone through. And yet, I suspect there has been no a proper examination by either officials internally and certainly none by historians externally of the lessons of that experience. So I think let's have more official history and let's make it more contemporary.
My Lords, I too would like to thank Lord Rogers of Quarrybank for securing this debate tonight, and indeed for opening up this whole question with this debate 5 years ago. I have to declare an interest as a secretary to the All-Party Group on History and Archives, and also as my noble friend Lord Hennessy, as a working professor of history in Queen's University, Belfast. One of the effects of the important debate introduced by Lord Rogers 5 years ago was the production of the Pilling report, and Lord Rogers has referred to it tonight. And there's a striking sentence by Sir Joe Pilling at the heart of his report endorsing the project of official histories. Really striking. I have come to see the work of publishing official history as, quote, the gold standard of accountability to the country from those who have been privileged to hold senior office. The gold standard of accountability to the country from those who have been privileged to hold senior office. And it is for that reason that Sir Joe Pilling advocates
essentially an improvement, an increase in the production of official histories. And I do recall that 5 years ago I mentioned the history of MI6 that my noble friend Lord Hennessy has mentioned tonight by my colleague Keith Jeffrey, which was then basically something that existed on Keith's desk. And now it does show these things can sell. One of the many points that are so important about that book is it's actually sold hundreds of thousands of copies across the world. It may be because the Chinese copy does actually have a gun smoking on the cover, but nonetheless, it is an indication of the fact that there is no definite economic death that follows for the production of official histories. So I think it's important to understand that the work of producing official histories is of great significance. But there is a darker side to Sir Joe Pilling's report. And if you read between the lines, he is aware, as a member of the Dacre Committee with Sir David Cannadine as well, that it was likely to be the case that we would move from a 30-year rule. Actually, the Dacre Committee recommended to 15 years, but in practice it is now a 20-year rule. And he is also clearly aware that this is going to become an argument on behalf of the state to say, well, really, actually, we don't need these official histories any longer. And he clearly is tacitly acknowledging that that is an argument which is going to appear, it's just around the corner, and of course it is the argument that is related to the hiatus that has been announced in the context of the austerity. This I completely understand. There's a forceful logic to this. But we are actually, there is another hiatus, if I might put it like this. And my argument is this, that would be forcefully true when the 20-year rule comes into effect. It will be much truer 5, 7, 8 years from now, insofar as it has truth that is actually today. And we still have a pressing need in public areas for a certain type of work in an official history programme. And let me explain what I mean by that. Let me take the case of the history of the Northern Ireland Office. If you actually want to look at the volume of official publications on Northern Ireland, on the shelf of our library, what you will find is a shelf of official publications. And it is Bloody Sunday, it is the Finucane Report, hundreds of thousands of pages, mostly dealing with matters of that sort, mostly dealing with occasions where the state has actually been seen to behave not very well. I have no objection to that. I was the historical advisor to the Bloody Sunday Tribunal Report. But it is somewhat ridiculous that there is actually no account of the work of those officials on the British side who struggled to bring about a peace process. It is astonishing that we are absolutely silent on the more creative, the more positive, no doubt deeply flawed aspects of the work of our state officials, while we are so loud in announcing some of the rather bad things that went on. And it seems to me this is an astonishing way to proceed. I also think, by the way, the same point can be made about aspects of the Foreign Commonwealth Office history in the 40s and 50s in recent times. We seem to now think that the way to educate our public what happened in the past is to apologise or have a large and expensive inquiry about something that's very bad. May well be necessary. But this is the case for a proper official history programme. And in the hiatus that now exists, still in the case Northern Ireland Office particularly, and also in the case of many arguments that there have been about legacy in Northern Ireland and a sense in Northern Ireland itself that the past has not been properly dealt with, I actually do think for the small sums involved there is a case for the government reconsidering its approach of austerity in this matter. And by the way, there is a further point made in Sir Joe Pilling's report which is worth drawing attention to, where he says that in fact the internet now would allow you to publish a lengthy set of footnotes and a lengthier text, the full scholarly history, but a 200-page shorter version as the book. And it seems to me, again, that's another way of government avoiding unnecessary expense. In other words, I'm arguing this actually can be done quite cheaply. So I would like to see the government reconsider the force of the Pilling Report of 2009.
Very good, very good. Of the Minister. I would just like to say that I agreed very strongly with the arguments of the noble Lord Butler arguing for a historical advisor to many government departments. I had the privilege of accompanying the Lord Carrington on a visit which he made in 1981 to South America. It wasn't at all clear what I was doing, but I accompanied him as a historian of the Spanish world. When we got to Brazil, an official of the Brazilian foreign minister asked me what my mission was. I said, I am Lord Carrington's historical advisor. He hadn't appointed me, but I appointed myself. And the Brazilian official said, what a good idea, we must have one too.
My Lords, I declare an interest as a board member of the Brown Archive Trust, a Scottish registered charity which owns the personal papers of Gordon Brown MP, which are in the process of being deposited with the Churchill Archive Centre in Cambridge. I'd like to congratulate Lord Rogers of Quarry Bank for securing this debate and indeed for his persistence in sponsoring earlier debates on similar themes. He does us all a great service. This has been a very high-quality debate, and it's fallen into possibly three topics. The first one was on the official histories, where the balance of opinion seems very clear that these are a very important part of the overall architecture of the responsibilities of governance and accountability, and I hope the Noble Lord the Minister will be able to give us some thoughts on that when he comes to reply. I certainly found them fascinating, and I think they are an important part, and we ignore them at our peril. The second point was really the question which was picked up initially by the Noble Lord Rogers, but was also graphically explained by the Noble Lord Prescott, my noble friend, where the question is, are the papers in good order? And I want to come back to that when I speak later on in this debate. And the third point, which I thought was an interesting one from the Noble Lord Butler about the question of historical advisers, and I will also be interested to see what the response of the Noble Lord the Minister is to that. My Lords, I'd like to focus on the question of emails. I've done some work on the Brown papers, the papers that relate to the administration headed by Gordon Brown. And I'd like to thank the staff in the Cabinet Office and indeed in the Treasury for their expertise and support when I've had to access these files for various issues in the last year or so. I have had some sense of what Noble Lord Prescott was saying, but by and large my experience has been good, and I have been able to find the papers I've needed reasonably in the time, and I'm grateful to those who have supported us in that. Mr. Brown's administration was, however, the first which was almost entirely digital. Papers, minutes, notes and messages were all exchanged electronically, and indeed the key evidence of meetings and events, which I notice the National Archives' one of the main foci of its work, were in electronic form, as indeed were the diaries. There are, of course, some traditional papers in the manila files which characterise the way Whitehall keeps its data on administrations, but these are mostly simply printouts from the electronic system. I know to my own cost, because I've spent many hours looking at them, that the paper files contain some very substantial gaps. But my main concern is that the emails which support and exemplify how policy was decided are not generally incorporated into the paper files. Indeed, the email files are kept separate, and no work seems to have been done on them since the end of his administration. So can the Noble Lord the Minister explain what the government policy is here? I'm assured, and I have some evidence to back that up, that the emails are being kept, that the technology is being looked at so that they are progressively kept alive. But keeping records is not the same as keeping records permanently. If you keep records permanently, it means that somebody has assessed the records and found them to have enduring long-term value, selected them and made them safe and secure, and can find them when they are required. Keeping records indefinitely means we can't find a basis to set a retention rule on them. Although the staff in Number 10 were encouraged to file material, we need a lot more than that. The current standard seems to be that email accounts get removed after the government changes or a member of staff leaves. But surely this should only happen after a pre-exit process in which an archivist and an employee go through the email account together and decide how to deal with these emails, or in a post-exit process, an archivist would look at the emails which need to be kept and ensure that they were catalogued and tagged for future access. That approach would at least recognise that in the real world, people cannot be relied on to comprehensively and routinely deal with their individual emails as they go along by filing or deleting. Email communications are exchanged with such frequency that backlogs quickly scale up to a size that makes patient sifting and sorting virtually impossible. But we also need to recognise that the electronic way of working is intrinsically different from the earlier paper-based systems, and our archiving approach needs to reflect that. Emails typically deal with several different topics in one chain. How are they to be broken up and filed across those various aspects? Even if an individual never used their work email account for non-work correspondence, their account is still likely to contain personal information of a sensitive nature exchanged with colleagues. That needs to be addressed. Emails within the context of ministerial context are often political in nature, issues that perhaps should not reach the permanent archive but should be made available to those parties which are involved. And it's also within emails, it's hard to establish an electronic document management system which will work. Where access to email archives are problematic because the information contained in the totality of that archive, which is of course virtually accessible if you go straight into an email archive, is so sensitive that the National Archives might well have difficulty in imposing a rule which does not exclude very large amounts of information, a point which was made earlier. This of course is a very general issue, and I'm sure the issues that I've been touching on here work in commercial companies as well as in government. There's a quote from an eminent historian of American higher education, Winston Silberg, which is worth recording at this stage. Historical research will be absolutely impossible in the future unless the archivists find a way to save email. What we need is an approach to email that results in staff leaving behind an email account that their colleagues and successors can routinely access and use without unduly harming either the account holder or people mentioned in their correspondence, and that we have defensible access rules and, importantly, retention rules. I suspect it's beyond the ability of a single organisation to develop such an approach because it involves changes to available tools in the technology, changes to the way we think of an email account, and changes to how we ask colleagues to treat emails. But I look forward to hearing from the Noble Lord the Minister about what progress is being made in this crucial area.
My Lords, may I begin firstly by thanking my noble friend Lord Rogers of Quarry Bank for initiating this debate. And indeed the House, I'm sure, are fully aware, as we all are, of his long-standing interest in these matters and the great experience he brings to bear in debates such as these, again, as demonstrated by his contribution today. May I also, in doing so, also thank all noble lords for the valuable contributions they've made and indeed raising several important questions, and I do hope that I shall be able to address most, if not all, of the issues and indeed write on any questions that are left outstanding. I also pay tribute to my noble friend for his work within the Privy Councillors Group, or the three wise men, as they are often referred to in this particular area. And if debates such as this are about prompting interest, as a minister in the government, this was a new area for me, and it certainly prompted my interest, and I'm certainly looking forward to my own visit to the National Archives over the next couple of weeks or so. Turning to official histories, if I may first, my noble friend Lord Rogers, and indeed the noble Lord Bute, referred to the reviews commissioned by the then Cabinet Secretary and the noble Lord O'Donnell, and conducted by Sir Joe Pilling and Mr Bill Hamilton. They recommended, my Lords, that the official history programme should be continued under the guidance of the Cabinet Office, but under the name of the Public History Programme. They proposed substantial changes to raise the profile and the relevance of the programme, including an increase in the involvement both of sponsor departments and outside bodies, a revamping of the publishing arrangements, and indeed an enhancement to its governance procedures. Several noble lords have referred to this, and I will return to it, that given the current economic constraints, the government at the current time does not plan to implement the proposed changes. However, my lords, we are moving forward with the completion of the existing programme, which will conclude with the publication of the Joint Intelligence Committee Volume 2 in 2016. Work on this volume will be completed, we hope, by the end of 2015, after which point recommendations will be revisited. My noble friend Lord Rogers referred to various matters of expense, and without incurring disproportionate expense, it is not possible to determine the overall cost of the current series of official histories. However, for the last year for which published costs are currently available, the years 2006-07, the net cost was £176,000. This particular cost includes fees and expenses of historian and research assistants and costs associated with publication, but excludes staff costs of Cabinet Office administrative support and accommodation-related overheads. Noble lords, I'm sure, will understand that until the future shape of any programme has been determined, it will not be possible to estimate the likely future costs. I would at this point reiterate the words of my noble friend Lord McNally when he previously answered a debate on this subject,
And he said that as for the future of the official history programme, a good deal of work is already in progress. And I do hope that we can review future work in happier economic circumstances. However, I share his enthusiasm and sentiment that for the programme of official histories, and I share also the point he made that it would indeed be a tragedy if we were to allow them to wither on the vine, as he said. The noble Lord Hennessy, with usual aplomb in his excellent contribution to today's debate, referred to the histories of MI5 and the Secret Intelligence Service, written respectively by Professor Christopher Andrew and Professor Keith Jeffrey. I should clarify for the House that these were authorised histories more akin to departmental histories, but were not commissioned under the official history programme. The noble Lord also suggested that an authorised or official history of GCHQ would be a valuable addition to those recent intelligence histories. In fact, my lords, nearly all of GCHQ's records of the period roughly corresponding to that covered by Professor Jeffrey's history of SIS have already been released at the National Archives. And I agree with the noble Lord that it is open, therefore, to any historian. Indeed, we have historians in our own chamber to write their own history of GCHQ, and I look forward to such books being written. Turning to the question of the arrangements for preserving government archives, we have grounds to be optimistic, given the progress made in a number of areas since 2008. And I will, if I may, just outline some of these. First of all, departmental record keeping and the responsibility. In line with Public Records Act 1958, government departments are responsible for their records up to the point that they are transferred to the care of the National Archives. The National Archives provides departments with guidance and supervision, but decisions on which records to select for permanent preservation remain the department's own. Turning to actual guidance, in June 2009, the Cabinet Office and the National Archives revised the guidance on the management of private office papers. November 2010 saw the revision of the Civil Service Code, which now, my lords, emphasises the importance of keeping accurate official records and handling information as openly as possible within the legal framework. In December 2010, the Cabinet Manual was issued, and this includes a section on official information and maintaining official records for departments. If I could turn to some of the questions which have been raised during this debate. First of all, a question raised by my noble friend Lord Rogers about reminding permanent secretaries of their accountability for record keeping in their departments. It is from the Cabinet Manual that permanent secretaries should indeed draw their guidance. Turning to several matters or issues raised by the noble Lord Prescott in his contribution, which I'm sure was we all found entertaining. To save the high cost of file storage in central London, certain records have been outsourced to secure locations outside London. Regrettably, I'm informed that mislabelling of the box containing the noble Lord Prescott's diaries led to a more extensive search being required, and I am sorry for any delay this caused. However, I'm sure all noble lords are delighted to learn that he has now received a response to the positive, and I'm sure we're all looking forward to the publication of the noble lords' diaries, and I'm sure they'll make an entertaining read for us all. Turning, if I may, to a point raised by the noble Lord Butler about former ministers in response.
Grateful to the noble Lord Goodfair. I'm sure the noble Lord Prescott can speak in his own right, but I think the point he was trying to make was that there are points where, particularly in today's world, where it's absolutely vital for people to be able to respond quickly and precisely to the allegations made for whatever reason in the press. I don't think the noble Lord responded really to that point. I accept his general point. Could he give us some assurance about how quickly these things can be in future?
In response to that, I would say that I have responded in much as saying, first of all, apologising for the delay. I think it's been recognised that that should not have happened. And, of course, measures have been taken where the archive record should be labelled properly. And I do give that assurance that that has been done. And, well, labelling, I'm sure the noble Lord will agree with me, does matter. It's good to know whose diaries are where. In response to a point the noble Lord also raised, Lord Butler is indeed absolutely correct in that former ministers can indeed see their papers within their former departments, and this is also, may I assure the House, outlined in the Cabinet Manual and available online. The Noble Lord Butler also talked about the coverage of historical advisors and sections across Whitehall. May I say to Noble Lords, the FCO does still have a historical section, the head of which is Patrick Salmon, and I will, if I may, write to the Noble Lord on the coverage of historical advisors across Whitehall in general. Indeed, I will, of course, place a record of that letter in the library. If I can turn to some other initiatives, the National Archives Information Management Assessment Programme began in 2008. To date, most of the departments of state and several key agencies have been assessed, and the remainder will be assessed during 2013-14. The National Archives is also about to begin a series of ongoing reassessments. The published reports of these assessments highlight good practice and make targeted, pragmatic recommendations for improvement. The National Archives works with each department to develop an action plan to address any risks and issues identified in the report. The Noble Lord, Lord Bew, also referred to the 20-year rule. As Noble Lords will be aware, from the 1st January of this year, central government began its 10-year transition from the previous 30-year rule to the 20-year rule. To smooth this transition, the National Archives has, with active participation of departments across government, comprehensively revised its guidance and processes for the selection and transfer of records. The National Archives has been tasked to collect and publish regular reports on departments' progress in reviewing and selecting records for permanent preservation during the transition period. The most recent report, which returns from 84 departments and agencies, was published on the National Archives website on the 1st of July. This level of transparency, my lords, around the government's record management is, I would suggest, unprecedented. With these reports and the transition itself, we have come a long way from the days prior to the Freedom of Information Act, when our best hopes for transparent government lay with such excellent initiatives, such as the one led by the Noble Lord, Lord Waldegrave. The Noble Lord Stevenson rightly mentioned the issue of digital records, and much work has been carried out to clarify and address the challenges presented by the shift from paper to digital records and the business of government in this respect. The National Archives now has greater confidence that much discussed black hole in our history wrought by obsolete digital formats is unlikely to materialise on the scale that we once feared. But it is important that in the National Archives programme, the issue of new technology is fully embraced. Digital continuity is now taken much more seriously across government than it was 5 years ago, and the programme of training instigated by the Noble Lord, Lord O'Donnell, during his time as Cabinet Secretary, has certainly aided a better understanding of our digital records and improved usability and accessibility. Of course, there remains the challenge of reviewing large volumes of digital records for sensitivity ahead of their potential release under the 20-year rule. The National Archives is working with other expert bodies to develop solutions. My Lords, I'm pressed for time, but in conclusion, I would say that I believe we all recognise that there remains much to do to ensure that the government record in all its forms survives for future researchers and historians. Indeed, that was something expressed by all Noble Lords today. But I do hope Noble Lords will take from today's debate some reassurance that these issues continue to be explored and addressed, and that, more importantly, much more of the government's work in this area is open to scrutiny by members of this House than ever before. The Noble Lord Butler, in his contribution, said governments need to look at history, and he indeed referred to the Noble Lady, Lady Thatcher, and her policy of a panel of experts, and I think we can learn a great deal. The National Archives do represent our history, and I suppose as a minister in the current government, it's apt to finish with a quote from Sir Winston Churchill, who said, study history, in history lies all secrets of statecraft."
Further consideration on report of the Marriage Same-Sex Couples Bill, Baroness Stoler-Beeston.
My Lords, I beg to move that this bill be now further considered on report.
Is this bill be now further considered on the report? As many as are of that opinion will say content. Contrary not content, the contents have it. After Clause 14, Amendment 95, Lord Bishop of Leicester.
My Lords, I rise to speak to Amendment 95, and I'm glad to do so after a dinner break, which I hope will have had the effect of moving you to see that this amendment merits the support of all sides of the House, whatever our disagreements may have been on many days of debate thus far. The effect of this amendment, my Lords, will be to ensure that there is no conflict
between the guidance issued by the Secretary of State on the teaching of sex and relationships education, and within that about the importance of marriage, and the obligation on schools of a religious character to teach in accordance with their trust deeds. It would ensure that while such schools will continue to have regard to guidance issued by the Secretary of State about the teaching of marriage as it will be defined by the Bill, it does not prevent them, within the context of sex and relationships education, also, in the words of the amendment, teaching the tenets of the relevant religion or religious denomination concerning marriage and its importance for family life and the bringing up of children. Now, my Lords, it's important to stress what this amendment is not about. It is not about seeking opt-outs for teachers, for pupils, or schools of a religious character from teaching about marriage as the Bill defines it. I personally would have no part in proposing that. Nor is it about seeking so-called protections for schools or teachers from the need to promote same-sex marriage. Many in this chamber and outside, as I know from many conversations, still remain haunted by the ghosts of Section 28. To anyone who's feeling so haunted this evening, my Lords, I offer the rites of exorcism. Let me be crystal clear, this amendment is categorically not about turning back the clock to those regrettable times. It is about reconciling two principles which have been the cause of many heated debates in this House: the principle of equality in marriage and the principle of respect for religious freedom. The focus of the amendment is on schools of religious character and how teaching on marriage will and should take place once this bill becomes law. Now, an earlier version of this amendment was tabled in committee by my friend, the Right Reverend Prelate, the Bishop of Ripon and Leeds. During the debate on that amendment, it was unfortunate that the substance of the proposal was lost amidst extended discussions about protections for teachers, schools, and freedom from coercion about what to teach. I will address some of those misconceptions shortly, but for now, I want to ask your Lordships not to be distracted by matters that have already been gone over at length and settled. They are not any part of the aim or purpose of this amendment. This amendment seeks to bring clarity and to resolve a conflict between what schools of religious character are legally obliged to do on the one hand, to meet the terms of their trusts, and what they will be legally obliged to have regard to in terms of statutory guidance from the Secretary of State about the teaching of marriage on the other hand. The bill, left as it is, sets both legal obligations on potentially a collision course. The substance of my case for this amendment is that without it, governing bodies of schools of a religious character will be left in a dilemma as to how marriage should be taught, and may even be encouraged through their legal obligations to require teachers to teach according to the tenets of the faith, to disregard the Secretary of State's guidance altogether. And no one in this House, my Lords, not least those on these benches, would like to see a situation arise where schools of a religious character are left in any confusion or doubt, or where they might frame a policy about teaching marriage that ignores the existence of same-sex marriage entirely. That's why I hope this amendment will command the support of people on all sides of this debate. I shall not repeat in detail the points made by the Right Reverend Prelate, the Bishop of Ripon and Leeds, in committee. The situation can be summarised as follows. All schools of a religious character, whether the Church of England, Roman Catholic, Methodist, Jewish, or other faiths, of which there are several in my own diocese of Leicester, are legally required to ensure that teaching takes place in the school according to the tenets of the respective faith. Church of England schools, for example, are established on trusts that require them to provide education in accordance with the tenets of the Church of England. They are legally obliged to comply with that requirement in their trust deeds, and a failure to do so would result in the governors acting unlawfully. As far as teaching sex and relationships education goes, all maintained schools are required to have regard to guidance issued by the Secretary of State for Education under Section 403 of the Education Act 1996. That guidance says that pupils must, I quote, learn the nature of marriage and its importance for family life and the bringing up of children. I wonder if I could, my lords, just clarify the point here. The point here is the very specific area of sex and relationships education. The principal provision of Section 406 of the Education Act 1996 requires SRE to be given in such a manner as to encourage pupils to have due regard to moral considerations and the value of family life. Section 403 then builds on that general requirement by requiring the Secretary of State to issue guidance on the nature of marriage and so on, and requiring heads and governing bodies to have regard to it. So we're not talking here about teaching the tenets of the religion in a general sense, but in this very specific area of sex and relationships education and moral considerations and the value of family life. That's why this particular area impinges on the tenets of the religion in a way that education generally does not. And that's the reason to address this situation specifically. My lords, after this bill becomes law, the references in the guidance will of course be taken to mean marriage as the bill defines it, which, as anyone observing these debates will surely know by now, is not exactly how the tenets of the great majority of the world faiths define it. So this leaves schools of a religious character with two competing legal duties. One says that the teaching has to be according to the tenets of the faith. The other says that they must have regard to the guidance. And my lords, why might that be a problem? Some may wonder why schools cannot just teach both alongside each other in a sensible way. And that, of course, is certainly the approach we'd want to see in Church of England schools. But the crucial point is this: there are strong legal grounds to conclude that the obligation to comply with the terms of the trust deeds of a school of a religious character outweighs the duty to have regard to the Secretary of State's guidance. One is a duty to comply, and the other is a duty to have regard. Unless members of this House accept this amendment and resolve the conflict on the face of the bill, there is nothing to stop some schools of a religious character making a decision on legal grounds to set aside the guidance altogether. And I'm sure noble lords will be aware of the diversification of provision being pursued by the Department for Education and the potential for a wider range of providers to enter the system. And I contend that this makes it more necessary than ever to ensure that governing bodies are not tempted to set aside the guidance in this way. So, my lords, this amendment will give necessary space for schools of a religious character to stay within the terms of the statutory framework and significantly reduces the risk of them declining to teach about the changed legal nature of marriage at all. Now, my lords, in committee, many, including those on the front benches, questioned the strict necessity of this amendment. I hope I have addressed that point adequately. Others, including the noble and learned lords, Lord Leicester and Lord Pannick, argued against this amendment on the basis that schools will not be compelled to teach against the tenets of the faith, or that adequate protections existed already in domestic law. They are arguments beside the central point. Although there are protections in the Human Rights Act, it is surely the better course for Parliament to make Section 403 of the Education Act 1996 expressly compliant with that Act, rather than schools having to fall back on requiring the courts to make decisions about compliance. And while Section 403 also specifies that the Secretary of State's guidance must ensure that pupils are, I quote, protected from teaching materials which are inappropriate, having regard to the age and religious and cultural background of the pupils concerned, the provisions of that paragraph only apply to the religious and cultural background of the pupils. And my lords, in a city like Leicester, Many of our schools have pupils from many different religious and cultural backgrounds learning together. This amendment is instead concerned with the institutional religious character of the schools. Now, what is clear is that schools of religious character are going to continue to teach about marriage according to the tenets of the faith in any case, once this bill becomes law. The key question for your lordships is, should that fact be addressed within the statutory framework or outside it? Not only do we on these benches think that an inclusive approach is best for Church of England schools, we also happen to believe that this approach is in the best interest of all those who support the principles of this bill. My Lords, this amendment is necessary. It is moderate and it is, in my view, eminently sensible. I repeat, it is not about creating opt-outs and protections for church schools. It will not give licence to schools of a religious character to ignore the fact that same-sex marriage exists, or that it should be taught without due respect and sensitivity. In fact, quite the opposite. And it isn't going to undermine or threaten this bill in principle or in practice. My Lords, the day after the second reading debate and vote, the vote in which, incidentally, I abstained, I issued a statement as convener of the Lords Spiritual, which said it is now the duty and responsibility of the bishops who sit in the House of Lords to recognise the implications of this decision and to join with other members in the task of considering how this legislation can be put into better shape. My Lords, that statement came in recognition of the rapid and dramatic swing in the pendulum in terms of social and cultural norms which the passage of this bill has demonstrated. A wise Parliament and a wise government will, in my view, recognise that when the pendulum swings this far and this fast, there comes a moment when concessions designed to create a satisfactory space for adjustment to the rate of change to be accommodated is sound politics. I put it to the House and to the noble lady the Minister that much clarity and social benefit will arise from this amendment, and that the argument that it is unnecessary does not hold water, and that a sympathetic response for the Minister will go a long way to dispel the concerns of this bench. I beg to move.
Amendment proposed, insert the new clauses printed on the martial list.
To support the Right Reverend the Bishop of Leicester's amendment. Parents, we know, go to great lengths to get their children into faith schools. They are hugely popular. 30% of schools are faith schools. Parents value the ethos, the discipline and the character of these schools. They teach the importance of marriage for family life and for bringing up children. And of course that's nothing new. It's built into our existing law. As the Right Reverend Prelate has said, Section 403 1A of the 1996 Education Act requires the Secretary of State to issue guidance and ensure pupils learn, and I quote, learn the nature of marriage and its importance for family life and the bringing up of children. In the future, though, we know the word marriage in Section 403 will mean both opposite sex and same-sex marriage. So when the bill is enacted, it will change the meaning of the word marriage. Now, as I understand it, the amendment is designed to tackle a problem that will arise by reason of the wording in Section 403 1A that requires more than ensuring that children learn about the law of the land. This section puts an obligation on the Secretary of State to secure that children, again, I quote, learn about the nature of marriage and its importance for family life and the bringing up of children. It is those words that are of concern because they entail more than the teaching of fact or law. They require schools to teach that marriage is valuable and beneficial for family life and the bringing up of children. And as the Right Reverend Prelate has said, it could be in conflict with the Secretary of State's guidance. In this amendment, we merely want to ensure that schools with a religious character are able to continue ensuring that pupils learn about their understanding of the importance of marriage for family life, and that they're not prevented from doing so by the redefinition of marriage in Section 403 caused by this bill. It's a modest amendment, and it will alleviate the concerns of many schools, alleviate the concerns about the conflict which could arise, as the noble prelate, the Right Reverend Prelate, has outlined. Now, I'm sure noble lords will say it's simply not needed. That has been the argument that we've had for a lot of the amendments that have been put forward. But thinking about this, I was reminded of Voltaire, who said, "Define your terms. You will permit me again to say, or we shall never understand each other." I think that it is important that we do understand each other, that especially as legislators, that we are very clear about what we are considering to be the law of the land. The government last Monday saw no harm in actually redefining some of its terms, and previously we were told it wasn't necessary to clarify parts in the bill. But in committee, the government generously perhaps put forward amendments to further clarify the wording around the Public Order Act and also the definition of compelled, amendments which we consider have really improved the bill. So our aim is not to allow schools with a religious character to avoid teaching the law of the land. As the Minister rightly pointed out, and again I quote, such schools already teach about topics that may be considered sensitive, such as divorce, and they do so without issue. But we do think that all schools, including schools with a religious character, should teach the law, and this amendment has been very carefully drafted to ensure that schools will not be enabled to ignore any guidance requiring them to do so. It is not designed to prevent schools educating children about the law. On the contrary, we want schools to teach the law, to ensure that it is taught with clarity, is even-handed, and as they understand it, within the character and ethos of faith schools, without conflicting with the Secretary of State's guidance.
I understand the concerns that have moved the Right Reverend Prelate and the noble Lady Baroness Cumberledge, but I do think this amendment is inappropriate for these reasons. Section 403, which the amendment addresses, is concerned with sex education. There are many contexts where sex education raises religious issues, homosexuality, contraception, no doubt many more. I cannot understand why there is a need for a specific statutory provision in section 403 to address the impact of same-sex marriage on sex education when there is no need for a statutory provision to address other issues which may have a religious dimension. The Right Reverend Prelate referred to section 403 1A, which, as the noble Lady Baroness Cumberledge pointed out, says that the guidance to be issued by the Secretary of State must put sex education in the context of marriage and family life. But there is a very good reason why the guidance requires sex education to be put in the context of family life and marriage, and that is because sex education should not be taught simply on the basis of physicality. It should be presented, I'm sure all noble lords would agree, in the context of responsibility and the development of relationships. Surely, if and when sex education addresses homosexuality, it should equally be taught in that same context of responsibility and other relationships, and as a result of this bill, that will include same-sex marriage. And for this amendment to be adopted, I'm afraid, would run counter to everything else we're seeking to achieve in this bill.
Excuse me, my lords, I rise, not surprisingly perhaps, to give my support to the Right Reverend Prelate, the Bishop of Leicester, who moved this amendment with balance and with moderation, even though with a quiet passion. And I do not believe that the acceptance of this amendment can do any damage whatsoever to the bill that is shortly to complete its passage through your Lordship's House. We're not debating tonight the rights and wrongs of same-sex marriage as against traditional marriage. We are not rehearsing again the arguments that we specifically add extra definitions to two forms of marriage within the bill, but we are in this amendment seeking to give a degree of reassurance to those who are concerned at the enormous social change that the passage of this bill will bring about in our country. And there is no point in anyone denying that there is going to be enormous social change. Now, those parents who send their children to faith schools, denominational schools, whether they be Church of England, Roman Catholic, or any other faith, have a right to expect two things above all. One, that their children should be brought up and taught to understand the realities of the society in which they live. And so, of course, it is right, and the Right Reverend Prelate stressed this, for guidance given by the Secretary of State to be not only to be received, but to be followed. Of course, it is necessary that my grandchildren, and many of your lordships will have grandchildren, should be brought up to understand that Parliament has in its wisdom decided to effect a major change to the social fabric of our land. But if that change is to come about with a degree of mutual tolerance and understanding, and yes, good humour, then it's important that the second requirement, which parents look to, should be fulfilled. Namely, that their children should be taught the basic tenets of the faith. There need be nothing incompatible between these two aims. And I believe that the manner in which the Right Reverend Prelate introduced this amendment showed that that is foremost among the aims and objectives of he and his colleagues who sit on the Bishop's bench. And I believe there are times when we in this House can benefit from the guidance and wisdom of the Lord Spiritual. And I believe that tonight is one of those occasions. My Lords, the acceptance of this amendment will show sensitivity and understanding on the part of the government. It will do nothing to damage the cause of those who believe very passionately indeed, and I respect their beliefs, in the essential, not just rightness, but necessity for the legislation that is before us. And there are many who do believe that it's utterly necessary. I don't happen to share that view, but I do hope that when we have finished our deliberations on this bill, either next Monday or whenever we have to re-debate amendments sent back from another place, I do hope that there will be a spirit of mutual tolerance and acceptance of what we have enacted in all parts of this House. And that will call for a degree of charity on the part of all of us, whichever side we have taken in this debate. And so, if we can assist in laying the foundation for that spirit of charity tonight, as the bill approaches its final stages, we should do so. And so, my Lords, I warmly commend the amendment, I even more warmly commend the spirit in which it was moved, and I very much hope that it can be accepted without a division by your Lordship's House.
My Lords, I've spent some time to try and understand the issue raised by the Right Reverend Prelate, the Bishop of Leicester, in this amendment. As I understand it, the Right Reverend Prelate is worried about the teaching of marriage in faith schools and academies as part of sex and relationship education. The Right Reverend Prelate has explained his concerns, and in particular the conflict he perceives between the guidance issued by the Secretary of State and the teachings of the tenets of the religion as protected in the bill. I am sorry that I cannot support the Right Reverend Prelate in this amendment for many of the reasons that the noble and learned Lord Panic has outlined. I'm also afraid that if we agree this amendment, which I don't believe is absolutely necessary, that it will provide a foothold for those who are opposed to this bill to reopen old debates and old wounds. I believe it has the potential to be quite destructive in the hands of those who don't want this bill to succeed. Whilst I cannot support this amendment, I did, however, want to put on record my growing appreciation of the new direction of travel within the Church of England. My Lords, I didn't know that the Most Reverend Primate, the Archbishop of Canterbury, would be in his place. But anyone that heard his presidential address to the General Synod cannot have helped but to have been impressed by his thoughts on the matter. The Most Reverend Primate, after listening to our second reading debate, said he could not have failed to have been struck by the overwhelming change of the cultural hinterland. He said that predictable attitudes were no longer there, and he committed the Church of England to work tirelessly against homophobic bullying in schools that it runs and the children it educates. My Lords, I want to pay tribute to the Most Reverend Primate once again for fueling this journey, which I believe can only be of help to our society as a whole. My Lords, I also want to pay tribute to the Right Reverend Prelate, the Bishop of Leicester. I know this bill is not what the Church of England wanted. I know they'd rather this bill had not come about. But the Right Reverend Prelate, under difficult circumstances, has navigated very choppy waters with some skill and conviction. Finally, let me say to the Right Reverend Prelate, the Bishop of Leicester, it's not your amendment I fear. It's those who would use it against us and do the opposite of all that you want. That is the reason I cannot support this amendment, and I hope the Right Reverend Prelate will understand that. I also hope that Right Reverend Prelate will not test the opinion of this House, because I, like many in this House, have no appetite to vote against the Right Reverend Prelate for the reasons I've already said.
Rise to support the comments made by Lord Ali and Lord Panic, and particularly the compliments paid to the Right Reverend Prelates, both those present and those in the past who have been working on this. I wanted to raise a very slightly different issue. The Right Reverend Prelate raised the difficult issue that faith schools have this balance between a duty to comply and have due regard. And I absolutely understand that. And I wondered if it might be helpful just to read very briefly from Hansard of the Monday Just Gone, column 6, where we had in oral questions a question about the new sex and relationships curriculum. I asked a question about academies, but the answer refers to all schools, and what happens where you are not forced to comply with the SRE, sex and relationships education. And Lord Nash replied, my noble friend is quite right, academies are not obliged to teach sex education, although if they do, they have to have regard to the Secretary of State's guidance on these matters. I repeat the point that Ofsted inspects for all social, moral and cultural provision in schools, and we, the government, will be ensuring that it focuses on this point. And I think that the reason I wanted to raise that is I see a distinct parallel for faith schools in the same way that religious education is taught, where the schemes of work that the Church of England has for covering a range of other faiths are sensitive and educational but not promoting. And I absolutely see that parallel here, that you are not being required to promote, merely to educate. And I think often we get bound up in this idea that SRE only happens in sex and relationship education classes. But young pupils will ask at peculiar times, and therefore a school needs a policy. And again, I have seen many faith schools' policies on SRE that recognise that, and all staff are empowered. So I really hope that the Right Reverend Prelate does not press for this amendment, because I believe you have the protections you need in the Education Act as it stands.
I know, my Lords, that... I'm so sorry. Yep.
My Lords, I think that this debate has moved into a different manner of speech in virtue of the Noble Lord Alli's gracious response to the Right Reverend Prelate, the Bishop of Leicester. Indeed, if I may say so, there was graciousness on both sides. I hope that whether or not this amendment is pressed, and whatever the vote might be if it is pressed, that we could have some assurance from the front bench that the issue of the possible conflict between trust law and the directions of the Secretary of State, to which schools have to have due regard, could be given further attention, because I believe that if that happens, we could have a possible way forward with which we'd all walk. So I look to the front bench to have some possible assurance, if that is possible, on that area. Granted, the positive exchanges between the Noble Lord Ally and the Right Reverend Prelate, the Bishop of Leicester, my
Lords, I won't be too long. I'm grateful to the Noble Lord. I know that this amendment refers to all faith schools, but I hope I may be forgiven if I concentrate my remarks on the only faith schools I know anything at all about, and that is the Church of England schools. And I'm encouraged in doing so to some extent by the report I read of what the Prime Minister told the National Prayer Breakfast meeting, which took place recently in Westminster Hall. And I quote briefly from the report which appeared in the Times on the 26th of June this year, in which he said, in which the Prime Minister said, "It is encouraging that Christianity still plays such a vital role in our national life. It has had an immense historic influence in the development of our culture and institutions, and it motivates British people to wonderful acts of service and self-sacrifice. We are a country with a Christian heritage, and we should not be afraid to say so." Now, throughout our debates on this bill, frequent reference has been made to freedom of speech, to equality of treatment and esteem, and to the fact that marriage is seen and acknowledged to be the building block of society. Now, one aspect of marriage, up until now, which I think will change as a result of the passing of this bill when it becomes law, although its importance must still remain a significant feature in our life, that is that family life is a very significant factor in marriage and in the bringing up of children. And ideally, the family includes a mother and father, maybe siblings, maybe uncles and aunts, and hopefully grandparents. And grandparents do have a significant role in the nurturing and upbringing of children. So the aim of a family should be to provide a stable and secure environment for the nurturing of children. Church schools, in my view, and I'm sure this goes for schools, church schools of all faiths. Church schools can help families by providing moral guidance and a set of standards which they seek to have upheld. It is something, I think, of increasing significance in our life today, when the pressures on children and family life are so enormous. And we have in this House had several recent references to that in terms of video games and in terms of other aspects of pressure to which children are subjected. So the more we can hold on to standards which are enshrined in the values of faith schools, the better, I believe, it will be for the nurturing of children. And because of the change in the definition of marriage, which inevitably will follow the passage of this Act, it is very desirable, in my view, notwithstanding the observations of the noble Lord Panic, that these words in the amendment form part and parcel of the bill. Church schools should be encouraged to teach the tenets of religion concerning marriage and its importance for family life and the bringing up of children. Those are words which need emphasis over and over again, because there are many, many people beyond this House who are afraid that those principles of married life will be undermined by this bill.
Rise with very considerable trepidation and with humility, and if I may say so, with some dubiety in relation to this particular issue. I come from Welsh nonconformist stock, a Welsh Presbyterian, and my family have been Welsh Presbyterian for well over 200 years. I, however, appreciate and respect the Church of England, the position that it occupies in the history of this land, the position of status that it has as an established church, and indeed all faith schools. The question, however, it seems to me, as a lawyer, or I should say more accurately as an ex-lawyer, a retired lawyer, is this: is there a point where a faith school or a body operating under any trust is entitled, if it so wishes, to go contrary to a principle that has been clearly and specifically spelled out in an Act of Parliament? The answer to that, my Lord, must be in the negative. I don't know exactly what the circumstances might be in relation to this particular section under the Education Act 1996. If the noble and prelate is right and says this is no more than making assurance doubly sure, in other words, consolidating a line that is already there, I would accept this amendment. On the other hand, if it is a case of allowing, by this amendment, the whole principle that this bill represents to be endangered and imperiled, then of course one must oppose it. As far as the wording of the amendment itself is concerned, it seems to me to be very wide and to encompass all manner of possibilities. It says, as far as subclause 2 is concerned, nothing in subsection 1b, and that's a reference to the Act of 96, prevents teaching the tenets of the relevant religion or religious denomination concerning marriage and its importance for family life and the bringing up of children to registered pupils at schools which have a religious character. Does that mean, as it seems to me that it must mean, that a teacher in a faith school would say, of course Parliament has passed an act in 2013 in relation to same-sex couples, but we believe that it's wrong. Everything that our church or denomination represents suggests that it's utterly wrong. Not only wrong, but evil. What does that create? That is not, it seems to me, a license that can be allowed to any body at all operating within the democratic principle of the rule of law and the rule of Parliament. If I'm wrong about that, I apologize. If I'm right about that, then it seems to me the amendment should be rejected.
I am seeking to obey the rules of the House, so not to repeat things that were said at committee stage. I'd like to begin by talking about the fact that faith schools teach children. I say that because my county of Lancashire, where I chaired the Education Committee for 10 years, had the largest percentage and number of faith schools. I would, my lords, like to begin by pointing out that not all parents in counties such as Lancashire choose faith schools. Faith schools are the nearest schools, and actually parents can't choose to have their travel paid to a non-faith school, although they could, to a faith school. But noble lords have referred to the fact, that was the case, Baroness Cumberledge, that the option for faith school education entitled travel. However, what I would say is that faith schools seek to teach the whole community, wherever they are. I've been around for so long that I remember Faith in the Cities, Geoffrey Duncan, and those who argued that the role of faith schools was to teach the whole community in which they were located. Some of the faith schools in Lancashire had a majority of pupils, and probably still do, who are Muslim pupils. But those schools taught the children. That was the issue, the teaching of the children. And the confidence of the parents, those Muslim parents of those children, was a confidence based in the fact that the school would respect the views of the parents as well as teach the children about the beliefs of that community. Some notable lords in this debate have spoken as though this legislation is going to create a new set of circumstances in the communities and the families, the relatives, the friends of the children who come to the school. My lords, it isn't. This legislation is recognising what is happening in our communities. It may be giving a new name to civil partnership, but those relationships actually exist now in the families, the homes, the communities of the children who will be in the schools. I have tremendous respect for the aims of the Right Reverend Prelate, the Bishop of Leicester. Actually, many years ago, the Bishop of Leicester was somebody who gave a lecture at my wedding on the importance of marriage and education, but it wasn't the Right Reverend Prelate who's with us tonight. I've been married too long, my lords, for it to be that young Right Reverend Prelate. But what I would say is that I listened very carefully. I didn't always listen to him when he was in office in government. But the noble Lord Baker explained that we don't need to change the 1996 Act to secure the benefits that the Right Reverend Prelate is seeking to achieve. Some noble lords have talked as though our schools are places where ideas are promoted. My lords, even with young children these days, but certainly with 13-year-olds, they will ask questions, but the idea that a teacher can go into a classroom and tell children at the age of 13 what to think and what to know is pretty ludicrous, because those children are growing up in the world, they recognise the world. Actually, we are recognising the world of those children who recognise it. A 12-year-old said to me, "What are you doing in the House of Lords?" I said, "Same-sex marriage." Why should there be any argument about that? Who's arguing? I said, well, some of the people from religious backgrounds. The child said to me, "You know, I could go off God." That's a child in a church school in rural Essex. I said, well, you really mustn't blame God for what some of the religious followers say. It isn't always God who's wrong, it may be their interpretation. My lords, I hope that the Right Reverend Prelate will not feel the need to press his amendment. I hope that the noble Baroness, the Minister, will be able to assuage any fears he feels. And in closing, my lords, can I say that I too wish to say how important it is that all children in all our schools, and I'm certain that the denominational schools feel this, ought to be able to love and respect all members of their communities and families. Those children know those people are there now. My lords, perhaps we're a bit late recognising it.
Friend will be able to address and clarify for us the perceived conflict between the guidance and the documents under which the churches, faith churches, have to operate, names of which I forget. My lords, because it does seem to me that actually what these amendments ask is not the very big thing that it is being suggested that it is. It must surely be right for church schools and other faith schools to teach about the world as it is and as it changes, and the world is, and the world is changing. But their faiths do not necessarily change at the same rate, or indeed at all. And they are part of the world, and therefore they must be taught. What I think is at issue is whether there can be recruiting or promoting of the particular faith, and it needn't be Christianity, or the particular orientation, and it needn't be heterosexuality. That is what it is issue, and I would like my noble friend to assure us that there is a legally proof way through this which preserves the right of faiths, all faiths, to explain to children what the tenets of that faith are, whilst at the same time addressing the actual world which the children will grow up into without being fear of being in breach of the law. And I believe I'm right in saying that the original concern of the Right Reverend Prelate was not so much with teachers as actually with the foundations. We haven't heard so much about them. But this has to be available as a protection to the foundations of the schools, and it should not, in my view, be phrased in such a way as to threaten in any way the intentions of this bill.
My Lords, I wonder... I'm so sorry.
My Lords, I rise to support the Right Reverend Prelate's amendment. Neither the Equal Marriage Bill nor this amendment changes the doctrinal position of religious organisations. In fact, the bill recognises in clause 1.3 that the doctrine of the Church of England remains that marriage is the union of one man and one woman. This amendment is about religious educational institutions, as the Right Reverend Prelate has said, operating within the ethos of their faith and charitable foundations, whilst giving due regard to the breadth of opinion on the nature of marriage, including equal marriage. It ensures a true diversity whilst allowing for a particular perspective to be honoured. The Human Rights Act, Articles 9 and 10 of the European Convention of Human Rights and Section 403 of the Educational Act 1996 may seem to preserve religious freedom or the exercise of discretion in selecting materials for SRE teaching, but the legal process proving that if these freedoms are challenged might be lengthy and very expensive. It is better to amend to resolve the conflict between different legal requirements at this stage. This amendment will protect and promote religious freedom and thereby enable the ongoing contribution to the common good of the religious traditions and diversities of this country. Marriage makes a great contribution, a fundamental contribution to our society. It is better that all views are included and encouraged for all to flourish. There is no homophobic Trojan horse in this amendment. Rather, there is a recognition of true diversity of opinion. God willing, we will move beyond homophobic attitudes. This amendment is actually one way to do this, ensuring that true diversity is taught in a faith context and providing formation for nearly 1 million children for which the Church of England is responsible in teaching in its schools.
My Lords, I've sat very patiently through much of the debates that we've had within this bill but didn't speak at committee stage. I'd like to support the Right Reverend Prelate's, the Bishop of Leicester's amendment, because I think what it's asking us all, and particularly from the Minister who's going to respond, is seeking clarity, because clearly in passing this bill, and I'm sure this bill will pass, we are actually changing the law. And therefore, I don't accept some of the contributions that have been put forward that there is no need for it, that it is actually covered, because I don't think it is, and therefore I do think that this amendment is extremely important. Secondly, I have to question the fact why so many parents, and many of them from no faith at all, choose to send their children to faith schools. What is it about faith schools that they think that that child will gain? And I have to say that many people that I speak to will say very sensibly, as far as they're concerned, we don't have a particular strong faith. We have a faith, but not a particular strong faith. But there is something within the faith schools teaching that is extremely important, and in that comes into marriage and all the sorts of things that we've been talking about earlier on. So to me, this amendment really is seeking clarification. It's seeking to see whether we can still teach the religious freedoms, and on that, based on marriage particularly, between one man and one woman. And I must admit, I was grateful to listen to Lord Owley's contribution earlier, but extremely dismayed when he ended up by saying, but it could be used against us. And I'm thinking, against whom? This bill is actually an inclusive bill. It might be something that some of us are struggling to come to terms with, but actually to use it against what is being proposed in this bill I found deeply concerning. I think the Church of England schools and other religious faith schools do need to know where they stand with regarding to their legal requirements, and I'm sure that members of the teaching staff will do that in the best possible way that they possibly can. But if one goes further than just marriage and actually looks about children and bringing up of children, the nurture of children, one of the questions I'm sure that will be posed by children is, who's my mum and who's my dad? And I mentioned this earlier once before in committee in a very brief interjection that I had, because it's something that won't go away. A child is naturally going to say, who is my mum and who is my dad? And in same-sex marriages, that's something that will have to be overcome. And I think from the teaching point of view, that the people who are teaching do need to be very clear as to what advice is being given to them on that particular topic. We've talked a lot about the theory and the well-being of the move towards same-sex marriages. But many of my emails have actually, and I'm sure other people's the same, reflected on their concerns about the implications that has for the children. How will children react? And how will that balance out? And just briefly, I wanted to say that I do think this amendment, which I think is very moderate and I don't think divides the House in the way that some of the others perhaps earlier on have looked for special compensation or special thoughts, is a very genuine attempt to try and get clarity on where we are and how we can go in the future. And I do hope that the Minister, rather than just giving us, as we've sadly had over many, many issues raised, just a no answer, will actually be able to enlighten and help us in the way ahead, because that's what we're after.
My Lords, I hadn't intended to speak, and I know it's unusual for there to be as many interventions from these benches, but I do believe there's one point that has not yet been quite as fully made as it might have been. And I was prompted to these remarks by listening to the noble Baroness Farringdon. I have to say I agreed with most of what she had to say, but I was led to a very different conclusion. I fully agree with her understanding of church schools and what they exist for. For that reason, I've always refused to fall in with lumping church schools into that easy category of faith schools. The Church of England schools, and this is particularly true of the primary sector, exist as part of our mission to the whole community. We are there to serve the community as a whole. And to that end, and I speak as a former teacher, a governor, a chair of boards of education, to that end, our schools have always sought to hold to an integrity which involves being true to the Church's teaching and to trust law and true to the law of the land. Now, this is absolutely at the heart of the dual system, which has underpinned much of the education of this country for a very long time. Now, what this bill does, though, is almost for the first time, it introduces in a novel way a potential conflict between trust law and education law. And what the amendment being put forward by my friend, the Right Reverend Prelate, the Bishop of Leicester, does, is to seek to reconcile that potential conflict on the face of the bill. Now, that does seem to me to be hugely important. I'm not a lawyer, but I do know that there is a recognized branch of jurisprudence which goes under the heading of conflict of law. I also know that the study of that subject, conflict law, teaches that where the conflict between different laws has to be resolved, it always raises questions of jurisdiction, and normally raises questions of supra-jurisdiction, a jurisdiction greater than the two parties to the conflict. Now, there's a deep concern, my lords, in this country at the present time about the loss of jurisdiction from the High Court of Parliament. And for me, I would enter a final plea to the Minister and to all front benches to consider the advantage of having a potential conflict between trust and educational law dealt with on the face of this bill, rather than leaving it to a jurisdiction which may well be beyond the High Court of Parliament.
My Lords, I too pay huge tribute to the Most Reverend Primate, the Archbishop of Canterbury, for what he said in his first speech to the General Synod as head of the Church and the Anglican Communion about the changing attitude towards gays, the need to fight prejudice against homosexuals, and the fact that the Church looked, in his words, out of step. I'm also grateful to him, to the Right Reverend Prelate, the Bishop of Leicester, and the Right Reverend Prelate, the Bishop of Ripon and Leeds, for the way in which they have considered this bill. I have absolutely no doubt that they will ensure that Church of England schools will teach about same-sex marriages in a factual way without any prejudice, and that they will naturally also teach about their own views of marriage as is right and proper. I also know that they are absolutely against any opt-outs, and indeed I would say to them that I wholeheartedly agree that marriage is a very good thing for society, and that should be celebrated. I understand the concerns that have been expressed about the pace of change by both the Church of England and the Catholic Church, with whom I had an excellent meeting last week, for which I am grateful. It is true that it will take a while for some people to get their heads around same-sex marriage, but, my Lords, they will, and they will be comfortable with it. I've had several conversations over the weekend with people who have in the past expressed concern but have changed their views already. And I have to say that both the vote in this House and the debates in this House and the speech by the Most Reverend Primate have had a real impact on those people. But to return to the issue at hand, we have said throughout our deliberations on the bill that in our view, these amendments or amendments pertaining to teaching and to faith schools are not necessary. Teachers are already able to teach according to their religious tenets. That will not change, and neither will the ability of faith schools to operate within the tenets of their faith. Some people, whilst generally accepting that point, say why not give comfort to those who are concerned by putting something onto the face of the bill. But I do understand that the Right Reverend Prelate is making a point about a legal point. Others, like the Bishop's benches, want to ensure that the legal and religious definitions of marriage can be taught alongside one another in an appropriate way. And I'm well aware and grateful to the bishops that they do not agree with those who are seeking protections. I also know that the reasoning behind the amendment is to give space for schools of a religious character to stay within the terms of the statutory framework and to reduce the risk of them declining to teach about the changed legal nature of marriage at all. I warmly welcome the fact that the Church of England is clearly determined to pursue this inclusive approach for its own schools and to commend it to others. Indeed, that is exactly what should happen under this bill as drafted when it becomes law. I realise that the Church of England and many in the Catholic Church would not wish to see any return to those dreadful days of prejudice. But, as has been said many times, prejudice still exists. I know strong professional men and women who are still hesitant, even unwilling, to come out at work. As we do not believe that this amendment is necessary, and because we do not want to risk the way in which it could be interpreted by those who are intolerant or homophobic, I regret that we cannot support this amendment. However, as other noble lords have said, I hope that whilst not accepting the amendment, that the noble Baroness, the Minister, will be able to give the necessary reassurance and clarity to the bishops and to all members of this House and to those of other faiths. Yeah. Well, may I start also by paying tribute to the Most Reverend Primate, the Archbishop of Canterbury, and also to the Right Reverend Prelate, the Bishop of Leicester. And I'm grateful to the Right Reverend Prelate for the statement that he issued after second reading, and which he referred to. It was an important statement, and it was one that I was certainly grateful for. During the last few months, the Secretary of State, my right honourable friend Maria Miller, and I have enjoyed some very constructive and productive discussions with both the Most Reverend Primate and the Right Reverend Prelate and their officials on a range of matters. And we've enjoyed some really good conversations and discussions, and I've valued them, and one of the things I've valued a lot is having the opportunity to get to know the members on the bishops' benches better than I had done up until to that point. And in our discussions, we've obviously included their concerns about religious freedom for faith schools, which is what the Right Reverend Prelate talked about in moving his amendment, and I'm certainly grateful to him for the very careful way that he did. In responding to him and to all of the noble lords who have contributed to this debate, let me start by saying that, or by stressing actually, that schools with a religious character provide an excellent education for their pupils whilst reflecting their beliefs across the curriculum, including in sex and relationship education. And we really value the work that faith schools do. And I would like to make clear that there is absolutely nothing in this bill that affects faith schools' ability to continue to do this in the future. The Right Reverend Prelate, the Bishop of Leicester, has explained that there is a specific concern, and indeed this has been echoed by other noble lords contributing tonight, that this concern that has been expressed is that without this amendment, a potential conflict could arise between a school's duty to teach its faith ethos and its responsibilities under Section 403 of the Education Act. And I really do understand the importance of this issue, and I can assure noble lords that the government have considered it very carefully indeed. Noble lords will have heard me say on many times during the passage of this bill that this is an area that we are considering, and we have done so with great care. But having done so, we do believe that this provision is unnecessary. And in coming to that conclusion, and in saying that clearly, I need to try to reassure the House why we have come to that view. In schools of a religious character, teachers deal admirably with teaching about marriages which may not be recognised as such according to the tenets of the relevant faith, for example, as an example has already been given, marriages of divorcees, or indeed, for some religions, mixed faith marriages. In order to take account of this distinction, they already interpret their duties under Section 403 of the Education Act according to their religious tenets. Faith schools must take the guidance into account when developing their policy on sex and relationship education, and in doing so can also take into account other matters, including in particular relevant religious tenets. This is already recognised by the current legal framework. And if I can just expand a little bit more on this, and I will respond specifically to the question put to me as well by the Right Reverend Prelate, the Bishop of Guildford. But to have regard to means just that. Having regard to a provision does not mean that it must be followed assiduously, should there be a good reason for not doing so. This was made clear in the decision of the Privy Council in Barber versus Minister of Environment in 1997. Faith schools must take the guidance into account when developing their policy on sex and relationship education, and in doing so can also take into account other matters, including in particular relevant religious tenets. A relevant faith tenet is a perfectly sensible reason in this context, and one that the current legal framework recognises. Now, as I say, the Bishop of Guildford and also the Right Reverend Prelate, the Bishop of Exeter, sought assurance that there is no legal conflict between a school's trustees and the obligation of them in relation to the guidance. And I can happily give that assurance. The requirements placed on faith schools by their trustees are a matter such schools must take into account when determining their policy on sex and relationship education. The requirement on schools to have regard to the guidance ensures that they can take other relevant factors, including, of course, their trust deeds, into account. They are not required to follow every element of the guidance, but simply to have regard to it. But as well as being unnecessary, we are concerned that the amendment could be unhelpful. As is noted in the Joint Committee on Human Rights report following its scrutiny of this bill, some are making the argument for clarification in this area as a way of protecting faith schools from being required to promote or endorse marriage of same-sex couples.
Now, we are clear that no school is under any duty to promote or endorse any particular view about marriage. And I recognise what the Right Reverend Prelate, the Bishop of Leicester, said about ghosts of the past. But we have heard in our debates over the past few weeks the real concern gay people still have when it seems a duty to explain might equate to promoting gay marriage. That seems an argument against teachers being able to inform children in an appropriate way that we are not all the same. Now, my noble friend Lord Cormac, in his contribution, talked about the children of families, the parents who send their children to faith schools, and the importance of those parents attached to their children being able to learn about the tenets of their faith at school. And my noble friend Lady Byford made a similar point and stressed that that was the reason behind the decision that some parents make in sending their children to faith schools. And my noble friend Lord Cormac said that he hoped that we would be able to give some comfort to those who need it in face of enormous social change, I think was the comments that he made when he was making these remarks. And I understand the point that my noble friends are making in this regard. As I know, I hope he will remember, I made a point right back at second reading where I acknowledged that we all deal with change at a different pace, and it's perfectly reasonable for people to need some time to adjust to social change. But I don't think that this amendment and what it will achieve is the way to give people comfort in order to adjust to the social change that is happening in society. And the point I would make, which I don't think has been made so far in the course of our debate this evening, but when we talk about parents and their decisions that they make to send children to faith schools and why they do so, that some parents who send their children to faith schools are gay. So I don't think that we should assume that all parents who are sending their children to faith schools are straight couples. And I think that's the kind of the very sort of sensitive issue that we're dealing with when we're actually debating this kind of matter. I know that the Right Reverend Prelate and all of his colleagues, because I understand absolutely that their strength and their conviction and their complete sincerity in bringing forward this amendment. But I'm trying to explain how it is complex in terms of how it gets interpreted and the effect it has on what we are trying to achieve, all of us, I think, which is get to a point where we have an accepting and tolerant society where we all understand and respect each other. I do, however, note that and understand that whilst the government does not believe there is a need to legislate on this matter, that there is a desire for additional clarity for all schools and teachers. And as I have mentioned several times during our debates over the last few weeks, we have secured the agreement of the Equality and Human Rights Commission to work with the government to review the Commission's guidance and statutory codes of practice. And I don't think I've ever been as clear as I need to be that in the codes of practice that they produce, there is a specific code of practice which is for schools and teachers, and this guidance is about the Equality Act 2010, and what the EHRC is going to be doing is to reviewing that guidance in light of this bill becoming an act. So there will be new guidance from the EHRC which will go out to schools specifically to help ensure that there is clarity around the fact that belief that a marriage should only be between a man and a woman must be respected. And that's something that we know is very much wanted by people, and that is something that we are very much committed to providing. The Department for Education will also work with relevant organisations that provide advice on the teaching of sex education, as well as the Catholic Education Service and Church of England Education Division, to ensure those organisations' advice to schools makes clear that faith schools are able to explain relevant religious tenets when teaching about marriage. Now, I recognise, of course, that my response will be disappointing to many noble lords, not just to the Right Reverend prelates on the Bishop's bench. My noble friend Lady Byford referred to concessions, and I am sorry that this is not an amendment that we can accept. We have made several amendments to the bill and accepted concessions, the change to the Public Order Act being one, and the other that we talked about on Monday around clarification of the word compel. And we felt able to do those because we thought it was possible to clarify and to give people that greater confidence they wanted that the protections that we have in the bill are robust. But as I said at second reading, we would only make those changes where we were confident that by clarifying we didn't introduce something else that would then call into question what we are trying to achieve. So it's on that basis that we have come, after much careful consideration within government, to the conclusion that we have. And as I say, I recognise that this will be disappointing news, but I hope that by being as clear as I can be about the other efforts we will be making to ensure that there is clarity in schools, that is of some comfort to the Right Reverend Prelate who has moved this amendment, and to all those who spoke in support of it in the chamber this evening.
My Lords, I'm grateful to all those who've spoken in what has been a serious and gracious debate, and I know I speak for my friend, the Most Noble Primate, in expressing gratitude for the tributes that have been paid to his leadership, particularly at the General Synod and in so many other ways, a leadership for which we are growing more and more appreciative, both in the Church and in the nation. I want to thank the Noble Baroness, the Minister, for the care and attention, the accessibility and the understanding that she has unfailingly shown in the conversations we've had leading up to this debate, and also the Noble Baroness Royal also for helpful conversations in which I think we have been able to make clear our genuine concerns. My Lords, I think it was Paul Newman in Cool Hand Luke who said, what we have here is a failure to communicate. And at times in this debate, it has felt a bit like this, because if you listen very carefully to what was said in support of this amendment, what I'm trying to do is to ensure that this bill prevents faith schools opting out of teaching about same-sex marriage. We really are on the same side of the argument, and it does seem at times as though that message hasn't been heard. I wonder if I could just make one or two specific responses to certain noble lords. In response to the noble Lord Panic, I'd want to say that Section 403 is the only education provision that refers to marriage, and it is the meaning of that word that is being altered by this bill. We don't need to amend other legislation, as he has suggested, because other education legislation does not deal with marriage. The amendment does not run counter to the bill, therefore. It says that there is room for both religious and legal understandings of marriage, and that they can live alongside one another in religious schools. To Lord Eccleston Morgan, I would just clarify the question that he put to us. The position is that there is a difference between a requirement to have regard to statutory guidance and an obligation to comply with the terms of a trust. The latter is an unqualified legal obligation. The former is a duty to have regard and is therefore weaker. Hence the danger of some religious groups going their own way if the potential conflict is not resolved. That was the point I was trying to make. To the Noble Baroness Farrington, the concern is not that the bill is changing what goes on in homes and communities. The point is that the bill changes the law, and we need to ensure that the new law and teaching about marriage in church schools can happily coexist. And so I believe that this bill does not, this amendment does not in any way erode, undermine or attack the central purpose of the bill. Rather, it strengthens it. But having said all that, my lords, it's late and I know we have much more work to do. The Noble Baroness, the Minister, has given what I take to be an undertaking, that if it does come to a trust deed, the government recognises, to a conflict, that the government recognises that the trust deed overrides the requirements of the Secretary of State's guidance. And on that basis, my lords, I beg leave to withdraw this amendment, and I reserve the right to consider the implications of this debate further in case we want to bring some of this back at third reading.
Is it your Lordship's pleasure this amendment be withdrawn? The amendment is by leave withdrawn. Amendment 95A, the Earl of Listowel.
I rise to move this amendment, which has the effect of putting a duty on the Secretary of State so that he must provide evidence-based information to teachers on the implications of the measures in this Act for the raising of children and the promotion of family life. And the purpose, my lords, of my tabling this amendment is to obtain a statement from the government of their assessment of the impact of same-sex parenting on child development. I'd really appreciate a careful and thorough assessment from the government, perhaps with the aid of an appropriate mental health professional and a statistician, to look across the research we have currently on this issue and produce a report. A letter in the first place to me, a place in the library would be very welcome, but perhaps it might be at the basis of further work which could also help in terms of the support for schools that the Noble Baroness Minister was just talking about, in terms of helping schools to manage this new piece of legislation. Lords, can I just briefly, and I will try to be brief given the hour, thank the Minister for kindly meeting with me at committee stage to discuss my concerns. It was very generous of her to do so. And may I also thank, and I see her in her place, the Noble Baroness Lady Thornton, for her kind words on my work in the course of Monday's business. My Lords, for me there seems to be a twofold challenge that makes me ask these questions. Firstly, and I know this is debatable, this bill may give a significant inadvertent nudge to same-sex couples, to teachers, to doctors, and to child family and family social workers. We agree, I think many of us, that marriage has traditionally been seen as the last and very important step before one starts a family. So, for many professionals, this bill might seem to encourage them to think that the same-sex parenting is just as good, or even better, than heterosexual parenting, and nudge them towards, for instance, giving IVF, making placements with same-sex foster carers or adoptive parents, or teaching children same-sex parenting is no longer problematic or debatable. And I remember, for the context of this, behind this is also, your Lordships may recall the Human Fertility and Embryology Bill a few years back, where the requirement for clinicians to ensure that those taking part ensure that it kept the interest of the child in having the contact with a father figure, that duty was removed in that particular bill. So to me, I'm just afraid of a gradual erosion of that traditional norm, which was that, you know, the best situation for every child is to have a mother and a father. Most, the second difficulty is around the research. The phenomenon of same-sex parenting is relatively new, and research only stretches back about 30 years. Typical problems are that their samples are of small number and too narrow, and that duration of study is too short. And another problem is the science is undertaken under the pressure of polemic from both sides. There are people here who desperately want this to be proven to be absolutely non-problematic, and there are other people who desperately want this to be shown to be just the wrong thing to do entirely. And the truth lies somewhere in between, and is sometimes hard to find. The Noble Baroness has alluded in the past to, I think, the research from Melbourne in Australia, a cohort study, the largest cohort study so far, of about 400 families, I think, about 750 children perhaps, which is now looking at them at the age of 17, I believe that's reached. And it is encouraging that such large cohort studies are taking place. But again, I would just say we need to look at these very critically and look at the samples that they're taking. I will come to the detail of what might be considered as we examine that research critically. But also, I think on Monday, the Noble Lord Winston pointed to the research by Professor Susan Gollenbach at the University of Oxford in terms of pointing to positive outcomes for children in same-sex parenting arrangements. And that is very interesting research, and of course I'm sure we all are grateful to the professor for this important piece of research, which is perhaps the most important in this country. But it is of a small sample. I think, from memory, I haven't looked at it for a couple of years, but I think it's about 60 families. So it's a small sample. Again, it's only to the age of 18, so we don't know what happens to the adult children of same-sex families. So the point I'm trying to stress is it's still early days, and the evidence needs to be looked at very critically. And what I notice, I think we all see that there seems to be people jumping too soon to a conclusion on what that points to. And my lords, the evidence, looking at the evidence matters, because we are dealing with a phenomenon that our past experience suggests may be problematic for children. We know from past experience that boys growing up without fathers are at greater risk of poor outcomes than those with fathers. We know that male same-sex relationships can be of brief duration, and that unstable parental relationships are harmful to a child's development. And of course, there is the common sense argument. I think many of us would just think it's common sense to expect that children will do best if they have a mother and father. And I listened with great interest to the Noble Baroness Lady Farrington quoting a child in the earlier debate. Recently meeting of foster carers yesterday, in fact, they gave me an example of a 5-year-old who was offered by his social worker 2 fathers, and his comment was that that would be just silly. So there is also that, if you like, common sense argument. So, my lords, I'd just like to quote from an academic whom I think has written a very interesting piece assessing the evidence so far, and this is Lorraine Marks of Louisiana State University, and her paper, Same-Sex Parenting and Children's Outcomes, a closer examination of the American Psychological Association's brief on lesbian and gay parenting, and this was published in the Journal of Social Science Research on July 2012. In her conclusion, she writes, "We now turn to the overarching question of the paper. Are we witnessing the emergence of a new family form that, unlike cohabiting, divorced, or single-parent families, provides a context for children that is equivalent to the intact family?" Even after an extensive reading of the same-sex parenting literature, the author cannot offer a high-confidence, data-based, yes or no response to this question. The data are insufficient to support a strong claim either way, and thus insufficient to produce a definitive binary statement. Such a statement would not be grounded in science. Representative, large sample studies are needed, many of them, including high-quality longitudinal studies. Although some same-sex opponents have made egregious overstatements, and conversely, some same-sex parenting researchers seem to have implicitly contended for an exceptionally clear verdict of no difference at all between the same-sex and heterosexual parents since 1992, a closer examination leads to the conclusion that strong assertions, including those made by the American Psychological Association, were not empirically warranted. I apologize for quoting at such length, my lords, but I hope that may have been helpful. And she goes on a bit further about specifics. The Minister has a copy of the report. My lords, in conclusion, I just repeat that same-sex parenting is a new phenomenon with potential important consequences for children. I recognise that the Minister disagrees with my concern that this bill is a cue, perhaps, for people to be less for promoting or for encouraging the notion that same-sex parenting is no longer a matter of some, with some issues around it for people. I understand that, but what I would be really grateful to the Minister if she could is to write to me with an analysis of the current evidence, perhaps with the aid of a statistician, a relevant mental health professional. My noble friend Baroness Hollins is the former president of the Royal College of Psychiatrists and is currently, I think, or has just left the role of being the president of the British Medical Association. So she might be able to advise someone who could help the Minister in reflecting on this research. I'd be most grateful if the Minister could help with this sort of assessment of the effect of same-sex parenting on child development, and I look forward to her response.
Is the Noble Earl going to move his amendment? Thank you. Amendment proposed, insert the following new clause as printed on the Marshall list.
My Lords, my maiden speech in your Lordship's house, which you all remember, I'm sure, was a 3-minute speech on a motion put forward by the Noble Earl Listowel about support and counselling for young homeless people. It was 2 minutes more than I needed to know to say what I knew about the subject. But ever since then, the Noble Earl Listowel is somebody to whom I've paid the utmost attention, and his consistent devotion to the cause of children in this house and their well-being is an example to us all. He never ceases to give up campaigning for that, and he's doing so again today. I want to agree with him only to the extent that I think it is important that in future that there be research into the effects of this bill and into families which come into being when this bill is passed. I disagree with him, I think, because I think I detected in what he said that he starts from a base position of believing that somehow this is going to be bad. I don't necessarily. I think that this is a very hopeful bill, a bill which will bring a great deal of stability to families in future, families which have not had stability up until now. I think it's very helpful that the Noble Earl led us into thinking about these matters. So I was sitting thinking during the last debate how much of a change that this bill is going to bring about. When I was at school, nobody ever talked about being gay at all. If they did, they only talked about it at best in terms of a joke, but quite often in pretty horrible terms. And nobody in their right mind would talk about being gay. We didn't. And actually what happened to people of my generation was that in order to live the lives that we felt we had to do, we had to go away. Lots of us went off and lived in other places. That's not going to be an option for many young people, gay people in future. And that is why it is so important that in the communities in which they live, they are understood, they and their families are understood and accepted. And schools, and I include in that church schools and faith schools, are going to have a very, very important part to play. The Noble Earl is right. There is very little research into these issues already. Not least because there haven't been that many families who've been able to take part in the research. And what research there is, quite often is seized upon and used in a very partial way, either by those of us who take the view that I do, or those who take a more cautious approach. I do think that Professor Gollenbach's work is of the highest level of peer-reviewed research. She may be misinterpreted for different purposes at times, but I think it is the beginning of an important piece of work. I think it is also interesting that organisations such as Barnardo's have begun to look at the effects of earlier legislation on children. So I as ever, I take my hat off to the Noble Earl Listowel for having children first and foremost. I don't think this amendment is necessary. I don't think the Noble Baronesses would be able to accept it. But I'm glad that he has raised the issue and put it on the agenda for social researchers in future. He's right. This legislation deserves to be researched and tested just like any other.
The Noble Earl reminds me of, has the same effect on me as Tony Benn. And whenever I listen to Tony Benn, I'm always convinced. I believe him. He's amazing. And then when I walk away, I realise he said the opposite of the thing that I believed, and it was wrong, in my view. And the Noble Earl believes that children brought up in same-sex relationships will do much less well than those brought up by their biological parents. And it is that central premise that the Noble Earl comes from, and everything he has put forward is about proving that premise. The Noble Earl's intervention in Amendment 1, when the Noble Earl supported 2 classes of marriage, and in Amendment 46, when the Noble Earl contended there was no definitive research on the subject of children in same-sex relationships, and said he believed the arguments were finely balanced. It seems strange to me, given the Noble Earl believes there's no research, no definitive evidence research, how the Noble Earl can then ask the Secretary of State to provide evidence-based research as part of their guidelines to teach. If there is no evidence-based research, how can the Secretary of State be using evidence-based research to inform their guidelines? My Lords, I think it's also worth reminding, which the Noble Lady Baroness Barker did, of what Lord Winston, who's now in his place, said in column 28 in the report on Monday. And I quote, "Research on children who are being raised by people who are gay, either lesbian or homosexual, there is now a large and incontrovertible body of research evidence, particularly from Professor Gollenbach of the University of Cambridge, which shows that on average such children do better than children who were born in the normal way of current marriage." The central point is there is no evidence-based research at worst. At best, it doesn't support the Noble Earl's premise. So I have to do what I always do with what Tony Benn says. I have to nod and smile at the Noble Earl, say I recognise his contribution and value it, but I think it's nonsense.
Yes, great.
I think if I might just come to the Noble Earl's aid to some extent, I would like to support his request for evidence-based research and that the evidence presented should itself be tested, as I am well aware of a body of research which was put forward to the government during its initial inquiries before this bill, which was very seriously challenged, apparently by well-qualified people. The challenge was never answered or rebutted, and I will be happy to write to the Noble Minister about this because I think it's something that should be looked into further. But what I'm saying is that where there are advocates of a cause who are commissioning research or presenting it, it is just as well to test it very carefully before taking it as valid.
My Lords, I just rise briefly to say that in the next amendment I will be producing some evidence-based research which very much supports the concerns of the Noble Earl of Listowel.
Lords, could I just say I agree entirely with everything that's been said by the Noble Lord, Lord Alley, but the concern of the Noble Earl Listowel is the implications of the measures in this Act. I can see no reason whatsoever for thinking that the interests of a child being brought up by parents in a same-sex marriage could be any less favourable than the interests of a child being brought up by parents in a civil partnership. And I would have thought that the stability and the status of a marriage would be as beneficial to the child as it will be to the partners of the same-sex marriage.
My Lords, if I can just very briefly build on Lord Panick's comments. I mean, we're often obsessed with a view of normal, as if in every classroom in the land all children come from what was a traditional normal background. But I know from the children who I come across daily in schools that they know from their own experience that their friends come from single-parent families, whether through bereavement, divorce, separation, kinship carers, foster parents, and yes, children of civil partnerships. Some children know that they were born by IVF and actually have more than two parents. And one child I know, his father married the woman who had first been his mother-in-law, and later she became his stepsister-in-law before becoming his wife. That is something to do with family values in the 21st century. And I think Lord Panick's point about the value of a stable relationship is absolutely key, and that is what the research should be looking at. And the research that has been quoted from Cambridge already demonstrates that there's really strong evidence that children thrive in that sort of same-sex relationship.
Yeah. And building again, my lords, on the wise words of the noble Lady Brinton, that actually there is, and what the noble Lord Panick said, there is really no need to attach this amendment to this bill. The Secretary of State is already bound to provide guidance to teachers under all circumstances, for, it seems to me, that this, and will do so with regard to this bill in the right and appropriate manner. But this is not the way to do it. And if you read the amendment itself, you can see that actually it really is not appropriate that this research is commissioned in this bill.
My Lords, I'm very grateful to the Noble Earl, Lord Listowel, for moving this amendment, and also for taking the time and trouble to come and have a discussion with me a couple of weeks ago, which I enjoyed very much. And I would just like to echo what my noble friend Lady Barker said about his commitment to the interests of children and his dedication to that, and the way in which he makes contributions to all of our work in this House with that specific goal in mind. I think in answering this debate, I just wanted to make some specific points to hopefully assist all noble lords, and particularly the noble Lord Listowel. I think the first thing I want to just re-emphasise is that the bill before us does not change the position for children in families of same-sex couples, the government believes that the principles of long-term commitment and responsibility which underpin marriage are a good basis for providing children with the support and protection they need throughout their childhood. So, as the noble Lord Panick has said, and we very much agree with him, extending marriage to same-sex couples will mean that children of those couples will be able to benefit from the stability of a family founded on marriage in the way that other children are able to do, and we think this is a good thing. The noble Lord Listowel and others referred to comments that the noble Lord Winston made on Monday during our earlier debates about the concerns, or rather concerns about the ability of same-sex parents to bring up children effectively are not supported by the available evidence. The noble Lord Winston made the point there was no evidence to support the concern that some people might have, and that research studies have shown that there is no negative impact on children's self-esteem, psychological well-being or social adjustment if they are brought up by same-sex parents. And this includes lesbian couples, because the noble Lord Listowel raised the point about there being no father figure in the family. And I think what a point I'd just like to make is that when mean, it's a bit of an obvious point to make, but I think it's important nonetheless, is that when gay couples decide to have a child or children, the decision, very obviously, is a conscious one. It has to be. And so therefore, I think it's very safe for us to assume that having made that very conscious decision, they will be very conscious about the needs of that child and ensuring that by taking care of that child, they address all of those child's needs. And no doubt, as parents, they will ensure that if we were talking about, say, two lesbian women, that there are male role models to play a part in the children's lives. And I mean, I know this was something that we discussed when he and I met privately, but I do think I think it's, as I said in the last debate, I mean, I'm aware that, as I say, some people respond to change in different ways, but I do think it's important to be clear that same-sex couples, in their decision to become parents, will approach that either as seriously as any other couple will do, or perhaps more so because of the fact they have had to make that decision very consciously. And there is research to support this, and it's been referred to, the Gollenbach report, Growing Up in a Lesbian Family. There is other reports, all of whom seem to have very interesting names, and I'm sure if I start trying to say them, I'll mispronounce them, so I won't. But there's other studies coming out of the US. The Noble Earl referred to a report by Lauren Marks in the USA, and quoted quite extensively from that. I mean, I think that I should point out that the American Psychological Association took great interest in that particular paper, and they issued a statement about it, saying that on the basis of a remarkably consistent body of research on lesbian and gay parents and their children, the American Psychological Association and other health professional and scientific organisations have concluded that there is no scientific evidence that parenting effectiveness is related to parental sexual orientation, that is, lesbian and gay parents are as likely as heterosexual parents to provide supportive and healthy environments for their children. Yeah. And I do understand that the Noble Earl's request to me about providing some analysis of the research that is out there. I hope the Noble Earl will forgive me if what I do instead is, I'm happy to send him a letter following on from this debate, but I don't think that actually this debate sort of justifies the use of resources really to carry out the kind of analysis that he has called for. But I will write to the Noble Lord. I will ensure that that letter is in the library, and I will copy it as well to my noble friend Lord Elton. And I will obviously be interested to receive the letter that my noble friend said he will send to me about some other issue related to this debate. But I hope the Noble Earl feels able to withdraw his amendment.
My Lords, I'm grateful to the Minister and to those who have spoken in this debate. I'm mindful of the hour, so I'll be very brief in my response. I would still suggest that it is very early days in this phenomenon. Noble Baroness Lady Barker referred to the difficulties at the current time, just the small numbers of families in this particular position. But I am very grateful to the care with which the Minister made her response, and I look forward to receiving her letter. And I beg leave to withdraw the amendment. Thank you.
Is it your Lordship's pleasure that Amendment 95A be withdrawn? Amendment is by leave withdrawn. Amendment 96, Lord Singer-Wimbledon.
My Lords, I rise to speak to Amendment 96, which appears on the order paper in my name. My Lords, the need for a referendum is important for two reasons. Firstly, as we all know, no attempt whatsoever was made to consult the electorate before the last election, or through green or white papers, on the proposed redefinition of marriage, which millions see as an essential building block of society. Respect for the electorate demands their explicit consent for this major social change. Secondly, many of us hope that the wider implications of this legislation would be discussed and genuine concerns listened to in the progress of the bill in the other place and in your Lordship's house. Sadly, this has not happened. My Lords, what is concerning about the support for this bill is the narrow crusading zeal with which genuine concerns are either ignored or brushed aside. Many of us, concerned with making ours a fairer society for all, welcomed civil partnerships legislation, which gave both legal rights and dignity to the gay community in our wonderfully diverse society. The legislation recognized both dignity of difference and equality of respect. The Sikh gurus from whom I take my cue taught the importance of recognizing and respecting difference and the right to differ. But they also taught that all of us, men and women, are equal members of one human family. I vainly hope that some of this sort of thinking would become evident in this debate. Sadly, those pushing the bill, perhaps because of a collective guilty conscience over past persecution of homosexuals, looked to only the supposed wishes of the gay community, with no thought for the rights of others. My Lords, 3 tactics have been used as spoiling measures to stifle genuine debate. Firstly, past persecution of gays has been used to demand unreasonable reparation from the wider community by appropriating, distorting, and diluting the very accepted meaning of marriage, without consideration of the consequences for family relationships and the care and nurture of children. Secondly, we've seen a deliberate misuse of language to suggest sameness and equality, and I mean equality of opportunity and equality of respect. Sameness and equality are one and the same thing, and that to recognize and respect genuine difference amounts to prejudice and notions of superiority. The absurdity of this argument is self-evident. Cricket and football are different sports, but this doesn't mean or imply that one is superior to the other. Yet in seeking to blur difference in gay and heterosexual relationships in Monday's debate, the learned Lord Leicester put forward this same spurious argument. I quote from Hansard: "The attempt to define same-sex marriage differently from opposite-sex marriage while claiming they are somehow equal would inevitably be seen by the man in the street and me, a not very ordinary man in the street, I suppose, as attempting to give traditional marriage a superior status. How? My Lords, I believe the man in the street is far more discerning and would resent being wrongly patronized in this way. Statistics, too, as we have heard this evening, have been used to confuse debate. A small survey has been quoted again, the Cambridge survey, which is said to have found that some children do better with gay parents. Perhaps, but why ignore a much larger and more extensive survey of 3,000 people conducted by the University of Texas over a number of years on a random population, which included interviews with children, with the children who had grown to become adults. It showed children who flourish best, measured in categories such as education, employment status, depression, crime, welfare dependency, and drug misuse, are those who spend their entire childhood with their biological mother and father. all other family arrangements did significantly less well. The worst outcomes were in children brought up by their mother in a lesbian relationship. Are we doing our children any favours if we simply refuse to look at such studies? My Lords, following concerns I voiced at committee stage, I was pleasantly surprised to receive a letter from the Government Office. At the bottom of a politely phrased letter was a note that the copy of the letter would be placed in the library. I welcomed this as genuine discussion and wrote a response and sought to place my response in the library. I was told that only the government can do that. So it wasn't genuine debate, but another attempt to promote a narrow government view. My Lords, in summary, the electorate as a whole have been treated with contempt, not only because of an absence of consultation prior to the last election, but also a continuing reluctance to consult on the merits of the issue after the government took office. Worse, the very meaning of the word consult has been redefined to limit it to discussion on an already agreed course of action. The expressed concerns of religious communities have also been almost totally ignored. One of the supposed safeguarding locks is in fact an open opt-out door, an open invitation to opt out of clearly defined religious practice in a way that can only promote division and dissent. My Lords, it's beyond doubt that the implications of this major social change have not been properly considered, either in this House or in the country. The government should withdraw the bill for proper consultation with the electorate and affected bodies. If not, it should have the courage to allow the electorate to have a say on the merits of the legislation in a referendum on the lines suggested in this amendment. The man or woman in the street should be allowed to give their views on a measure that affects all of society. I beg to move.
Amendment proposed, insert the following new clause printed on the marshalled list on page 8.
My Lords, I haven't spoken before this evening, mainly because I've wanted to listen very much to what other people had to say. But I must say that as far as this amendment is concerned, I really do feel rather annoyed about it. Why on this particular bill? We have sat through legislation from this government on an enormous range of issues in the last year or so. Issues to deal with welfare, on employment law, on foreign policy interventions and so on. Has there been any pressure for a referendum on these issues? No, there has not. But on this question, where for long last we are producing legislation that is going to try and put right the discrimination against gays and lesbian people, the discrimination from which they have suffered for many, many years, we've got the opportunity now to put this right in this bill, and we are aiming to do that, and we are doing that. We have voted in favour of this bill in this House and in the other place with an overwhelming majority. So we now have a situation where the law is absolutely clear, and the law says marriage of same-sex couples is lawful. Is lawful, I repeat that. And yet this amendment suggests that we have a referendum to be held on the 24th of October 213. And on the ballot paper there is a statement which says, at present the law in England and Wales defines marriage as the union of a man and woman, and should it be changed, etc., etc., etc. Well, by the time we reach October, the law will be quite clearly not the same as indicated in this particular clause. It will have been changed because we will have voted to change it to the statement that the marriage of same-sex couples is lawful. And I've listened with amazement to hear the noble lord introducing the amendment, suggesting that somehow or other that this was not popular. In my view, this legislation is very popular, particularly with younger people. Perhaps much older people have some doubts about it. But generally speaking, younger people are all in favour of it. I was very pleased to see when we had the debate at second reading, when I got down and looked at my computer, I had messages from all sorts of people saying, well done, about the speech that I had made at second reading, from younger people. We do not need a referendum. We should throw this amendment out. It is really not a worthy amendment at all. Why on this bill? It's entirely discriminatory, and I urge your lordships to oppose it.
The noble lord, with respect, says, who introduced this amendment, says that the arguments were not considered in the Commons, in the other place. Actually, I think what he means is that they were considered. It's just that he doesn't agree with the conclusion that the Commons came to, and he doesn't agree with the conclusion that this House came to. Well, that tends to happen in a democracy. I mean, we make our decisions on the basis of the arguments. And I don't actually think that one can argue for a referendum upon the basis that one disagrees. I mean, there's not a great deal of difference, frankly, between what we're debating now and what we debated at the committee stage. I leave aside the wording of the question which is going to be put, which seems to me to say that this present law is an excellent law, or are you one of that band of eccentrics who thinks this excellent law should be changed? I'm not sure the Electoral Reform Society would totally agree with that being the question on the referendum. But my objection is much broader than that. I'm not opposed to referenda on constitutional issues. I think that my government back in 1970-72 made a mistake. We should have actually had a referendum when we went into the common market. I'm glad that Mr Cameron is promising a referendum as far after his negotiation and before it comes to the Commons after the next election. What I cannot support is having a referendum after a bill has gone through both Houses of Parliament, through the very extensive discussions that we've had in both houses. It's been approved by massive majorities. I mean, there's no question about that. It's not on the margin. These have been massive majorities that have been assured for this bill. And I think that is particularly the case when it comes to members of Parliament, because it is the members of Parliament who, at the next election, have to answer to their constituents. That is what democracy is about. That's what parliamentary democracy is about. And I don't frankly think, I think that you can actually go to a situation where legislation in Parliament goes through the Commons, goes through the Lords, and then we have a referendum on it. I think it makes complete nonsense of the role of Parliament and the role of parliamentary democracy. And it's one of those things that is my underlying concern about some of the opposition to this legislation, that we're really kind of going against the very fundamental beliefs in parliamentary democracy, but also in the role of this House itself. This House at this stage shouldn't be in a position where, frankly, we should be considering an amendment of this kind. Its only purpose can be to try to wreck the bill, a last chance to actually ditch it. And I don't think we should have, frankly, my lords, any part of it. So, with respect to the noble lord, I've listened to him before, I listened to him again, but I am totally unconvinced in his argument.
My noble friend Lord Fowler is making rather a meal of it. I can think of only one justification for having a referendum, and that is to allow the Prime Minister to get off the hook on which he has impaled himself by bringing forward this bill in the first place. Everybody knows that the bill came forward to Parliament in a most disreputable fashion. There was no well, we've gone over this many times, and I'll just say it in a sentence or two. The Prime Minister himself, 3 days before the election, said that he had no plans to bring forward such a bill. There was no reference in any party manifesto to there being a bill. There was nothing in the coalition agreement about having a bill. There was no proper consultation, and the result is that UKIP has had a field day, going, yes, all right.
My noble friend accuses me of making a meal of it. The way he's going, he is making a massive feast of the whole thing. Surely every argument he has just deduced has been debated and debated again at second reading in the Commons and at second reading in the Lords.
Yes, the trouble is that my noble friend hasn't listened to the end of my argument, because my argument is that as a result of the Prime Minister's behaviour, UKIP has been gleaning Tory votes throughout the country, and at the next general election, if we don't do anything about it, will no doubt be making hay as a result. I would really suggest to my noble friend that the only real justification for having a referendum is to help the Prime Minister by having a referendum so that the whole issue is removed from the public arena well before the next general election.
My Lords, listening to the little exchange that's taken place in the last few minutes between two distinguished noble friends who are members of the Conservative Party just led me to thinking whether an alliance between UKIP and the Tory Party, which of course has been mooted, might be regarded as a same-sex marriage. But leaving aside that little bit of private grief in the Conservative Party, I have to say that I agree with every word that's been uttered by my noble friend Lord Fowler, and will not repeat it because I could not say it as well as he. Like many people in this country, I have a great admiration for Lord Singh. We hear him on the public radio from time to time, and he utters very wise words, mostly. But I say to the noble Lord that regrettably on this occasion, he has actually let us and himself down. And I would invite him to reflect upon whether this proposed amendment really is a proper use of the debating procedure of your Lordship's House. What he said sounded to me awfully like a second reading speech. In order to ascertain whether that would be a justified comment, I spent some little time looking at the noble Lord's biography and bibliography to see what other issues he has suggested would be suitable for a referendum because they have an ethical or moral component. There are none. This is special pleading, and I urge your Lordships to reject this amendment on that simple basis.
Yes. Can I remind your Lordships that your Lordships Constitution Committee, of which I was then a member, recently produced a report on referendums, and what we said was that there are significant drawbacks to the use of referendums, essentially for the reasons that the noble Lord Fowler gave, and our advice to the House was that they should be confined to fundamental constitutional issues. This is not a fundamental constitutional issue, and helping out the Prime Minister, I say to Lord Waddington, if he needs help to get off any hook, is not a fundamental constitutional issue.
My Lords, I too don't want to help the Prime Minister, but let me say I am most grateful for the Prime Minister's help, and he has shown huge personal courage in bringing forward this bill, and for which many of us would want to pay tribute to him. Can I say to the noble Lord Singh, December 2012, Maury poll, 73% agreed gay people should allow gay marriage. 5th of February, House of Commons second reading, 400 to 175 on a free vote. Yes. 21st of May, House of Commons, third reading, 366, free vote to 161. 4th of June, House of Lords, second reading, 390 to 148 on a free vote. 8th of July, report day 1, votes, 314 for on Amendment 1 to 119, 278 to 103, 163 to 32, 84 to 50. The noble lord seeks to suggest this is undemocratic, unconstitutional, and in doing so, I fear he treads a very dangerous ground and risks insulting the integrity of both houses of this Parliament.
Not, my lord, insulting the people who have never had a chance to speak on this and whose views are rather uncertain. If the noble Lord Alley, who has set out this litany of votes, and I cannot gainsay that in any way, but I could certainly gainsay with him on the polls which have been taken, that if he is so confident about the view of public opinion, he could clearly have no diffidence, no hesitation in going forward in agreeing to this referendum. And indeed, it's something which was discussed last Friday in the other place, when the Foreign Secretary was really quite lyrical about referenda. If I can remind him of some of the things, if I can find the thing, some of the things he was saying, the Foreign Secretary was saying at that time. He said, for example, that, and this is column 1191, that is why every member of this House who is a true Democrat can and should unite behind this bill. This is the referendum bill on the EU. It is about letting the people decide. Ultimately, it will be up to the voters to decide, and that is the essence of democracy. Certainly, there is no constitutional objection on the part of the government to referenda. They've held referenda on issues, I concede, mostly constitutional, though there have been examples in our history of referenda on issues which are manifestly not constitutional. My first referendum, which I was aware of, was in relation to the opening of public houses in Wales, and even those with the want to stretch their imagination can hardly suggest that the opening of public houses in Wales was a referendum issue. No, I follow the noble Lord Singh. I adopt what he has said. Indeed, he issues an amendment which I broadly put forward myself at committee stage. The only difference has been that, having listened to the objections at that stage, the objection, for example, that it was just a delaying device and therefore 2015 was too late, the noble Lord has brought it forward to 2013. But I'm not convinced of that the wording is as should be. The wording should, I believe, as was said in the committee stage, probably be left to the Electoral Commission, which is the normal pattern, though I think the noble Lord Fowler did a great disservice to the amendment which has been put forward by distorting it in the way he did, as if the current position is perfect. Some zealots wish to alter it. Do you agree with the zealots or not? This is a fairly reasonable, I think it's a reasonable wording. The only reason I object to it is that I think it should come from the Electoral Commission and not be on the face of the bill. Now, the basic argument, my lords, for having a referendum is the fact that the government has no mandate for this, certainly no mandate for the people. The commitment was not in the 2010 Conservative, Liberal or Labour manifestos. The subsidiary argument, of course, is the speed of passage through this bill, that not only was it not mentioned in the manifestos, not only did a number of the relevant pressure groups not come to this view in respect of gay marriage until a year or two ago, but there's been an unholy haste in this bill which is difficult to understand. It is rather as if there's been a mass conversion over the last year or two, equivalent to that of, say, an African tribal leader who mass converts so many of the members of his tribe. I understand, of course, that noble lords have suggested there have been occasions in the past when legislative changes have been made without a mandate. That, of course, is true, but none, in my judgment, as fundamental as is in the bill before us today. Although laws defining marriage have changed incrementally over the years, and the noble Lord Alison Morgan gave the whole series of those, nothing in my judgment as fundamental as this, changing the basic definition of marriage.
I suppose that a case could be made for an exception to the electoral mandate principle if it is apparent by other means that there is a consensus in public opinion. I concede that there has been majorities in both houses, but there is no clear consensus in public opinion. It depends very much on the question which has been asked. Opinion polls have been fairly evenly divided, and some opinion polls have suggested a majority against, some in favour. And indeed, if further proof for the absence of consensus were needed, however, let me quote from the government's own analysis of its consultation process. They said, and I quote, "Overall, views were divided. Of the 228,000 responses to the consultation, 53% agreed that same-sex couples should be able to have a civil marriage ceremony, and 46% disagreed. However, these figures do not take into account of those petitions we received which were universally opposed. Moreover, the need for referendum set out in my committee speech was compounded by other failures of due process. I shall not repeat that which I said at the committee stage in relation to the failures of due process during the passage of the bill. And I've made the point that, of course, the government is not against referenda in principle. One argument advanced in our earlier debate was that it would not be appropriate to have a referendum when the bill was passed with such a clear majority in another place. That, however, as the noble Lord Singh has properly pointed out, misses the point. No one questions the majorities, the facts are there. But if the referendum is proposed in order to make good the lack of any mandate, the votes of MPs on this issue are not relevant because there was no electoral mandate at the time for an issue which is manifestly a fundamental one. Other noble lords who objected to the idea of having a referendum simply because they considered the redefinition promoted by this bill to be a self-evidently good thing, and recoiled at the idea that it should be subject to a vote. If it was, of course, such a manifestly good thing, why have so many colleagues come to this realization so speedily and at such a late stage? Had this vote been taken 3 years ago, it would not have had those majorities, 2 years, even perhaps 1 year ago. So it is not such a manifestly good thing. Another argument advanced, certainly by the Minister, and advanced earlier in this evening's debate, was that referendums should be preserved for constitutional questions. Well, quite apart from the fact that Parliament is completely free to apply referendums whenever it sees fit, the key point is that the marriage bill does actually raise important constitutional questions, and I refer to the implications for the establishment of the Church of England, as explained by the Right Reverend Prelate, the Bishop of Chester, in his important second reading speech. Moreover, Aidan O'Neill QC, in his legal opinion on the bill, suggests that it risks partial disestablishment. Again, I would cite that this bill the government have made as a constitutional question by disregarding due process and by conducting a consultation, which in my judgment was a bogus constitution because they ignored many of the questions, the majority, which was in fact against. So I come to my conclusion, my lords, it is increasingly common to hear politicians express their profound concerns about the disconnect between political institutions and the public and their passionate commitment to reaching out to and listening to the people. Well, this is an opportunity to do so. Certainly my judgment is there is profound discontent, and not just among the older generations on this issue. And it is certainly the fact that those bills which have been pushed through in haste, and I still wait to hear from the noble lady, the Minister, as to why there is such an unprecedented haste in pushing through this bill. There must be some good reason, some reason behind the reason, which I would like to hear, that we should not, in my judgment, seek to kid ourselves that we can proceed on this basis and expect other than unhappy consequences. Rather than being a law that was developed in a proper way and rests upon a constitutionally appropriate foundation, everyone knows that it was pushed through without proper regard for constitutional convention. Certainly, there was no mandate. Certainly, there has been substantial haste, as yet unexplained. So, to date, the government has not provided any compelling reason for not supporting a referendum. If they believe that the tide of history, certainly over the past year or the past 2 years, from their Damascene conversion, if the tide of history is on their side, and they have no constitutional objection to it, and I cite the two referendums in general, and I cite again the rather lyrical references to referendums in the speech of the Right Honourable Foreign Secretary last Friday, they should have no hesitation in providing for a referendum so the people can decide on this issue.
My Lords, I've always looked forward to the wisdom of the Noble Lord and the Noble Lord Waddington, and it's nice to see them disagree with one another and disagree so well. But what I do feel is this, is that it is an amendment. It doesn't need to be the case. It's often the case, rather, that a minister has got to the dispatch box and said, well, this amendment is not suitable, but perhaps we can get something else. And I rise to my feet to say that I think there should be some consultation with the people. Now, if everyone argues that it's a democratic process and therefore that should be good enough for the people, remember the problems that this generation and generations before us had, because in Northern Ireland we had a government that kept saying it's the majority that rules and forget about the minority, or forget about consulting with the people. We are the ones that will push through the legislation, and that will be the end of it. And I just point to several matters. The Noble Lord Fowler will recall that the first people in the British Isles to get the poll tax was the Scottish people. And that was because of a democratic decision in the other place. And MPs like myself at that time said, you're creating a rod for your own back. And it didn't. It wasn't until the poll tax came into the rest of the United Kingdom then people readily acknowledged that we were wrong. So the argument that it goes through both houses and that's the end of it, and the people will have to accept it, it's nonsense. We can be creating very serious problems. And bear this in mind, my Lords, it is normally the case that the opposition questions the government. In this piece of legislation, the opposition, if that's what they want to do, is not questioning the government. They're supporting the government in this legislation. And that's where I feel that there should be some consultation. Noble Lords will recall that the last time that the Labour Party and the Conservative Party got together, it was when there was a Labour government, and that the Conservative Party supported the Labour Party to go into Iraq and seek to remove Saddam Hussein. The Liberals said at that time, there is a feeling out there in the country that this is wrong. And ever since then, we have been questioning ourselves as to whether it was the right thing to do or not. And the reason I'm on my feet is that it doesn't need to be a referendum, but please find some way of consulting with the people about the difficulties that we've got here, because we're not passing a complete piece of marriage legislation. The government have been shrewd enough to exclude the Church of England and been shrewd enough to exclude the Catholic Church and say, we're not forcing you to do this. So therefore, we're not getting a marriage piece of legislation in the normal sense of the word. And all I say at this stage is, let's fit, of course, the dates that are down here in the amendment, but amendments can be changed. They can be replaced by something that's more suitable to the government and then ultimately to the House. But let's find a way of consulting the people about what we're putting through both houses.
My Lords, I rise very briefly, to thank my noble friend for alluding to the research that he did and for his support in my previous amendment. I will look with great interest at the research that he refers to, and he does also give me the opportunity to reflect on what the noble Baroness the Minister said in reply with regard to research in this area. And I perhaps should have pointed out that the Lauren Marks research was initially a criticism of a conclusion produced by the American Psychological Association 2 or 3 years previously. So she was writing this particular paper as a critical point of view on their conclusion that they felt that all the research so far pointed to no problems with same-sex parenting. So that was the reason she wrote that paper. So it's hardly surprising, therefore, that the American Psychological Association should come back again, if you like, and be very critical of her research. She was criticizing them. So I wouldn't take the American Psychological Association's damning criticism too much to heart on this. I do think she's definitely well worth reading and listening to. The second point I'd like to briefly make is, if I may offer my sincerest congratulations or sincerest good wishes to my noble friend for bringing forward this amendment at this point, this late point in the bill, because I do think that as a man of faith, as a man representing one of the great religions, it's absolutely right that we should be hearing a very conservative point of view. You know, when regarding the family, it's very important that there are these strong conservative voices, deeply steeped in religion, who can stand up against us modern people who are much less rooted in tradition, more flexible. And it's very important that people, if I may say so, such as him, who stand up on these occasions and put a strongly conservative point of view, even at this late point in the bill. And I wish that he'd been here when we were discussing the human fertilization and embryology bill, and to have heard his comments then with regard to removal of the assumption that it's in the best interest of the child for fathers to be involved in their lives. And I recall the Good Childhood Inquiry again, produced by the Children's Society and the Church of England a few years ago, which highlighted that with the relaxation, with the increased rights of adults in the 20th century, with the greater freedom of choice of adults, which many of us so welcome, the downside has been for children so very often that with parents being able to have greater choice, that's meant particularly many more children growing up without their father in the family anymore. So I think it's very helpful, if I may say so, to have my noble friend's voice here. And just finally, very briefly once more, I omitted to thank the noble Baroness Barker for her very, very kind comments. I'd forgotten that she made a maiden speech in my first debate, and I did appreciate what she said.
Deal with this perhaps in bullet form. The point that's just been made about parenting is totally irrelevant to what this bill seeks to achieve, and it's certainly irrelevant in terms of the amendment before us, to which the noble Lord Singh really didn't speak. And when he does, I think we'd be interested to hear under section 9 of those who'd vote in the referendum why you'd exclude members of your lordship's house. In terms of, we keep hearing about public opinion as if somehow it's divided. No, it's not. Every single poll that's been heard that's put the question in a neutral way has produced a very clear result. What's remarkable about opinion is not that it's divided, but how consistent it's been, as Lewis Baston has written in the latest issue of Total Politics. A typical result for a neutrally worded question is support somewhere in the low to mid 50% range and opposition in the mid 30% range. Before concluding, while there may be some legislative twists and turns in the House of Lords, the battle for public opinion has been won by supporters of SSM. So in a way, there's that consistency. There's really no need to consult. The position there is quite clear. In terms of holding a referendum anyway, as the noble Lord Pannick has pointed out, the Constitution Committee at the end of the last Parliament produced a very thorough report on referendums, weighing the arguments for and against, and concluded that if they were going to be held, they should not, it's not just on constitutional issues, but we said on fundamental constitutional issues. This is not only not really a constitutional issue, it certainly doesn't qualify as a fundamental constitutional matter. It is essentially a matter of social policy, but then Parliament's legislated on significant social policy before. This would be on a par with abortion and divorce, issues which, as I recall, were not manifesto commitments and not issues on which anybody was really putting forward that there should be referendums. So if we're going to start going that path and saying we should have referendums on social issues, there are wider implications for that. We'd need to consider it very thoroughly before we went down this particular route. I think there's absolutely no merit in the amendment that's before us, and I hope we do not pursue it.
My Lords, you have to kind of hand it to the opposition from the people who don't like this bill. They really don't like this bill, and they are fighting it right to the very end, and that's what this is about. And that's perfectly within their right to do that, and I particularly enjoyed the heartfelt plea of the noble Lord Waddington in this debate. However, I'm not going to repeat all the arguments that have been made. All I will say is that I would refer you to the noble Lord Fowler, Lord Pannick, behind me Lord Alley, my noble friends who've spoken in this debate, and the noble Lord Norton. They are absolutely right. And what I would say to the noble Lord Martin is, actually the votes were free votes. This was not a question of the government and the Labour opposition. They were free votes. There were members on all sides.
I'd just like to ask the noble Baroness, were the votes on Monday, the Labour Party votes, were they all free votes? There was an understanding that some of them were whipped.
The noble lady knows very well what the answer to that question is. All the votes that were taken up about the principle of this bill were free votes in both houses. It's absolutely right. We in the Labour Party made it completely clear that we would whip on two issues only, which were two issues of public policy, to do with teachers and registrars, and that's exactly what we did. We've been completely clear, open and honest about what we were going to do. So the fundamental issue here is that, and particularly in the Commons, the Democratic House, as the noble Lord Fowler said, all those MPs have to go and face their constituents about this issue. Of course they do. And they'll have to face them every week about this issue. So they would not have voted on a free vote for this bill had they not felt it was the right thing to do. And that's exactly what they should do. And frankly, the idea that the people in the noble lords in this House are somehow pushovers or sheep to be led through the division lobbies is completely absurd, as this debate shows. So we think, and if I might repeat what I said, I think, on committee, is that I think this amendment is a nonsense and the House needs to reject it.
Yeah. My Lords, Amendments 96 and 134, as we've heard, seek to provide in the bill for a referendum on marriage of same-sex couples to be held on or after the 24th of October 2013, and I do recognise that the date has been brought forward somewhat from the amendment which we discussed on committee, although otherwise it is very nearly identical to the amendment tabled by the noble Lord Anderson of Swansea in committee and supported by the noble Lord, my noble friend Lord Cormac and the noble Lord Singh. I think it will come as no surprise to the House that the government is unable to accept these amendments. We do not believe it is a sensible course of action, nor indeed is it required. But I've listened carefully to what the noble Lord Singh said in moving his amendment, and I do recognise the strength of feeling with which he feels on this particular issue. And although he knows he and I don't agree on the principle of the bill, nevertheless, I do profoundly respect not only his view, but the depth of feeling with which he holds it. But there's one or two points, my Lords, I would wish to take up on that matter. Perhaps one sort of practical matter to start with. The noble Lord, as it well suggested, almost I think that it was a conspiracy that the government were able to put my noble friend Baroness Stoll's letter into the library but somehow or another his couldn't. I think that is just the way that the House operates. But what I can say is that the government can place documents in the House library, and if the noble lord would like me to, I am happy to place a copy of his reply to my noble friend Baroness Stowe in the library, and certainly would be pleased to do so if he feels that would be helpful to the debate.
Say it was a conspiracy. It's my ignorance about the proceedings, the way the House operates. I was very happy. Here's a way of debating something, and then I found the block. You can't do that.
I know the noble lord didn't say it was a conspiracy, but I think he used the phrase that it was blocking off debate, and it almost suggested if it was being done deliberately. It was not. It's just, as he indicated just now, it's the rules of the place. But if he does wish his copy, his reply to be put in, we'll certainly arrange for the government to put his reply. And I think he's nodding assent to that particular proposition. But, my lord, in the letter which my noble friend Baroness Stowe sent to the noble lord, and it relates to issues about consultation, and she noted, for example, that the British Sikh Consultative Forum issued a formal submission to the consultation on equal marriage, that government officials met with representatives from the Sikh Council of the UK as recently as the 4th of April this year, that it held pre-consultation meetings with the Sikh Forum in December 2011, and held another meeting during the consultation period with the interfaith community in May 2012, which involved representatives from the Sikh faith. And I think it's also...
Have to intervene again. It is the meaning of consultation when it is a course previously decided on that you talk about. That, in my view, is not consultation. The other point is I have spoken to all those groups mentioned. They were totally opposed to the legislation, but that's not reflected.
I mean, there are always going to be situations where there are disagreements. But I think it's nevertheless, it has been the case that efforts were made to engage not just with the Sikh community, but with other communities. And that's why this bill has as a fundamental part of it the fact that religious organisations, whom the government readily recognises, indeed the official opposition readily recognises too, that there are religious organisations and faith communities which do not believe in same-sex marriage. And that's why an important part of the architecture of this bill is to give the protection to these faiths, and I think that's an important part that's come out of the discussions and the process that has brought us to where we are today with regard to this bill. But I think it was also suggested that the government somehow have been impervious to argument. It's just worth reminding the House that as part of the whole process, that the government listened to what the Church in Wales said and produced an opt-in procedure, that there's been additional protection for chaplains employed as members of staff, that we've added ecclesiastical law to the measures not affected by the bill, that we've clarified that same-sex couples are void when the couple are aware that the religion has not opted in, that we've ensured that the consent of a governing authority to opt in to same-sex marriage does not automatically fall if the governing authority changes. That significantly at report stage on Monday, and I think the noble lady Baroness alone commented and commended the government for it, we introduced an amendment which gave clarity or extended meaning to the word compelled, and again that we changed we brought forward an amendment to change the Public Order Act to clarify that criticism of same-sex marriage is not a hate crime. On other issues, for example, in humanist weddings, the government has been prepared to listen. Amendments made earlier today at report on fast-track procedure for gender recognition, and indeed amendments too, a very technical amendment, but an important one, with regard to reflect the absence of a legislative consent motion from Northern Ireland for overseas marriages in consulates or armed forces bases. My Lords, this government has, in a number of these issues, listened and has made appropriate amendments to the bill. But, my Lords, I think it's also been said that the use of referendums in the United Kingdom remains very much the exception in our constitution. And the noble Lord, Lord Panic, and my noble friend Lord Norton of Louth, and indeed I myself were members of your Lordship's House's Constitution Committee when we looked at the issue of referendum. And I don't think I'm betraying any secrets, I think it comes through in the report. We thought it really should be the exception, but the genie was out of the bottle, and therefore, if it was going to be used, the wording used in that was that the report clearly states that should be matters of substantial constitutional significance. And it gave some examples. The abolition of the monarchy, leaving the European Union, indeed what was the debate in the House of Commons last Friday, for any of the nations of the United Kingdom to secede from the United Kingdom, to change the electoral system for the House of Commons, to change the United Kingdom's system of currency. And, my Lords, whilst I recognise that what we've been debating in your Lordship's House on this bill as a matter of profound social policy, I don't think by any stretch of the imagination they could be described as a matter of substantial constitutional significance. And we acknowledge what we're doing is a significant change to marriage law. I recognise that many are uneasy about the proposals, but again I say it is not a significant constitutional matter. Now, I feel slightly difficult. I don't want to intrude on Conservative Party discussions between my two very distinguished noble friends with a distinguished cabinet career, my noble friend Lord Fowler and my noble friend Lord Waddington, but the Conservative Party did indicate that in their contract for equalities published alongside their election manifesto that they would consider the case for same-sex marriage. And my Lords, again the point made by my noble friend Lord Fowler, that this matter has of course been debated in the elected chamber, and quite what, apart from being passed by a substantial majority in this chamber, it was significantly passed by a very substantial majority in a free vote in the elected chamber. And I listened to the noble Lord Martin, who of course is a very distinguished speaker of the other House, and he reminded us of the poll tax in Scotland. Now, the noble Lord and I live in Scotland, and I tried very carefully and sensitively with Conservative friends here. The Conservative Party didn't exactly reap electoral dividends for what it did in the poll tax in Scotland. I think the Conservative Party would be the first to accept that their electoral performance since the poll tax has not exactly been an example of how you can ignore what the people say and get away with it.
Late, but I make the point that he and I both, at the same time, would have said to Conservative ministers, please consult with the people. And they would have found that the people would have clearly said, no way do we want this. And they wouldn't have got into the difficulties they got when it got to the rest of the United Kingdom.
Is that under our constitutional and democratic architecture, members of Parliament make their judgments, make their votes, and they then answer to the electorate. And I think that is the appropriate way in which we go about these matters. And I just say too, because it was mentioned that about the Prime Minister, I certainly think anyone who's heard the Prime Minister talk on this issue knows he talks from real conviction. And I think it's a great credit to the Prime Minister that he has had the courage to give leadership on this issue, and that this bill gets to where it is today. My Lords, I think support has also been reflected in recent opinion polls. My noble friend Lord Norton of Louth has referred to that. Just remind your Lordship's House, I think there's a House of Commons Library research paper on this. But summary of polls on same-sex marriages offering a two-way choice. October 2011, Comres, 51% support. 7th of March 2012 in ICM, admittedly, not a majority, but 45% support. May 2012, YouGov in the Sunday Times, 51%. December 2012, YouGov, 55%. December 2012, Survation, 60%. December 2012, ICM, 62%. February 2013, the Sunday Times YouGov, 55%. 5th of February 2013, YouGov The Sun, 54%. 19th of May 2013, YouGov, 55%. But the point I would make, my Lords, is that numbers isn't everything. What this bill is about putting right a wrong, because we believe of the importance of the institution of marriage. What we wish to do is to ensure that gay and lesbian couples can be part of it in the same way as opposite-sex couples are. We want to get on with it, and therefore I ask the House to reject this amendment.
My Lords, I thank the noble Lord Wallace for the graciousness of his response. I also like to thank those who have spoken in favour of this motion, Lord Anderson, the noble Lord Waddington, Lord Martin, and of course the noble Earl of Listowel, who put the position perfectly, although I was a little concerned about being called a conservative. I also would like to thank the noble Lord Fowler. In many ways, he didn't respond to any of the specific concerns raised, but in many ways, the manner of his response exemplified the concerns that I had raised earlier. My thanks again. It is late, I sense the mood of the House, and I beg leave to withdraw the amendment.
Is it your Lordship's pleasure this amendment be withdrawn? The amendment is by leave withdrawn. Amendments 97 to 105, Lord Mackay of Clashfern, not moved. Amendment 106, Baroness Stoll of Beeston, moved formally. The question is that Amendment 106 be agreed to. As many as with that opinion will say content. The contrary not content. The contents have it. Amendment 107, Lord Deer. Not moved. Amendment 107A, Baroness Alone. Not moved. Amendments 108 to 110, Baroness Stoll, moved formally. The question is that Amendments 108, 109, 110 be agreed to. As many as of that opinion will say content. The contrary not content. The contents have it. Amendment 111, Baroness Stoll. The question is that Amendment 111 be agreed to. As many as of that opinion will say content. The contrary not content. The contents have it. Amendments 103 to 118, Baroness Stoll. Oh, sorry, 113 to 118. Move formally. The question is that Amendments 113 to 118 be agreed to en bloc. As many as of that opinion will say content. The contrary not content. The contents have it. Amendments 109, 120, 121, 122, 123 withdrawn. Amendment 123A, Baroness Stoll of Beeston.
My Lords, I beg to move Amendment 123A, which replaces Government Amendment 123, which, as I explained to the House on Monday, the Government was considering withdrawing and has just done so. Perhaps I could give a little background. The Delegated Powers and Regulatory Reform Committee reported on this bill in its 4th report to the session. We are most grateful to the committee for its comments and recommendations, to which we responded in a series of amendments that the House debated on Monday. One of the recommendations of the committee was that regulations made under Clause 9, which deals with the conversion of civil partnerships, should be made by the Secretary of State rather than the Registrar General, and be subject to the affirmative procedure on first use, because it was not clear that all such provisions would be purely administrative in nature. We were happy to accede to this recommendation, but were also conscious that in the future the Registrar General may need to update her administrative procedures. To require regulations to be made by the Secretary of State regarding such matters would be overly bureaucratic and break with the convention that the Registrar General makes regulations relating to her functions that are purely administrative. For example, the Registrar General already makes regulations without any parliamentary procedure prescribing the detail of marriage and civil partnership registration, the duties of those responsible for registration and the forms to be used. We therefore propose, through Amendment 123, which has now been withdrawn, that the Secretary of State or the Lord Chancellor could make enabling provision for the Registrar General to make regulations relating to administrative matters. We continue to believe that such sub-delegation is the appropriate way of dealing with these administrative details. However, as the chairman of the committee, my noble friend Lady Thomas of Winchester, very helpfully highlighted to us before Monday's debate, the previous amendment had been drafted in a way that would allow the Secretary of State or the Lord Chancellor to sub-delegate in respect of any of their order or regulation-making powers in the bill. While it was never the government's intention to use the proposed power in such a far-reaching way, and the use of the power was limited in any event only to where it was in connection with administrative matters relating to the functions of the Registrar General, Superintendent Registrars or Registrars, we accept that it would not have been appropriate to move the amendment with such concerns outstanding. So that's why we've tabled Amendment 123A, which is more restrictive on its face as to the circumstances in which the Secretary of State may sub-delegate regulation-making powers to the Registrar General. Its effect is that there are just 2 provisions where the Secretary of State can now exercise such a power. The amendment states explicitly that subdelegation may occur only where the Secretary of State considers it necessary in connection with the Registrar General's, the Superintendent Registrars and the Registrar's administrative functions under Clause 9 concerning conversion of civil partnerships to marriages, and Amendment 90 concerning marriage by belief organisations, if the government in future decides to allow such marriage. We consider that the subdelegation of regulation-making powers to the Registrar General is necessary and appropriate in these two contexts, but it must be subject to clear restrictions. In particular, there is no power for the Secretary of State to subdelegate provision as to fees. Amendment 123A also makes clear that the default position is that any delegated regulations made by the Registrar General would attract the negative procedure unless varied by the Secretary of State in the event that she felt this was justified because of the nature of the particular regulations. I can assure noble lords that any regulations of the Secretary of State sub-delegating powers to the Registrar General will be put before Parliament for scrutiny. My Lords, the Chairman of the Committee has written today to confirm that the Committee is content with the revised amendment, and I'm very pleased about that. I hope you will agree that this amendment is a measured and appropriate response to the Committee's concerns, which delivers our policy intention whilst ensuring that there can be no inappropriate use of the powers. It's extremely nice to end the report stage on what I hope is a constructive and consensual basis, and I note that many people left the chamber as I started, and I commend Amendment 123A to the House.
Opposed. Page 14, line 19. At end, insert the words printed on the second marshalled list.
Can I thank the noble lady for that very clear exposition of these very sensible amendments, and I'm very pleased to say that we, of course, will be supporting them.
The question is, that Amendment 123A be agreed to. As many as are of that opinion will say content. Content. Contrary, not content. The contents have it. Amendment 125, Baroness Stoll, move formally. The question is, that Amendment 125 be agreed to. As many as are of that opinion will say content. Content. Contrary, not content. The contents have it. Amendments 126 and 127 move formally. The question is that Amendments 126 and 127 be agreed to. As many as are of that opinion will say content. Content. Contrary, not content. The contents have it. Amendments 128, 129, 130, 131, 132 and 133. Baroness Stoll, move formally. The question is that these amendments be agreed to en bloc. As many as are of that opinion will say content. Content. Contrary, not content. The contents have it. Amendment 134, not moved. Question 135, Amendment 135, Baroness Stoll, move formally.
Formally.
Question is that Amendment 135 be agreed to. As many as are of that opinion will say content. Content. Contrary, not content. The contents have it. Amendment 136, not moved.
No idea. That's it. Just adjourn to the House. I beg to move that the House do now adjourn.
That the House do now adjourn.
House of Lords sound.